Good morning and welcome, everyone. It is now 10 a.m. and I would like to formally open specific issue hearing 8 for the examination of Vannin Offshore Wind Farm project. Just to cover off a few housekeeping matters, can everybody in the room hear me right at the back? Thank you. And live stream and recording, have they started? Okay. Can everyone present please set all devices and phones to silent? Okay. Toilets are to the right through the double doors, and there's no planned fire drills today during this event. So please, if you hear an alarm, please leave the building by the nearest fire exit and collect in the car park. Onto panel introductions. My name is Ms. Sahai. I have been appointed under Section 27 of Marine Infrastructure Management Act 2016, or MEMA, to chair the panel of examiners for this application. I can confirm that I've made a conflict of interest declaration as part of my appointment, and for the avoidance of doubt, confirm that I've not had any professional or contractual engagement with Ørsted, which is the applicant, Department of Infrastructure, or any other department or agency in the territory of the Isle of Man. For context, I've been an examining inspector and chaired examining bodies such as these in relation to nationally significant infrastructure projects promoted across the UK from 2016 to 2024, where I have discharged my duties to examine those projects with openness, fairness, and impartiality. In the conduct of a thorough and fair examination for this application, all interested parties are free to raise the merits or disbenefits of the application. As we are still in examination, we have not made any determination on the merits and disbenefits. After the close of the examination, we will take all submissions and evidence into account for the purpose of our recommendation to the Council of Ministers, and it is the Council of Ministers who will make the final decision. I'm a chartered member of the Royal Town Planning Institute, which means I am bound by their Code of Professional Conduct, which sets out ethical standards for all members of the Institute to meet, including the requirement to operate with honesty and integrity and to exercise independent professional judgment. This underpins my commitment to conduct all the proceedings in a manner that is independent and procedurally fair to all. I will now hand over to my fellow panel members to introduce themselves.
Good morning, everybody. My name is Frances Fernandez, and I am a panel member appointed pursuant to Section 27 of MEMA. I confirm that I have made a conflict of interest declaration as part of my appointment, and for the avoidance of doubt, I also confirm that I have not had any professional or contractual engagement with Ørsted, the Department of Infrastructure, or any other department or agency in the territory of the Isle of Man. For context, I have been an examining inspector in relation to nationally significant infrastructure projects promoted across the UK. I am a fellow of the Royal Town Planning Institute, and this means I am bound by the Code of Professional Conduct, which sets out ethical standards for all members of the Institute. I operate professionally within the same professional and ethical framework that Ms. Sahai has just set out.
Good morning. I'm Ms. Pownell. I'm a panel member appointed pursuant to Section 27 of MEMA. I confirm that I've made a conflict of interest declaration as part of my appointment, and for the avoidance of doubt, confirm I do not currently, and since my appointment, have not had any professional involvement with Ørsted or the DOI or any other Isle of Man department, agency or business. For context, over the last 35 years, I've been integrally involved in consenting, application and construction of major infrastructure projects across the UK and overseas. Since I'm also a member of the Chartered Town Planning Institute, which means I am bound by a code of professional conduct in the same manner as it does the other panel members and frames my conduct for this examination.
Good morning, everybody. My name is Ryn Smith, and I too am a panel member appointed pursuant to Section 27 of MEMA. I confirm that I too have made a conflict of interest declaration as part of my appointment, and for the avoidance of doubt, confirm that I have not had any professional involvement with Ørsted, the Department of Infrastructure, or any other Isle of Man department, agency or business. And for context, I have been an examining inspector in relation to nationally significant infrastructure projects promoted across the United Kingdom. I served as the head of profession for planning inspectors in England and Wales from 2008 to 2012, and then onwards until 2025 as an examining inspector. I served as the equivalent to an examining inspector for infrastructure in the state of Victoria in Australia from 1999 to 2005. I'm a chartered member of the Royal Town Planning Institute, which means that I'm bound by the Code of Professional Conduct in the same manner as it applies to the other panel members, and it too frames my conduct in this examination.
Thank you. Together we constitute the examining body for this application. For all examination-related matters, we will be addressed formally either as Ms. Pownell, Ms. Fernandez, Mr. Smith, Ms. Sahai, or Ma'am and Sir. Case team introductions. Also present are members of Cabinet Office Case Team, Mr. Tom Randall, who provides procedural support throughout the examination process, supported by a team. The audiovisual service is provided by Energy Media Limited. A few words for the procedure of today's meeting. The agenda for Specific Issue Hearing 8, or SIH 8, was issued on Friday the 3rd of July 2026 and was subsequently updated on Friday the 10th of July 2026. Just a few words about the format of this hearing and the use of personal information and the general conduct of proceedings before we get into the substantive part of the agenda. Today's meeting is being undertaken in a hybrid way, meaning some of you are present with us at the venue and some of you are joining virtually using Microsoft Teams. Some of you have chosen to watch the live stream. Additionally, a recording of today's meeting will be made available on the MEMA website as soon as practicable after the meeting has finished. With this in mind, please ensure that you speak clearly into a microphone, stating the name of the organisation you represent, if that is relevant. If you're not sat at a table with a microphone, please wait until a roving microphone is brought to you. Just a few words about the use of personal information. When speaking, do think carefully about your personal information. If you feel a need to refer to something of a personal or confidential nature, please remember that anything you do say will be included in the published recording. The Cabinet Office is administering the consenting process for applications made under MEMA, and in that regard, it will process personal data in accordance with the Data Protection Act 2018 and GDPR and LED Implementing Regulations 2018. Further information relating to data protection can be found in Cabinet Office Privacy Notice. Please speak to Mr. Randall if you have any questions. A few words about the statutory framework of the hearing. Under Section 31 of MEMA and Regulation 31 and 34 of the Marine Infrastructure Consenting Process Regulations 2024, the examining body can hold specific issue hearings if we think it is necessary to examine an issue that requires us to hear from multiple parties, and so that principal stakeholders have an adequate opportunity to state their case. Examination under MEMA is an inquisitorial process, and it is for the examining body to lead the questioning in order to test the evidence before us. For the purposes of this hearing, I will not allow cross-questioning between parties. If parties consider that further points need to be explored, they should indicate this to the examining body, and we will decide whether those matters should be pursued here at the hearing or whether we will explore them through the written process. Today's hearing is Specific Issue Hearing 8 on Seascape, Landscape and Visual Impact and Groudle Bay. And the examining body notified parties of its intention to hold Specific Issue Hearing 8 in its Regulation 31 letter issued on the 26th of July. For avoidance of doubt, we are referring to the agenda, the updated agenda that was issued on the 10th of July 2026. If you don't have access to that, please speak to Mr. Randall, who will provide you with a copy of the updated agenda. Okay, let's turn to introduction from attendees. turning to the applicant first. If the applicant can identify the lead person and then introduce members of your front bench who are likely to be speaking in sessions 1 and 2, we will then take introductions from other members of the party as we go.
Something. My name is Amy Sterling. My name is Amy Sterling.
The purpose of this exercise is to enable them to calibrate the microphone settings. So if you just keep talking until you're told to stop, that would be very helpful.
Okay, noted. Good morning, Madam Chair. My name is Amy Sterling. I'm a partner and solicitor at Pinsent Masons, and I will be representing the applicant today. I will introduce the members of the applicant team who will be speaking prior to lunchtime, we expect, in terms of how the agenda is currently structured. I'm joined on my left by Dr. Gillian Carolan, who is the consent lead at Ørsted on behalf of the applicant. I'm also joined by Ms. Linda Thompson, who's our SLVIA consultant from Open, and also I'm just at the end of the table by Mr. Ryan McManus, who's a principal consultant at Gobi Consultants. Thank you.
Thank you, Ms. Sterling. Turning to attendees on my right, if I could have introductions from DEFRA and followed by introductions from Department of Infrastructure.
Ken Milne, representing DEFRA. I'm joined in person with Abiel Morgan and online by Oliver Brown.
Did you say online by Oliver Brown, Mr. Milne?
That's correct,
yeah,
yes.
Okay. Do you want to just check sound and video, Mr. Brown? Oliver
Good
Brown.
morning. Yes, hopefully you can hear me okay. Oliver Brown, landscape architect, representing DEFRA.
Yeah, thank you very much. Video and sound
Thank
is
you.
clear. Okay, Department of Infrastructure.
Good morning, Robert Garden. I'm partner and solicitor at CMS, representing the Department of Infrastructure. I'm joined on my right by Ian Brooks, who's the Legislation and Policy Manager, and also by Emma Rowan, who's the Senior Infrastructure Policy Officer. We may be joined online as well by Richard Webster, who is the Senior Highway Development Engineer within the Highways Division.
Okay. Mr. Webster, if you could just test sound and video.
Present, Richard Webster, BOI Highways.
Video is not ideal, Mr. Webster. If there's any way you can set your camera angle to show your face, that would be helpful.
It's a little bit better.
It's slightly better. Yes, much better. Hold it there. Yeah, let's stick to that camera angle. Okay.
Mr. Garden, please can you repeat the name of your team, because I don't seem to have them on the list that I've got here. Thank you. And I'm not sure how well the audio is picking up for those online.
Okay, thank you, ma'am. So on my right, you have Ian Brooks and Emma Rowan, and then online you have Richard Webster. Thank you.
Is there anybody here from GARF Commissioners who is intending to speak at the meeting? If you could just wait for the roving microphone to be...
Just let me interject there. There is no roving mic available at the moment, so please come forward in turn.
Okay, what I'm going to do, actually, just to make this easier, is I'm going to do this as a roll call. If you just raise your hand... God. bear with me. Richard Taylor from Gulf Commissioners, thank you. And Miranda Farragut, thank you. And it's just the two of you. Yeah, thank you very much. And then, do we have Dr. Beard? Thank you very much.
Can I say yes for the audio?
Yes, yes, Dr. Beard, yes. We'll do that later. We've got that. Okay, on to members of the public. I've got Anne Barks. Are you intending to speak? No? Okay. I then have Martin Cubban. Okay. And intending to speak, Mr. Cubban?
Yes, I will.
Okay, thank you. I do see other members of the public here. If anybody else is intending to speak, please raise your hand.
Shall I go through my list?
Yeah.
So have we got Jennifer Smith here? No. Richard Taylor? Sorry, I missed that one. I'm just trying to catch up with the audio. And if I'm repeating names, be patient. Peter Taylor? No. Donna Bailey? Thank you. David Owens? No. Jamie? Oh, we've done them. Ali McKinsey? No. Michelle Cook? Thank you. Ian or Ali Strafford? Both, thank you. Vicky Dunn. And no offshore wind turbines. Any representative? And have we? Can we hear your name, please, for the audio? Gina O'Sullivan. Ah, yeah, thank you. Yep. Yep, I've got that. Thank you very much. And Patricia Newton? Yep. Okay, thank you. Who have we missed? Yeah, if you'd be so kind as to introduce yourselves.
Yes, please.
Can you hear me? I just noticed that on the specific hearing 8, my representation on noise has been allocated to this hearing. Given that noise is not identified as a principal agenda item, I'd just be grateful if the examining body could explain why it's been allocated to this session, and I'm here to answer questions if necessary.
Thank you for highlighting that. The agenda is as it was published on Friday, the 10th of July. If something has not made it into the agenda, it is probably because it's going to be pursued through written means. But if, given you're here, if you have any questions, we'll call on you. Thank you very much. Is there anybody? Madam, did you want to come forward?
I don't know if you need my name just to attend. I have registered. It's Margaret Brown. They couldn't find me at the door, but they were really busy, so they said they would find me, but I'm not down, so just for your records.
Thank you, Ms. Brown. That's noted. Thank you. Yes. It seems there's, I can see another hand at the back. Would you like to come forward, please?
It's already on, is it? Yeah. Okay. My name's Judy Cannon, and I've come here because I am a very upset person and want to gain more.
Madam, we're not taking representations at the moment. Have you registered, and are you intending to speak?
I have registered, but not to speak.
Okay, that's fine. Noted. We've got your name. Thank you. I think that covers the introductions.
Good morning. I'd just like to introduce myself. My name is Diane Brown, and I'm here representing Cabinet Office Planning Policy Team.
Oh, thank you. Thank you, Ms. Brown. We've got you down in the list as well. Thank you very much. Okay. All right. I think that covers the introductions for today. We will move swiftly on to agenda item 3. And just a really quick overview of session 1. In agenda item 3, we'll look at changes to the proposed development that the applicant has put forward through the draft MIC that came in at deadline 6. And I will, for the purpose of this discussion, I'm going to call that Scheme 1, Proposed Amendments. In agenda item 4, we will look at the wider, more extensive changes that are currently in the without prejudice alternative indicative layout. And for this session, I'm going to call that Scheme 2, Indicative Layout. There is a pre-agenda item, which I do want to just take a few moments to just cover off. So just put those exercises to one side for a minute, and just let's revisit first the hearing actions and written questions that led to what the applicant has referred to as the thought experiment. So through the hearing actions arising from SIH 5 and subsequently through our second written questions, we essentially asked you to explain the evolution of the scheme from the agreement for lease through the design refinement process to the point at which the application was submitted, including the first change request. Now, you, along with the applicant, along with Department of Infrastructure, submitted documents to explain that process, and I'm summarizing my understanding of the evidence as follows. So the agreement for lease identified an option area within which you could seek consent. Within the agreement of lease itself, while the agreement of lease itself did not contain or secure a development scheme, the scoping opinion was, however, for an early development scenario for the purpose of commencing EIA and consultation, and that early scenario was approximately 100 wind turbines, approximately 180-meter turbine height, and 700 to 800 megawatts generating capacity. You've then gone on to explain that you have applied the developable area approach or a design refinement process, balancing environmental effects, technical feasibility, and commercial aspirations, actually generating output for the project. The process involved identifying likely significant effects, overlaying spatial constraints, including SLVIA, shipping and navigation, ornithology, commercial fisheries, so that the effects could be designed out or reduced in an early stage. I'm not at this stage indicating whether the examining body accepts those conclusions. I'm simply confirming that I've understood the case that you've advanced, and basically what I understand, therefore, the case that you submit is that the application boundary is already the product of multiple iterations of avoidance. What still remains clear is why the boundary of the application as submitted was selected as the correct endpoint of that exercise. Now, just a very quick advanced view of where I'm getting to with this is that the evidence that's come in at deadline 4, deadline 5, and deadline 6 means that a further reduced layout was in fact possible. So put that to one side for 1 second, but given that we're getting to that part of the narrative, right at the outset, what I'd like to understand is why the boundary of the application as submitted was considered the correct endpoint of that design iteration exercise.
Amy Sterling, on behalf of the applicant, I think there's a couple of clarifications that would be useful to make in relation to the statements you've made, Madam. First of all, important to note there were 2 scoping exercises. I'm not entirely clear which one you were referring to. There was a scoping exercise carried out in around 2015, which was the early stage design of the proposed development, well, not the proposed development, as a project, as it was then considered. There was then a new scoping exercise which ultimately informed this MIC application, and those were both fundamentally different proposals given the evolution in turbine technology between 2015 and 2024, I think it was, when the scoping report was submitted. So I think it's important that everyone bears in mind those distinctions. Much of this is covered in your agenda item. What I would say is, whilst I think it's also important to note the action points that the applicant took from the last set of hearings. One of the action points, specific issue hearing action 5, action point 8, asked the applicant to explain whether any SLVIA mitigations could be put forward that would reduce SLVIA adverse effects and the commercial and generation implications of those. That was the action which drove the thought experiment and ultimately the submissions at deadline 5 and deadline 6. As part of that ongoing testing of its design envelope, which is currently within the MIC application, the applicant has also identified some additional design refinements that it could make to what you term Scheme 1. I would suggest they're all part of the same scheme, but just with different levels of design flexibility, and therefore included those within the draft MIC at deadline 6. The applicant wishes to be very clear, however, that the thought experiment / indicative alternative layout, which is a representation of the scheme comprising the thought experiment, isn't an alternative which meets the same need as the proposed development. There is some reduction in impact for SLVIA.
Ms. Sterling, can I just interrupt you there? I think you've just jumped forward a little bit, because what I'm trying to understand is why you stopped at the point you did, which was the point at which the application was submitted.
Amy Sterling on behalf of the applicant. I understand the question, madam. I'm getting there, if you could just allow me a moment. However, so they do not meet the same project need. There is an approximately 21% reduction in generating capacity and reduced economic benefit. So the applicant has identified the proposed development as where it considers the economic and technical viability of the scheme and the planning need that it can achieve is more appropriately balanced as against the adverse impacts. Of course, ultimately where the planning balance lies is a matter for the Council of Ministers to determine. Hence, we've put forward the thought experiment and indicative alternative layout in case the Council of Ministers take a different view from the applicant as to where the planning balance is appropriately struck.
Okay, that's understood. That's clear. Okay, I'm just going to put a marker down at this point. There are a couple of questions about that process which came up at public meeting 3. I don't want to lose the flow of this conversation, so I'm not going to get into that now. But just so you know that we will be seeking responses to this either through hearing actions or possibly written questions. One was about financial information that has been made available for other offshore wind farms, which you are resistant to provide. And second is you've referred to bidders in your submission at several points, and this is the submission you've submitted with DOI. And we'd just like to understand what that process of competition was. This was again a point that was raised at public meeting 3. I'm not necessarily looking for responses here because I'm desperately keen to maintain the flow of this conversation. But let's return to this if we have time.
Amy Sterling on behalf of the applicant, if I may, madam. I would suggest that if the examining body considers it relevant to the determination of this MIC application as to why the Crown Estate made public the option fees for round 4, then that's a matter you should ask the Crown Estate what was their thinking in making the option fees available for round 4. I'm not aware they actually are publicly available for round 3 or for round 5. I would have to check. It's not really a matter the applicant can comment on why the Crown Estate in a different jurisdiction has decided to take the action that it has. These are generally private commercial agreements. In relation to the nature and the identity of the other bidders, we would have to defer to the Department of Infrastructure on that. Again, that was a process run by the Department of Infrastructure, not the applicant. Thank you.
Understood. Okay. Brilliant. So now this brings us neatly to agenda item 3A. And what I would now like to understand is how the narrative you've just described, and you've kind of touched on this, but let's just carry that process forward. The narrative that you've described continued beyond the point at which the application was submitted. And basically, how has that led you to the amendments that you are now proposing to incorporate into the draft MIC? So you may also wish, if this is relevant, for completeness, place these amendments in the wider context of the design evolution that's already occurred during examination. So that's the removal of Port Skillion. So if it is a part of the same evolutionary process, then do place it in that context. But basically, from deadline 5 cover letter and the subsequent amendments to the draft MIC, my understanding is that you're now proposing to reduce the maximum blade tip height from 350 to 330 meters, reducing the maximum number of offshore turbines from offshore platforms from 3 to 2, increase the maximum turbine spacing from 820 meters to 1,000 meters, and basically remove pile jacket foundation as a foundation option. What I would like you to do is to just explain how that process of design refinement led you to these particular amendments. So you've just explained that the application that's gone in your words, it meets the project need, it strikes a more appropriate balance between the adverse effects and the project need. So what is that refinement process that's led to these amendments? And then once you've explained that, talk us through each amendment in turn and what it does, what its purpose is. But before I hand over to you, there is one further change, 5th proposed amendment that is lurking, and that is in your deadline 6 cover letter, which refers to a further engineering refinement, reducing the Groudle beach and field landform from 2 cable circuits to 1. And that proposed amendment is currently not reflected in the draft MIC. So just explain to me if that refinement forms a part of this same design evolution process, if it's a part of this package of 4, now 5 amendments that's going to come through at deadline 7, and then get into the reason for it and the purpose for all of this. In 3B, we'll get into environmental effects. So there's no need to get into too much detail about the environmental effects just yet.
Amy Sterling on behalf of the applicant. Yes, taking the first package of amendments together, so the ones which were made at deadline 6, some but not all of them arose from the applicant's work in responding to the action points relating to the thought experiment, where the applicant identified a reduction in design flexibility which could go some way to mitigate some likely significant effects which were residual within the application. So the applicant considered that these refinements could provide some benefit for various environmental topics, which we can go on to, but nevertheless they clearly fell within the maximum design scenario and the assessment in the environmental impact statement. In all cases, there are reductions to the design envelope as applied for at application, and the applicant therefore made those amendments in the MIC at deadline 6 to reduce the design flexibility which was already inherent in the application. And I think that is a key point for everyone to be aware of and mindful of at the very outset of this discussion. Everything the applicant has put forward, if it were never discussed, if the MIC had been granted as applied for, could have been built anyway. There is no obligation to build the maximum design scenario which is consented within the MIC. In fact, the MEMA regulations are explicit that the opposite is the case, that there is no obligation to build the maximum design scenario. Nevertheless, the applicant considers it helpful, now that it knows that it doesn't need such design flexibility in relation to the parameters identified, to make those amendments within the draft MIC so that's clear for all parties at approximately just over halfway through examination, and allow parties an opportunity to comment if they so wish. The difference between these amendments and the landfall at Port Skillion, I think one is there is not any requirement, for example, to change the works plans for these amendments. The spatial extent of infrastructure remains the same. I would suggest that Port Skillion was also, there are examples, as we discussed, I don't want to go over all ground, we discussed previously, of the Port Skillion an equivalent change to Port Skillion not going through the change process in the DCO. Different applicants and different examining bodies take different approaches because it was always inherent within the maximum design scenario. Nevertheless, the applicant for Port Skillion considered a non-material change was appropriate because it would allow all parties to become aware of the reduction in receptors who were affected by the scheme. there's no equivalent sort of reduction in receptors associated with these design refinements which are put forward. You know, we're not removing whole categories of receptors as with port scallions. So that's where we consider the distinction lies. The reduction in 2 cables to 1 cable at landfall is arrived somewhat separately and later, hence why it wasn't included at deadline 5, signposted at deadline 5 and included at deadline 6. And that relates to ongoing discussions that the applicant has been having with DEFA in relation to the configuration at Girdle Bay, which I'm sure we got onto in detail this afternoon.
Sorry, just clarification, ongoing discussions the applicant is having with?
The applicant was having with DEFA in terms of the Girdle Bay configurations, which we'll get onto this afternoon. If it would assist, ultimately, therefore, the applicant, is very confident that, and the reason it hasn't put forward a change request, that everything it has put in its MIC, which I can run through now, is clearly within the maximum design scenario. It's a refinement in the flexibility that the applicant would otherwise have been able to build if the MIC had been granted.
That's helpful. Just in terms of the purpose of doing all of these, the changes that you've asked for, just in terms of a project design perspective, can you just talk us through that?
Amy Sterling on behalf of the applicant. Yes, I do then need to go into the specific changes, if that's okay, to explain the purpose, because it changes slightly depending. So the first one, I'll go in the order of my list, if that's okay. So the order of my list, the first was offshore platforms. The applicant amended work number 2A and requirement 9 to reflect the fact that the applicant is now seeking consent for a maximum of 2 offshore platforms rather than 3 offshore platforms. That also required an amendment to work number 2B to confirm that there would only need to be up to 1 interlink cable, not 2, because there would only be 2 platforms to be linked, not 3, so a requirement for only up to 1 cable. And that's a consequence of the reduced types of offshore.
Sorry, just so I'm clear. So just so I'm clear, the offshore platforms, reduction in offshore platform is actually linked to the change that you've proposed at deadline 6 cover letter, which is no.
Amy Sterling on behalf of the applicant. No, the interlink cable is the cable that connects the offshore platforms, not the offshore export connection cable, which is the cable to landfall. So if there are only 2 platforms, there can only be up to 1 interlink cable, whereas if there were 3 platforms, there could have been up to 2 interlink cables.
I'm so sorry, Ms. Sterling. Could you just slow down, because I'm trying to catch what you're saying, and the audio is not great from where I'm sitting. So if you would just be a little bit patient and just slow down, that will certainly enable me to keep following what you're saying. Thank you.
Amy Sterling on behalf of the applicant. Yes, I'll endeavour to do so. Would you like me to start again, or am I happy to keep going? Okay,
keep going, yeah.
There was a reduced number of offshore platforms from 3 to 2, reduced number of interlink cables from 2 to 1. That reflects a reduction in the type of offshore platforms. So the applicant is reducing its design flexibility to remove the option for an offshore O&M base or an offshore accommodation platform. The applicant has made this change to mitigate likely significant effects for SLVIA purposes and to reduce the flexibility in its design. That flexibility was initially sought at application for a potential integrated offshore O&M solution with Ørsted's wider portfolio within the Irish Sea.
Okay.
That's no longer being proposed for part of the application, as the applicant is seeking separately, as we've already discussed, an onshore O&M base at Douglas. So there was no need now within the application to have that offshore O&M platform / accommodation base. Therefore, removing that platform would have some SLVIA benefit and therefore reduce the design flexibility. I can group those offshore platform sort of changes together. Moving then to the reduction in the maximum tip height, the applicant has amended requirement 8, which is the detailed design parameters, to confirm that the upper blade tip height of each wind turbine generator is reduced from 350 metres to 330 metres. This refinement has again been made for Seascape landscape visual impact assessment purposes, a reduction in the height of infrastructure on the horizon. Nevertheless, the applicant has considered the supply chain and considers that 330 metre maximum tip height does maintain sufficient technology flexibility to allow the project to benefit from emerging turbine technology whilst also having some benefit in SLVIA terms. So therefore, that design refinement has been incorporated into the MIC application. Turning then to centre spacing, the applicant has made various amendments to the requirements in this regard. Previously, the requirements were drafted so that there was an infrastructure spacing between wind turbine generators only of 820 metres. However, the applicant, in relation to providing greater access to fisheries this time rather than SLVIA, has identified a reduction in the design flexibility that it requires so that it can increase the spacing between all offshore structures, so not just the wind turbine generators, but also the offshore platforms, to ensure that all offshore structures will have at least 1,000 metres centre to centre between them, and that the applicant has incorporated that within a new requirement 9A. Turning then to the next amendment, pile jacket foundations of wind turbine generators. The applicant has amended work number 1A and requirement 86B to remove the option of a pile jacket foundation for any wind turbine generators. And this was to reduce potential for likely significant effects from high frequency noise generated from pin pile installation and impacts and effects on marine mammal species. That would still leave the applicant 3 foundation options for the wind turbine generators. So again, just represents a refinement in the previously 4, now 3 foundation options, which were included within the maximum design scenario. The applicant has then made various consequential amendments given the above refinements. So the volume of scour protection, cable length, volume of cable protection has also reduced to reflect the reduction in infrastructure. And then finally, the applicant has removed the option of having a bridge link, as the bridge link would only have been relevant to the O&M base or the accommodation platform to allow people to use the bridge to traverse from platform to platform.
That's helpful. And the starting point, of course, is also quite good to understand, which is the removal of the O&M base, which you actually needed for Ørsted's to maintain operations and maintenance between other offshore wind farms, Ørsted-owned offshore wind farms in the East Irish Sea, if I've understood that correctly.
Amy Stelling on behalf of the applicant. Apologies, madam. I just want to make clear what I said. I'm sure I did say this, but just to be clear that the applicant has removed pile jacket foundations, or pin pile jacket foundations, not jackets entirely. I don't think I did say that, but I'm just clarifying.
No, that, yeah.
And I apologise, madam, could you please repeat your question?
It's just the starting point. You said the reduction of the offshore platforms down from 3 to 2 is primarily linked to the O&M base or offshore platform not being needed anymore, because you don't need the operations and maintenance base amongst other 4 other Ørsted-owned offshore wind farms in the East Irish Sea.
Amy Stelling on behalf of the applicant. I understand there was to be a potential an integrated O&M solution. I'm not entirely sure what the format of that was intended to be.
Got it.
And where relevant O&M personnel were intended to be at any given one time, but that is no longer proposed.
Fine. Okay, so that's good. Now, and I think what you've said, we completely understand that you've said that all of these things are... Sorry, Ms. Sterling, did you cover off that amendment which was the reduction of the cable circuits from 2 to 1 on Groudle?
Groudle Field.
We said we'll come back to that later.
Amy Sterling, on behalf of the applicant, yes, I flagged that it had arisen due to the work that's ongoing to identify the layout in and around Groundle, which we were going to discuss this afternoon.
Okay, so we've covered that. Okay, great. So now I think it's helpful that we've understood the purpose and why you're doing all of this. So we'll move on to agenda item 3, where I think it'll be helpful for the examining body to understand the environmental effects of all those amendments. And your position is that these refinements remain within the assessed design envelope. That is understood. But notwithstanding that position, we do want to confirm that there aren't, in fact, consequential implications elsewhere. So a few examples, for instance, is that if you are increasing the minimum turbine spacing, could that potentially increase the overall length of cabling? Will that inevitably have an impact on the array area? Reducing the number of offshore platforms from 3 to 2, and I think I understand this from your explanation, but it'd be helpful to go through it again, would that mean that the project is operated and maintained in a way that requires more concentrated activities, and therefore you end up having, worser effects? And similarly, the reduction of 2 cable links or reduction from 2 to 1 cable links to Groudle Field, does that potentially mean anything to needing a wider cable corridor, or possibly alter the construction period? So these are just examples that have come to the examining body that we've discussed, and we just want you to talk us through some of those environmental effects. Now, you have focused very much on SLVIA. You have focused primarily on SLVIA, but we would like to understand if the environmental effects could be worse for other receiving environments, such as marine ecology, so benthic, ornithology, marine mammals, fish and physical processes, then fisheries, shipping, etc., and landfall works generally. So, and if your position still is that there aren't any worse environmental effects, that's fine, but we just like to understand how you reach that conclusion.
Amy Sterling, on behalf of the applicant, to confirm firstly, yes, that remains our position, that there are no other refinements that would need to be made, certainly no increases in the maximum design scenario being sought, and therefore no greater impact than has already been assessed on a maximum design scenario basis in the EIS, and no intensification of effects. I'll pass to Dr. Carolan in case he's got any specific examples that he can walk through now. Thanks.
Dr. Carroll on behalf of the applicant. In relation to cable length it'll be reduced pro rata in relation to the number of turbines. So we initially had 87 turbines. That'll be reduced with the alternative scheme down to 72. So there'll be a pro rata.
Dr. Carolan, we are still talking about the scheme where the turbines have not been reduced. So we're talking about scheme 1, which has come through at deadline 6, not the without prejudice indicative scheme. So if it was just those amendments, which are in the draft MIC at the moment that will go through, then there isn't a reduction in turbine length, but there is an increase in their spacing. So does that mean that you will need more cabling and potentially need an increase in the array area?
Dr. Carroll on behalf of the applicant, apologies for that, my confusion. The reduction from 2 to 1 in terms of the OAC, reduction in the number of offshore platforms and a reduction in interlink cables will all result in a reduction in permanent footprint, temporary disturbance, in the generation of spoil, the deposition of spoil, but those won't be equally applied across all parameters, and we need to have a look at that to come back with some detail. There will be no change in operation and maintenance activities. The accommodation platform was just serving as just merely that, accommodation. There was no associated maintenance activities with that. So all maintenance activities for turbines and cables remain the same. There's no change. On the OAC, the island length, the reduction from 2 to 1 cable would result in a reduction to for the permanent and temporary footprint to that, on a reduction then in sediment disturbance and a corresponding reduction in the environmental impact. And in all cases, there would be no intensification because it would be a reduction, and that's been set out in our submissions at deadline 6.
Amy Sterling on behalf of the applicant. So in summary, Madam, I guess the answer is we aren't seeking any increases or changes in the maximum design scenario related to these design refinements. No change to the array area, no change to the length of cables that are sought, no increase in the number of vessels or helicopters we expect during operation and maintenance as a result of the removal of the offshore O&M platform.
Ms. Sterling and Dr. Carolyn, if we needed to be satisfied, or how you've arrived at those conclusions, because I'm still struggling to understand how you can increase the spacing and not increase the array area. I'm still struggling to understand how you can increase the spacing and not increase the cable length. I need to be reassured that if you're going down from one cable circuit from 2 to 1 to Groudle Field, how is that not increasing your cable corridor width? How will you satisfy the examining body of those matters? What can you give us in evidence to satisfy us? And I'm going to just turn to parties here, DEFRA, to seek your views on some of these changes that have been sought. But let's hear from the applicant on these questions.
Dr. Keogh, on behalf of the applicant, I can't think of any situation where a reduction from 2 cables to 1 cable results in an increase to any impact or footprint, as you allude to. I mean, if we have 2 cables, 2 permanent footprints, 2 temporary disturbances, you will remove one. The remaining one cannot, under any scenario, result in a greater impact than the 2. In relation to the turbines and within the indicative layout that's provided, so the 820 spacing that we were at and increasing that to 1,000 will have an effect on the turbine spacing around the perimeter, because we have really a dense border, so the spacing's closer there. Then within the remainder of the array, so if around the border of the site you, for example, have 60 turbines, then the remaining are scattered to maximise or to minimise internal wakes and to maximise revenue internally. So the spacing will increase slightly internally, but it won't really change in terms of cable length. So the cable length that we have in there is indicative, it's a maximum design scenario, and that's capped. So any final layout that is proposed will be within that limit. So it's not that another indicative layout would exceed the maximum design scenario for inter-array cables or interlink cables. So that's capped.
Okay, Dr. Carolyn, thank you. I think there's something that will help us. And basically, if you recall, for the removal of Port Skillion, we'd asked you to tabulate with reasoning, your justification why the environmental effects would not intensify or get worse for all the receiving environments. I think that justification would really help over here. So that's one thing. The second thing is that what will help the examining body and other parties is potentially to see another indicative layout with this increased spacing and the removal of one of the platforms. And I'm just wondering if that is something that you'd be willing to provide.
Dr. Keogh, on behalf of the applicant, yeah, we can easily provide that for you. Yeah.
Okay, so let's work on that. That is definitely a hearing action, but let's work on specifying that a little bit. No, I'm hoping to have that as a hearing. So let's move. Is that possible as a hearing submission?
Dr. Keogh, on behalf of the applicant, the indicative layout, so the increased spacing, you would like to see that as an indicative
but
layout
also
as soon
the
as possible.
tabulated ES
I think the tabulated
effect.
ES bit is going to take a little bit longer because we're all here in examination, so that's going to take a little bit longer, but the indicative layout will be our tactical team, so they can get cracking on with that pretty quickly, so we can follow up with that pretty soon.
Yeah. Can we touch base on this at break and then lunch, after lunch and then after break, and see whether you can, how far you can push that?
Push what? Sorry.
The ES tabulated. And I'll come to that in a second, but, you know, but if we, for now, in the hearing actions, say hearing submission /D7, let's see if we can come to a negotiated position.
Apologies if I missed it. When's the deadline for the hearing submissions? Is it Friday, Monday next week? Okay, thanks.
Latest by Monday. Okay. I know that my colleagues have questions, and I'm desperate to get views from parties. So, should we get views?
So just to track back, in terms of that external perimeter of the indicative layout, just explain again what the proposal, what difference it would make to that external edge.
Dr. Carroll, on behalf of the applicant, the border would be less dense, so we have a dense border. So we bring the turbines as close together as possible in the facing into the prevailing wind direction, so you get like a generation front. So instead of them being 820 apart, they would now be like a kilometre apart. So you wouldn't see it from a visual perspective. You wouldn't really see that. You wouldn't notice that 180 metres difference. But it would be, you know, a decrease in the density of the border, and then a corresponding increase in the internal density of the turbines, because then you would have more turbines in the same space internally. So it would just be a spatial change in the density on the perimeter with a corresponding change internally.
And in terms of lines of orientation, still maintaining one, it would have no effect on anything in that department?
Dr. Keogh, on behalf of the applicant, everything would remain the same as per the indicative layout that has informed the EIA to date. So, yeah, and everything would have to conform with the layout principles on the design and layout, all commitments within the EIA.
Okay. I mean, a follow-up question on that, obviously, in relation to the degree to which amended indicative layout cascades into the assessment in terms of shipping, fishing and navigational risk. I mean, clearly, if we do have the indicative plan that the Chair is minded to request, then that provides us with a basis to explore and ask written questions round 3, the degree to which any principal stakeholder might have a view that that change was in any way significant for their purposes in a way that has possibly not been perceived by yourselves to date. So that's a dimension of the why in terms of us needing that information, and probably there being relatively limited value in pursuing that sort of detail in oral questions at this hearing table, when in fact it's best dealt with by the relevant stakeholder with a plan in front of them and a written question to direct them to the main heads of analysis. There's a similar matter, and that does relate in part to some of the items that appear on this afternoon's agenda broadly in relation to social and economic effects, but I do note that one of the principal effects of your proposed amendment is to remove that general O&M activity on what would have been the third platform, and that in tandem you are thinking about an onshore base in Douglas. And so therefore, in terms of tabulation of effect that is drawn out against all the heads of analysis in the ES, that will need to include an analysis of economic effect and essentially a view on the rebalancing of the social and economic consequences of, one, an O&M workforce based at sea, utilising a platform, as against, secondly, an O&M workforce actually actively based and coming out of Douglas, and what the distinction in the consequences between those two positions might be. Is that something that you're happy to take on board as something that is picked up when the ES
Dr. Carroll, on
analysis
behalf of
is
the
done?
applicant, just in relation to the O&M, So the accommodation and operation and maintenance platform within the array doesn't change the O&M configuration, the O&M, the whole O&M assessment, the whole O&M requirement, the O&M base in Isle of Man, that would still remain the base. So all O&M activities would be undertaken from there, as opposed to commute out and back and out and back. The purpose of the accommodation platform is to minimise the return trips. So whenever there would be a long-term deployment or changing blades or maintaining turbines, they could go out and stay there. The O&M requirement within Douglas and within the project would remain unchanged. It would just mean now they didn't have the facility to stay offshore and they'd have to return back and forth. So the O&M activity remains exactly the same from a socio-economic perspective.
Because if you actually have essentially an increased number of instances of day trips to and fro Douglas, with more essentially service vessel utilisation from Douglas, potentially more overnight stays in Douglas, potentially more workforce spend in Douglas on T&S, travel and subsistence, you can actually start to, in aggregate, see a change. And I'm not suggesting it would necessarily be a negative change.
Dr. Keir, on behalf of the applicant, there would be no change because the scenario that you have set out is the scenario that's been assessed as the maximum design scenario in the EIA to inform the socio-economic assessment. So there is no change. We have assessed exactly that scenario.
So to clarify that point, just before I let it go, that our existing assessment as a maximum has therefore cumulated the effect of the offshore O&M base, but has assumed a rate of transport and service use between Douglas and the wind farm that operates as though that would not have been there in any case.
Dr. Keir, on behalf of the applicant, it doesn't assume between Douglas, it assumes a maximum O&M activity for the infrastructure type and for the corrective and maintenance works that are required. So it doesn't establish whether those activities are within the array area, so from the accommodation platform, or whether they're from Douglas. It just stipulates the total number of vessel trips per year, the total number of each visits to each turbine, to substation and stuff, and it collates them all together and provides an assessment on that basis. We don't specify that there's 25% of them from Douglas, 25% from the platform, 50% from Barrow, for example. It's a total O&M activity that's assessed.
I know. However, there is unless I'm getting things horribly muddled, there is a potential shift, namely that with a flexible O&M capability at sea, staffing and servicing can proceed from a very large number of potential bases, whereas in a world where you have shifted to essentially a greater emphasis on utilisation at Douglas, there is actually potential for greater activity in Douglas, greater spend in Douglas, greater employment in Douglas, that may well be within your maximum design scenario in terms of overall effect, but I'm suggesting to you that there are circumstances in which a greater yield share of that might be in Douglas, as distinct from the circumstances before where possibly it could have been less.
Amy Sterling, on behalf of the applicant, the point is understood, sir. I think we probably need to take it away and consider.
That was my suggestion,
yes, exactly.
That it actually be reanalysed within the framework of
that taking it away. I did just want to test with the examining body, perhaps want to consider over the break, is whether it's Monday or nothing for a hearing submission. Monday's probably quite tight, given we're in here till at least 5:30 on Friday. Would next Friday for the review of the environmental effects document be sufficient rather than waiting to deadline 7? Because I do take the point it could then inform your written questions due at the end of the month.
We'll take that away during the break. Ultimately, if there is a late submission, it is at the discretion of the examining body whether or not we accept it. And so, the fallback option is potentially just that. I do want to turn to parties. I do want to wrap this up in the next 3 or 4 minutes. Not to limit your time to speak at all, but I want to move on to agenda item 4. So sticking very much to the changes that have come through deadline 5 and deadline 6, what are your views and have you been consulted on this? Have you shared your thoughts? So if I can hear from DEFA first and then from Department of Infrastructure.
Ken Milne, representing DEFA. Before I respond, can I maybe just put on record for clarification that everything that's said at the hearings as a DEFA position is based on previous political policies and informed by scientific research and data. They're not based on personal DEFA officer positions other than professional capacity representing the department. Now, turning to this item, DEFA, we note the change. We've had some discussion on it with the applicant. There was a lot of information came in deadline 6, which we've not had a chance to fully review. So I think we need to take a lot of this away and look at it and come back and have a future deadline to actually respond formally on those matters. At high level, reduction in number of landing sites at Groudle would obviously be reduced environmental impact, so things like that we are obviously supportive of. But we'd have to go in to look at the detail before we could formally respond.
Okay. So the first time you saw these changes was at deadline 6 in the draft MIC?
Ken Milne representing DEFA. I believe so. I'd have to check.
Okay.
Thank
All
you.
right. Mr. Garden, on behalf of Department of Infrastructure.
Yeah, Mr. Garden, on behalf of the Department of Infrastructure, I think in terms of the points the applicant has made and the updates that have been made to the draft MIC, I think importantly they are changes that could have come through the approved design and layout plan process pursuant to the draft MIC. And I think that's reflected in the fact that we now have firmer controls. So there is a consequent reduction in the limits in the draft MIC from an enforcement perspective. So the department welcomes that. And I think to your point on cable circuits that you were raising, there is no increase that's been proposed in requirement 11. So that parameter does remain, and there are consequential reductions in the interlink cable. So the department is satisfied with the approach that's been taken in relation to the drafting of the MIC. In relation to the reduction at Groudle, we've not seen that as yet, but we'd expect it to be a similar approach, that it's a reduction in terms of what's secured to what has previously been within the maximum design scenario. I think on the question on consultation, I think it's fair to say, and I can take it away, but I think the first we saw when the documents were submitted as well, so there was no consultation prior to that.
Okay, so I think there's 2-3 things. One is your views on the proposed changes and, the 5. So actually there's more than 5. When we looked at the consequential changes, there are a few more, but what we've discussed today under agenda item 3A, what are your views on that? And actually the point that both Mr. Garden, you picked up, is your opinion as a government department, whether they can be brought forward with changes in the MIC rather than needing any further procedural steps, would actually be quite helpful with justification. So, why you feel that needs to be brought forward. So actually Ms. Sterling gave quite a helpful distinction between Portskillion and this. And I think that would really help the examining body and indeed other parties to help understand that. Okay, questions? Yes?
Should the panel read anything into the fact that DOI and DEFA hadn't seen these changes ahead of them being published at deadline 6?
Amy Sterling on behalf of the applicant. I would suggest not. If you remember, the timescales between deadline 4, 5 and 6 were incredibly tight. There was a week between deadline 4 and deadline 5, then 2 weeks till deadline 6. The applicant was doing a lot of work in that time period to test itself from a commercial and technical perspective as to what would be appropriate to include at deadline 6.
Okay, thank you, Ms. Sterling. Are there any other parties that wish to make a comment on any of this? Would you like to come forward?
Farragut for Golf Commissioners. I can only reiterate that we also were not aware. It is a moving feast, all this, and extremely hard to keep up with. We had a brief discussion, the commissioners that were at Groudle at the meeting yesterday, and you just don't know how to respond. Definitely consultation. I don't know when it's going to be done or how it's going to be done. if you want me to talk on some other matters, but I'll leave it till later on.
Thank you, Ms. Farragher. And in terms of consultation, I think let's just be slightly careful about the use of the term. This isn't. This is the process where we're seeking views from parties on matters that are coming into examination. Of course, if it was a formal change request, then the consultation process is slightly different as stipulated by legislation. So, whenever the applicant provides further information, or indeed based on the information that's already in the examination, please do provide your thoughts on...
We need to respond. I understand that. It's just with lay people involved, we simply do not have the resources to keep up with this huge process. And that's being absolutely honest.
Yeah, that's noted, Ms. Farragher, and you do have our sympathy on that point. Thank you. Are you registered to speak, madam, in the middle row? Would you like to come forward to the microphone? And I'm just going to confirm, while you're making your way over here, it is specifically about agenda item 3 that you want to say something.
I think it is. Did I switch it off or on? Okay, on. So Jennifer Smith for myself. One of the things that has struck me in all this discussion is, again, the technicalities which are inherent in any process like this. But I'm struck by the use of flat plan, flat diagram, quite obscure labeling, certainly for the layperson. It becomes quite difficult to get an idea of proportion and size. So, for instance, in terms of Groudle Bay, how big would that substation be in its landscape? What would that look like? How would that impact the appearance of that bay? And how would it impact the electric rail, the electric trams that go there, et cetera, et cetera? Now, if I were to commission a house to be designed by an architect, I would never just accept the plans in a flat diagram, in a one-dimensional diagram. I would insist on an architecturally drawn image of what my home would now look like. And I think that is something that the public is lacking in terms of gaining an understanding. And it's not just Groudle Bay, it's obviously the proportion of the whole wind farm in proportion to the Isle of Man. And we can look through goggles, which only certain people have access to, etc. But I believe that the applicant should have by now actually have created some three-dimensional image of what this is going to look like, because that is the only way most people will be able to access and assess the impact on our lives.
Okay, so. Thank you, Ms. Smith. And I think the point about making the examination information more accessible to public has been made to the applicant before, and we will urge you to continue doing that as far as you possibly can. So there's some good points that have been raised here. I'm not going to ask the applicant, unless they want to respond specifically to the points you've made about effects on Groudle, because those matters have been covered to quite some extent so far. So, but yes, that point about making information more accessible is well made. Thank you.
Thank you.
Amy Sterling, on behalf of the applicant, if I may, Madam, I think there is one important clarification from what's just being said. There is no substation, proposed at Groudle Bay.
Yeah, thank you. Thank you for that clarification, Ms. Sterling. I see a lot of hands. In the interest of time, I am going to just take the first hand that had come up, which was over here, I believe. Okay, sorry. My apologies, madam. It was Dr. Baird who requested time before.
David Baird, Max Fish, producer of the organisation. I just wanted to comment on the increased distance from 820 to 1,000 metres. It doesn't have any benefit to fishing at all, because if you've got wider spacing on the perimeter, the wind turbines are still connected by cables to each other.
Okay.
So, and our position is at the moment that we cannot fish over cables. So whether it's 100 metres, 1,000 metres or 2,000 metres, it makes no difference because we can't fish over that area. So we can't fish in between the turbines.
I would like to hear a response to that.
Dr. Carroll, on behalf of the applicant, we have a very different opinion on that. We have submitted into examination evidence of similar types of fisheries fishing in close proximity to cables. We've had discussions with Dr. Beard for ongoing now for a few years where he flip-flops between increased spacing being beneficial to fisheries, and then 1 minute it's advantageous, the next minute it's not required. So we've made commitments. We're trying to get a position with Max Fish Producers organisations, and we have a commitment to agree on the final array layout. We've got consultation. We have a fisheries coexistence liaison plan. We're committed to working with Dr. Beard, and it's just we have a difference of opinion in relation to the spacing on the cable arrangements.
Dr. Carolyn, I'd ask you to be careful about the way you characterise the way consultation responses are received.
I understand. Apologies.
Okay, noted. I think the difference in opinion is one way of characterising it, but I think there's that is a valid point that probably does need to be addressed. And so I think we do need to take that point away. But I think for the examining body, Dr. Beard, it would be helpful if you can substantiate some of what you've just said, that in terms of, the distance, the increase in the turbine distance is not going to make a difference. Because ultimately, if there is a point, and we are very fast approaching that point, where if the examination closes with difference in opinion, we will need evidence in order to be able to pick a side, essentially, on matters that remain outstanding. Yeah.
Okay, well, David Beard, Max Fish Producers, I think I've made my position clear at deadline 4 when I put the evidence in as to why we wouldn't, at this point, be prepared to fish over cables. I don't know if I have to repeat all that. It's in evidence. And also,
that reference is enough for me.
Yeah, and also, I haven't flipped and flopped. My opinion has been straight all the way through, and I do object to that.
That is noted, Dr. Beard. We objected as well, and Dr. Carolyn has extended his apologies. So. Okay, so that is one point. Is there anything else that persons, I know that there were several hands, but I am keen to move on to deadline, to agenda item 4. Madam, it was you first and then yourself. And I am going to then bring this agenda item to a close.
Hello, Kiri Jenkins. I'll make my point very quick. The legislation does not appear to allow a material reduction to an application after it had been submitted through the simple change mechanism. Section 28(5) of the Marine Infrastructure Management Act states that the examining body may, at the applicant's request, make changes to an application only if it is satisfied that the changes are not material. It also requires regulations governing how that power is exercised.
Ms. Jenkins, if I could just stop you there. We are very familiar with that legislative provision. So if you could get to the point that you're making.
Well, those regulations in Regulation 36 state that there's a non-material changes to application. It sets out those procedures. If this alternative layout is not the application before the examining body, what legal authority allows either the examining body or the Council of Ministers to recommend or grant consent for it? And my question would be, at what point does a series of individual changes cease to be a non-material amendment and become materially a different development? If removing the offshore platform, removing the accommodation, removing a second interconnector and relocating the array are still collectively said to be non-material, what changes would, in the applicant's view, ever amount to material change requiring a fresh application?
A good question, and we will seek. I will touch upon that briefly, but that matter has been discussed, so I'm not going to seek your response immediately. Madam in the front row.
Michelle Cook, I'm a principal stakeholder. You mentioned that an information request had previously gone in to the applicants for a 3D model, or any kind of visuals really would be great, to be put forward. Or VR, I don't think we really mind, we just want to see something. So in relation to this, may I ask when that request was placed, because it hasn't been fulfilled, it hasn't been met, and we're running out of time now. The examination will close soon. Sorry, did you catch that? It's going to close soon, so we need that request to be met. As it hasn't been met, it seems it's a bit open-ended, given the time constraint that we're now under. So can I request that you request or impose a deadline, agree it, so that we can get that? And can we know what form it will be in? Because one of the problems that's gone on in the past is people just haven't known to participate. There hasn't been the consultation process that there should have done. So now we have groups like Not for IOM who will be able to publicise that, and there will be a channel for getting people involved this time. In the past, the applicant hasn't done that, but the volunteer groups will be able to galvanise to make up for the deficits that, you know, the shortcomings of the professionals that are supposed to be doing this. So that would be great. So can we impose a deadline, please? And can we agree what it's going to be?
That's understood. So just a couple of points of clarification. The accessible information that I referred to was not in relation to visual or model type material. It was to make some of the technical information more accessible. This was issued after public meeting 2, and the applicant's response to that is in deadline 4. As far as visual material is concerned, we have been seeking whatever material we feel is necessary for our understanding of the examination of the application. For instance, we've asked the applicant for a layout. I completely appreciate that this is technical material, but at this point, to enable the examining body to examine this application, we are seeking the information that we are. You're aware that we are looking at some VR modelling later on today. So, as I've said, that the examination is to enable us to examine the application. All of this request that you've put forward is in examination. It is up to the applicant to respond to this. But it is not something that that we can necessarily impose on the applicant if it is not something that we essentially, as evidence, require in this examination.
I understand that. Thank you for the clarity. As part of the examination, you are examining the consultation process and the whether that's been met or not and how it's been met. And I think that it's very difficult to say it's been met if the islanders who have to live with this thing don't know what it looks like. And I just don't understand why it is that in order for you to examine properly, you haven't asked for input from islanders about the visuals, because we haven't seen it. We just don't know what it looks like. If I asked anybody in the room who's confident that they know what this looks like to stand out, I'm pretty sure no one would be on their feet. And
Understood.
I just don't understand how that hasn't been requested as part of the examination process when you know that we don't know what it looks like because we bang on about it all the time.
Thank you. Thank you very much. Now, we are assessing this application against a policy set out in MEMA, and the wireframes that have come through as part of the SLVIA process is what we have before us as evidence, which is what we need as evidence. Your request is noted, and the applicant will take that away and respond to it either by providing something or by not providing something. But as I've said before, that in our assessment against policy, the visuals that we require, we have before us. Madam, I am going to have to draw a line under this. I'm going to just... Okay, now there's a couple of points well, the point raised by the lady in the first row, which I do want to cover off to finish agenda item 3. We will then take a break, but we will return to agenda item 4 in session 2. So we are running behind. So the point that's been made is, and actually it's very close to the question that I have drafted before me, is we just want to understand how the package of 5 amendments remains design refinement, notwithstanding your position that each element falls within the maximum design scenario. Just rehearse for me all the points where you feel that this is not a change request. The other thing that I'm just trying to understand is that in your deadline 5 cover letter, you did ever so slightly leave it open-ended for the examining body to determine whether this needs to be a change request or whether this is something that can be covered off through amendments to the draft MIC. So I'm just trying to understand, what is the procedural route you are proposing? What is the justification for that? And what is the question you're placing before the examining body?
Amy Sterling, on behalf of the applicant. With respect, Madam, I don't think we can do it without reference to the fact that they all remain within the maximum design scenario. That is entirely fundamental to the point as to why these are not considered to be a change.
Ms. Sterling, can I just interrupt you there briefly, that the removal of Portscillion also remained within the maximum design scenario. So what helped me previously was that comparison, so you might want to use that as a reference point.
Amy Sterling, on behalf of the applicant. Yes, so as I mentioned earlier, the changes to the maximum design scenario that the applicant has put forward at deadline 6, signposted at deadline 5, and set out why, in its view, these were not changes to the application because they were not increasing any of the parameters inherent within the application already before the examining body and subject to consultation and ongoing examination, was because ultimately they are a version of the scheme which could be built if the MIC application was granted as applied for. They are reductions in the flexibility within the design. Now, whilst that is the same for Portscillion, I think it was debatable at the time whether Portscillion needed to be subject to a non-material change request. The applicant took the view that because there were corresponding changes to plans, it removed certain receptors and certain likely significant effects. It would be prudent to put them forward as a formal non-material change request so that those items could essentially be removed from examination, and it was clear to all parties that their particular area at Portscillion was no longer being affected by the application. Again, I think it's debatable whether or not a non-material change application in that circumstance was required, but the applicant went through that process. What the applicant signposted at deadline 5 is the changes that it was proposing to make, in its view that these did not represent a non-material change for the reasons I've just explained, but ultimately recognising that it's the examining body who control the examination process. And we've had that if the examining body disagreed with us on that, then of course you could invite us to put forward those changes via an official non-material change process, and then there would be a consultation requirement for a period of 10 working days, and those could then flow into the rest of the examination. We do not consider it necessary. Ultimately, the examination process is, of course, the examining bodies to run. Thank you.
Okay, so there's just a few technical questions. One is, and because you've referenced changes to plans and other certified documents, what are the examination documents that will need changing, whether or not this is a change request or comes forward as a change request or amendments through the draft MIC? What further amendments will need to come into examination is one question. And secondly, if the examining body did determine that this does, because cumulatively, there are 5 changes, cumulatively, they do need to come forward as a change request, how do you see that playing out during this examination, the remainder of the examination timetable?
Amy Sterling, on behalf of the applicant, can I just be clear that we're talking about the changes to the maximum design scenario for the scheme as applied for and not the thought experiment.
That's right.
Because those changes have already been made to the MIC with the exception of the 2 cables to 1 cable at Girdle. So that would be one additional change which the applicant flagged in its deadline 6 cover letter. If you just bear with me 1 second. Amy Sterling, on behalf of the applicant, have confirmed that there are no further amendments required to management plans or otherwise to reflect the maximum design refinements that we've put forward at deadline 6 or the 2 cables to 1 design refinement that we're proposing.
I mean, wouldn't you need to change the works plans to reflect at least the change from 2 cable circuits to 1?
Amy Sterling, on behalf of the applicant, no, because you could still place 1 cable anywhere within that works description, so it's within that works area. So the works description changed, the area doesn't change.
Is that something that a DOI and DEFA can take away as well, and just confirm that point that you're satisfied that these changes are? Well, you're looking at the assessment of the ES and whether, you know, to what extent that that might need to reflect these changes, but equally if there are any documents that you feel that need changing. So this is definitely a hearing action, but if the examining body can just consider how we sequence this during the break, and we will come back to you, because it might be prudent to actually seek responses from parties around the table at the same time and expect some conversations to have happened behind the scenes. Yeah. Yes.
So, listening to the concerns that have been raised from principal stakeholders in the room, and thinking that we're coming now to a break and we also have lunch and we are here today for the duration of the day. Later on we're looking at the VR goggles. I think it would be extremely helpful for people that have not had a chance to look at them to be afforded the opportunity to look at those VR goggles if that's possible. And also, of course, to explain how the changes have come about as a result of our questioning during the examination. Hence, what we're discussing now are changes that have been made during the examination, what those changes you are proposing look like. And if you can take the time to explain that to people here, I think that would also be helpful during the breaks.
Amy Sterling, on behalf of the applicant, yes, as requested by the examining body, we do have the VR headsets available today. Those reflect the MIC application as applied for, as confirmed at the request of the examining authority. So they are different to what was consulted on, because there has been scheme refinement between consultation, a reduction in the number of turbines, etc. But the applicant can make those available.
So, and that is, of course, fully understood that that was consultation. It's not what is in the application. Nonetheless, I think it helps people to visualise in terms of 3D what it is that is being discussed.
Amy Sterling, on behalf of the applicant, yes, that's understood.
Okay, the time now is 11:33 a.m. We'll take our first break. If everyone can endeavour to be back by 11:50 a.m., please, and we will start with agenda item 4. ready? Okay, welcome back, everyone. Can everyone please settle down as quickly as possible, please? We will make a start now. The time is 11:52, and we're starting session 2 of specific issue hearing 8. And we're going to start with agenda item 4. And so we will now move on to what I've referred to as the Scheme 2 indicative layout. These are not amendments which the applicant has proposed to incorporate into the draft MIC. Instead, you've introduced them as what you've described as a without prejudice indicative alternative layout, whilst maintaining that the primary case as the proposal, the primary case remains the proposal that you're seeking consent for. So again, from my reading, a summary of what this indicative alternative layout is. It's a reduction in the array area from 211 square kilometers to 113. A reduction in turbine numbers from 87 to 72. Relocation of the array further offshore, typically by about 3 to 4 kilometers, depending on the viewpoint. Reduction in the number of significant landscape and visual effects from 56 to 47. Balanced against that, it also results in a reduction in generating capacity from approximately 1.4 gigawatts to 1.1 gigawatts, and a reduction in revenues of approximately 20 to 25% over the life of the project. So, my first question, the examining body's first question, quite simply is, what is the status of this indicative alternative layout? Are you asking the examining body to consider it as an alternative scheme capable of recommendation, because some of your wording suggests that? Or is it simply an illustrative concept? And if that is the case, what are you expecting us to do with it?
Amy Sterling on behalf of the applicant. I think it is worth reiterating the action that we were given, action point 8 from specific issue hearing 5, which drove what was initially called the thought experiment, which was to explain whether there were any SLVIA mitigations which could be put forward that could reduce SLVIA adverse effects and the commercial and generation implications of that. The applicant therefore prepared the thought experiment document submitted at deadline 5, including an indicative alternative layout, which incorporates the changes we've already discussed under agenda item 3, in addition to the changes that you've mentioned, Madam, so the reduction in turbine numbers and the reduction in spatial extent of the array. And the applicant presented that at deadline 5 within its thought experiment to provided some information at that time on the environmental and other implications of that design refinement, and particularly focused on SLVIA. At deadline 6, the without prejudice submission was a confirmation that that reduced scheme remained technically and commercially viable. The applicant needed the additional time between deadline 5 and deadline 6, so the substance didn't change between deadline 5 and deadline 6. That was simply the ongoing governance process that the applicant has. The applicant therefore has put forward the without prejudice indicative alternative layout as a representation of the thought experiment and a reduced scheme that the examining body could seek to recommend if they felt that's where the planning balance was more appropriately based. And the Council of Ministers could determine and grant the MIC if the Council of Ministers determined that's where the planning balance more appropriately sat. The applicant's position is that the planning balance remains for the proposed development as applied for, subject to the design amendments we've already mentioned, because the reduction in SLVIA impact is not without implication for the delivery of the project needs. So there is a reduction in generating capacity, therefore a reduction in export opportunity, a reduction in output, and therefore a reduction in economic benefit. Ultimately, it's for the examining body in your recommendation report and the Council of Ministers in their determination to decide how the benefits and the impacts of the scheme should be weighted. The applicant's position is that the planning balance favours the granting of the MIC application for the proposed development. That remains its primary case. Nevertheless, it has identified this reduced project, which does have some reduced impact, but also has reduced benefit, as an alternative that the examining body could seek to recommend, or the Council of Ministers could grant, if they felt the planning balance was more appropriately balanced at a smaller scheme.
Okay, so just one point of clarification. So the Scheme 2 alternative layout is in addition to Scheme 1, not instead of Scheme 1.
Amy Sterling, on behalf of the applicant, if the MIC application was granted for Scheme 1, the applicant could always have built Scheme 2. I think that's important to note because it is inherent within the maximum design scenario. I think it's important to note that this, I don't think it needed to specifically be referenced in the legislation, but it is. Regulation 41.3 of the Marine Infrastructure Consenting Process Regulations specifically states that a marine infrastructure consent may be phrased to refer to the maximum extent of proposed control marine activity without requiring the applicant for consent to carry out the proposed control marine activity to the fullest extent permitted by it. So if the applicant never introduced the thought experiment, never introduced the indicative alternative layout, but was granted the MIC application as applied for, it is still a scheme that the applicant could have built. Nevertheless, the applicant, in response to action points raised by the examining authority, sought to challenge itself to whether or not there is a reduction in design flexibility that would still leave a commercially and technically viable scheme that would have some measurable impact on SLVIA and other topics. The output of that thought experiment is represented by the indicative alternative layout, which the applicant puts before the examining body as an option that they could recommend if they felt the planning balance was more appropriately struck with a smaller benefit, with a correlated smaller impact, albeit it's not linear.
Okay, so that's interesting. I think the point about whether or not the Scheme 2 alternative layout is something you can deliver should Scheme 1 be consented, I think that's debatable, because if you're reducing generating capacity and you're reducing revenue and you're reducing the array area, etc., then there is possibility of it to be a material change to the scheme.
Amy Sterling, on behalf of the applicant, I wholeheartedly disagree with you, madam. That's not how a maximum design scenario works within a consented application. There is nothing in any DCO or in the MIC, and I've read you the legislation, which would require the applicant to build the maximum design scenario. It is consented. It would be for the applicant, albeit through the discharge of conditions process, to identify a commercially and technically viable scheme that it was putting forward at detailed design.
Okay, so there's a couple of things that you've put forward here. That you've put forward this thought experiment, which you believe can be delivered regardless whether it's brought forward through this application or not. So there are two procedural routes you're suggesting. One is that it is for the examining body to decide whether the planning balance is more appropriately met with the reduced scheme or Scheme 2 alternative layout, or with the current scheme, or indeed the option is left to the Council of Ministers.
Amy Sterling, on behalf of the applicant, clarification is not for the examining body to decide, it's for their recommendation. It's only the Council of Ministers who can decide.
That's understood, Ms. Sterling, and that's, I don't think you need to specify those matters to us, because those matters are something that we have been, rather clear about right from the start, and in fact is something that forms a part of our introductory remarks, that we are only making a recommendation to the Council of Ministers. So whether we propose that in our recommendation is for the examining body to decide. But let's visit those procedural routes under agenda item 4D. So let's just put a pin on that for a minute. What you've then I think this very neatly leads us to agenda item 4B. But bear with me before I move on. Okay, I think I'm content to move on to agenda item. Okay, we've got a question on Teams. Yep. The microphone, yeah, okay.
Thank you very much for Janet Clark. I think the thought experiment came out at deadline 5, but also between deadline 4 and deadline 5, there was another change, and that was in one of the commitment documents, which was a change from micro to macro. Please, can the applicant explain the exact differences between those? Because I think macro means that things can be changed post-consent, and how these relate to the changes that they're proposing in the thought experiment. In particular, does the change from micro to macro mean that they may suggest a reduced scope now?
Ms. Clark, can you give us the examination library reference number? Can you give us the examination library reference number for the what you're referring to?
So the micro to macro, it's the commitment document. I think is it 3.1.1, but it was referenced by somebody at deadline 6, and I'm just trying to remember who that was. I think it was Anne Crane who referenced it.
I am not 100% sure I understand what you're referring to, because I don't have the document reference or indeed any prior notification
of the applicant. It's D5011, which is the applicant's commitment register. Thanks.
Please, can the applicant explain what the difference is between micro and macro then in their glossary? Thank you, because that definitely changed. Thank you very much.
Applicant?
Dr. Keoghan on behalf of the applicant. Up until deadline 5, we had been referring solely to micrositing, and micrositing being the movement of any infrastructure within a tolerance of 50 metres. There was some discussion with DEFA and with other stakeholders that micrositing, we were referring to the term micrositing on interpretation that it should be wider than 50 metres. We then introduced a change in the terminology used. So we have micrositing, which is for all foundation infrastructure. So for all turbines, that they can be microsited 50 metres. And then we have a macro siting, which is in relation to the island link cable only, and due to it was something that was raised by Manx Wildlife Trust at the last series of specific issue hearings, that there's a preponderance of outcropping in bedrock in close proximity to groundle. So we thought, having reviewed the geotechnical data for that, it would be best to introduce the concept of a macro siting, and that macro siting is constrained within the MIC to be 150 metres, and it only applies to the movement of the export cable in relation to sensitive features that are mapped pre-construction. So the macro siting is a process that is it's set out in the biogenic geogenic reef mitigation plan, and that process will be done in consultation with the final approval with DEFA and DOI.
Thank you. That's helpful clarification. Anything from DEFA on that to either corroborate or?
Ken Milne, representing DEFA. Just to reiterate what the applicant said, that was right. We had a discussion with the applicant, and we were keen to avoid high-value priority sites, habitat sites, so it made more sense, a bit more flexibility. So it just helps clarify between micro and macro.
And without putting words in anybody's mouth, and that's obviously within the maximum design scenario.
Dr. Keoghan on behalf of the applicant, it's not necessarily, it's not outside, it's not really a concept that's linked to the maximum design scenario, it's really how we confirm the construction, so where the cable will be. So within the consented envelope for the cable. We'll go and do the pre-construction geophysical and benthic survey. We'll come back then. We'll map up all of the sensitive features and any basically buffer zone that's required to ensure that they're not damaged during the construction. We will then route the cable around them, so it's within the design corridor, so within the works corridor. So it is within, there's no change to the maximum design scenario of the cable or anything like that as a result of the micro or macro siting. It's just the process by which we agree that final location of all infrastructure within the offshore environment.
Okay, we are ever so slightly straying out of this agenda item, so I do want to bring us back to topic, but this is important. Ms. Clark, was there any further clarification you needed? But okay, I don't see any hand up.
Thanks very much.
Thank you.
Clark, thank you.
Thank you, Ms. Clark. Okay, if we want to pick this up, we can pick it up later in the afternoon or indeed at SIH 9, but that's helpful clarification. Good, okay. So where are we? We were moving on to agenda item 4B. And I think the point was, what I want to explore under 4B is planning policy implications. So one of the consequences of the work that you've undertaken, and you have now put this in front of us, is you've identified what appears to be a viable alternative scheme or an alternative layout, which on your own evidence potentially reduces the adverse effects. We've not tested it. We do not have an ES in front of us with this, so which is why I'm couching my language to say it potentially reduces the adverse effects. So that just raises a number of policy questions. So first, strategic policy 4, which requires consideration of whether the need for the development cannot be met in other less ecologically damaging locations or by reasonable alternative means. Now, given that you have now identified what appears to be a less environmentally damaging alternative, could you explain why you consider that the application before us continues to satisfy this policy requirement?
Amy Sterling, on behalf of the applicant, yes, of course. I think the key point in the quote you've provided from Strategic Policy 4 is need. The need for the development cannot be met unless ecologically damaging locations or by reasonable alternative means. The applicant's position is that the need is not met to the same extent by the reduced scheme because there is a reduction in generating capacity and therefore output, a reduction in the ability to export renewable energy to the UK to assist the UK meet its energy targets, and also a reduction in the energy benefits to the Isle of Man via taxation and rent. So the applicant considers the MIC application as applied for continues to strike the most appropriate balance between need and impact.
So I think there's quite a few points that emerge here. First of all, you have always talked about the policy requirement that you are meeting, and in fact, DOI have confirmed that, is economic benefit, not need. Secondly, there isn't a threshold in your policy documents for what that, for instance, there's a threshold in Planning Act of what becomes an NSIP, and therefore the need for a particular project is established in the NPS if it crosses that threshold. There isn't that threshold in these policy documents. So how is something that's generating, just for sake of argument, £2 billion versus something that's generating 1.6 billion or 1.8 billion pounds, how is that distinction? How do you draw that distinction that you're not meeting the need?
Amy Sterling, on behalf of the applicant, if I may, Madam Chair, can you please explain why you don't consider economic benefit to be relevant to need? I would suggest the applicant's position is that economic benefit and export opportunity are the two factors which demonstrate the need for the development, and the need for the development is established, in our view, in policy, and it hinges on those two factors, the export opportunity and the economic benefit, but I don't consider them to be distinct or in any way removed from the need for the proposed development. And on that basis, the applicant considers that the benefits are reduced with a smaller scheme, and that therefore there's nothing within strategic policy for the MPS or the EIA regulations, which require the applicant to bring forward a minimum viable project to meet policy aims.
Anything from you, Mr. Garden?
Yeah, Mr. Garden, on behalf of the Department of Infrastructure, I think in terms of the policy basis, that is correct, and that's how the department has been approaching it, is that the 2014 report establishes the need for this project in relation to the economic benefits and the export opportunities. I'll slightly couch my response similarly to you in terms of the work that needs to be done by Treasury to understand the potential implications of this change request, or not change request, but potential reduction in generation capacity. So I think that needs to be explored and is something we can take away with Treasury colleagues.
Okay, that's it was helpful to understand that distinction between economic benefit and need for the proposed development as two distinct things. I'm not saying that we're accepting that analysis, but that distinction is definitely helpful. Okay, what we'll do is that we'll put that down as an action in terms of what Treasury needs to understand, Mr. Garden, what you just mentioned right now. We'll put that down as an action, but I suspect that that action is going to get massaged and become slightly different as we go further into this agenda item. Okay, good. Let's move on to EN1. Paragraph 5.10.26. And given that you've identified that this is a relevant policy document, I'm going to just read this verbatim. Secretary of State should be satisfied that the applicant has demonstrated that the proposed development is a suitable design in terms of its potential adverse effects, including landscape and visual effects, taking account of the effectiveness of any proposed mitigation. Once again, can you then explain how the primary case continues to satisfy the relevant EN1 policy on design, evolution and reasonable alternatives now that this alternative layout has been identified?
Amy Sterling on behalf of the applicant. Yes, we can, I think just as you've read, paragraph 5.10.26 says reducing the scale or otherwise amending the design may result in a significant operational constraint and reduction in function. Our view is that the without prejudice indicative alternative layout demonstrates there would be a significant operational constraint and a reduction in function as compared to the proposed development as applied for. It would then be for the examining body in its recommendation and the Council of Ministers in its decision to determine whether there are exceptional circumstances whereby the mitigation could have a very significant benefit and warrant therefore a small reduction in function. Ultimately, that's a matter for the planning balance which has to be undertaken. The applicant's position is that the proposed development strikes that appropriate balance between function and impact. It is ultimately for the examining body and the Council of Ministers to determine whether they consider that balance is more appropriately struck for a reduced scheme, and therefore there are exceptional circumstances where the mitigation has a very significant benefit which would warrant a small reduction in function. The applicant considers that the proposed development remains where the balance should be struck. I do think it is also important, though, Madam, just to also refer to other parts of the MPS, which are also relevant. So, paragraph 4.3.23 of MPS EN1, which deals with alternatives more generally, considers that the Secretary of State, in that instance, should consider alternative proposals, be guided as to whether there is a realistic prospect of the alternative delivering the same infrastructure capacity and the same timescale of the proposed development. Of course, there would be a reduction, quite a significant 1% reduction in generating capacity. So overall, the applicant's position is the MIC application meets the relevant policy within the strategic plan, within the MPS, but nevertheless, that there is a smaller, reduced viable scheme, which the planning balance in our view would also favour, that could be consented if the Council of Ministers and the examining body in its recommendation disagree.
Okay. All right, and I think just in terms of EIA, marine infrastructure consenting, let me just rehearse this. Yeah, so what is required under the MIR is a description of the reasonable alternatives studied by the prospective applicant, which are relevant to the proposed controlled marine activities and its specific characteristics, and an indication of the main reasons for selecting the chosen option. I think you have roughly covered that in everything you've said so far. Is there anything else? So, and I just keep going back to the point that with this alternative before us, give us your justification of why your proposed scheme remains your preferred option, and whether it continues to meet these policy requirements, given that that alternative scheme is now, has seen daylight.
Amy Sterling on behalf of the applicant. I don't know if we've got much more to add, Madam. It's about planning balance, the balancing of the impacts and the disbenefits of the scheme. The benefits and the disbenefits of the scheme. The applicant's position, as set out in its planning statement, the predecessor, the planning support statement, is that the planning balance warrants the MIC application being granted as applied for because the benefits outweigh the disbenefits. That doesn't change by the identification of a smaller project within that maximum design scenario, which remains commercially and technically viable. I would suggest that the EIA regulations, yes, they require a description of reasonable alternatives considered. The applicant has complied with those EIA regulations through its site selection alternatives document, through the developable area approach that it has presented. There's nothing in the EIA regulations or policy which require the applicants to identify the minimum viable project as a reasonable alternative to be put forward. So our position is we've complied with the policy and legislation, and that the planning balance favours the MIC application as applied for.
Okay. Okay, I don't have any follow-up questions. I'm just looking around the top table if... No? Okay, I do want to turn to DEFRA now. Once again, my assumption is that the first time you've probably seen this was at deadline 5. What are your thoughts?
Ken Milne, representing DEFRA. We've not had sufficient time to review it all properly, and everything we've said in our previous submission still stands. And we just need a bit more time to consider and evaluate everything that's been submitted.
Okay.
Thank you.
Mr. Milne, I think it'll be reasonable to say that it would help the examining body to know what your view is in terms of a preferred option. It is an option before you. We have asked for your views on planning balance before through hearing actions. And given the applicant's case about that this is ultimately about planning balance and whether the reduction in adverse effects justifies the reduction in the benefits of the scheme, and where that balance is better struck, I think we would really like to hear the government's views on that.
Ken Milne, representing DEFRA. I'll just pass over to my colleague, Abigail Morgan.
Abigail Morgan from DEFRA.
Madam, could you move the microphone closer to you, please?
Yeah. Is that okay? So Abigail Morgan DEFA planning, so we are distinct from the Cabinet Office in that regard. In terms of the planning balance, if you were considering the both schemes separately, they would all have their own pros and cons, which I think the applicant has set out quite clearly from my perspective, and they would all then be considered in the round. With both of them, there are benefits and disbenefits. From what I can tell, some of the benefits of the reduced scheme come from the SLIVA requirements. So how much weight you would put on those, reduction of visual impact and those other things that come from the SLIVA would be for the decision-making process. And then that would have to be then weighed against what the negative aspect would be with the reduction in the amount of energy supplied and any revenue return to the government. But I suppose as they stand, both of them would have equal balance measures in the proposals if they were two separate applications that were before us. Thank you.
It's the reduction in adverse effects is not just SLVIA. Presumably, it will be quite significantly wider than that, simply because of the reduction in the array areas, almost 47%. So I think the effect on marine ecology will be quite significant as well. I think your point is noted, and I completely appreciate that it is going to be difficult to do that assessment of the pros and cons of the two schemes. But I will urge you to do that and get back to us. If again, we can note that down as a hearing action, that'd be really good. And then I think it's important to turn to DOI. And I think you've already made your point about the reduction in the revenue and that you need, to hear from Treasury. But what are your thoughts on this?
Yeah, Robert Garden on behalf of the Department of Infrastructure. I think in terms of the planning balance, the department has set its position out in previous submissions by reference to the 2014 report. That has a kind of upper capacity limit, and it has identified sums that it attributes significance to. And I think the sums that have been proposed here still exceed those sums. So I think whilst we have to go away and look at those sums, there is still an element of significance there. And clearly, in the planning balance, the reduction in the number of significant effects in terms of landscape impacts, but potentially other impacts, does potentially lead to less weight being afforded to those in this alternative scheme as part of the planning balance. I think in terms of information, and you may come to this, so stop me if you have further questions, but in terms of information that is needed in front of the examining body before a decision can be made on this, and noting that we saw the kind of without prejudice document with the financial sums at deadline 6 for the first time. I think you've alluded to planning policy compliance, and you've got a compliance schedule for the first scheme. You probably need that for the second scheme, as well as the environmental sensitivity test that we touched on for scheme 1 earlier. But I think we also need to see what the consequential changes to the draft MIC will be, because I think without prejudice document notes that there'll be a number of outline plans that might need to be updated, for example. So from the department's perspective, what they need to understand to fully respond to this is what that looks like, and what a draft MIC might look like that came out with this alternative scheme, in addition to the Treasury position as well.
Okay, and just because you touched on this before, in terms of this being able to be brought forward within the draft, through draft MIC changes, just as an alternative recommended MIC to the Council of Ministers, what is your view on that? Or does this present an alternative layout which then needs to go through the change request process?
Mr. Garden, on behalf of the Department of Infrastructure, in relation to the process that it needs to follow, I think Ms. Sterling is right that effectively this scheme could be delivered pursuant to the maximum design scenario. So we have that maximum design scenario currently secured in the draft MIC, and it would be entirely for the applicant to promote this scheme at the point at which they go through procurement and then discharge of the conditions, and the department will have its role there in terms of discharging the conditions. I think that the difference is where we're being asked to effectively cap, if you like, not the number of turbines. That will need to be secured if that is the basis for the Council of Ministers decision in the draft MIC. So if you were to recommend and the Council of Ministers were to determine that this was the basis on which consent was being granted, then the draft MIC would need to be clear to that effect. It would need to amend the number of turbines, and I think there would need to be consequential amendments probably to some other management plans that are sat behind the draft MIC as well.
I think changes to the MIC are understood and there's no contest there. But my question is more whether this potentially presents an alternative scheme which needs to go through that materiality test, and whether that is something that needs to be done within the examination.
Mr. Garden, on behalf of the Department of Infrastructure, I don't think it does need to be done, and the reason for this is what you are effectively being asked to do is to assess the maximum design scenario still, so you still have that as the worst case, but impose requirements that limit the amount of infrastructure. So I think what needs to be done is effectively that continued assessment of the maximum design scenario with a sensitivity test against it if you are considering taking this forward. And that's where, probably similar to the Scheme 1 process that you mentioned earlier in terms of the environmental assessment, I think that's what needs to be done here in order to impose requirements like this through the draft MIC.
Okay, I'm going to hand over to Mr. Smith for a question, but just so I don't lose my own chain of thought, I have procedural questions here, and I've got what further information is needed. So let's just, those, I'll return to those, but I'm just going to hand over to Mr. Smith now.
Well, thank you, Mr. Garden. This is a consequential on that conversation, but I thought it would be useful not to go beyond this point before just briefly exploring the question of whether there was a level of reduction in apparent benefit from an application before us that would reach a point at which, in terms of your view, it would be possible that the harms became unacceptable in principle vis-à-vis the reduction in scale of benefits. So in other words, if you're looking at the balance, at some point if you take benefits away and the harms are maybe not reduced in proportion, you end up with something that has less benefit than harm and the balance tips. Is there any possibility of that emerging from what we have in front of us? And if that were to be the case, would there be any merit, in your view, in securing essentially a minimum viable position?
Mr. Garden, on behalf of the Department of Infrastructure, on the first point, I think this is the bit where we need to understand from Treasury what the consequences will be. But theoretically, yes, I think there is a tipping point where the potential benefits do not outweigh harms. But I'm not saying that is where we are here.
No, I know that. And frankly, I wouldn't ask you to form that judgment live in this session, absent a range of supporting material that we need breaking down the effects of these changes vis-à-vis all of the relevant heads of analysis in the environmental statement. So rest assured, you're not being put in too hard a spot.
And in terms of the second question, I don't think that is necessary, because I think what will come forward would be ultimately flexibility within that scenario still, and I think it would potentially place an undue onerous condition onto the applicant. So it's not something we have considered to date of imposing a kind of minimum viable scheme. That has been based on effectively the maximum design scenario and flexibility within that to date. So that reflects the position that we have adopted. And I think if you were to take the view that effectively the decision that you make is that on the scheme 2 that has been put in front of you, that the benefits outweigh the harm, that there is no reason to depart from that in terms of decision making from what you were presented with scheme 0.5 before scheme 1, effectively.
And that remains true at all points of potential further reduction in scale, because the logic of Ms. Sterling's submission before us is that essentially there is no minimum that one can continue to peel off and not deliver elements of the consented scheme down to almost a one turbine model.
Mr. Garden, on behalf of the Department of Infrastructure, I think that the key here is effectively the schemes that are in front of you, and I think you have those two with the benefits and the disbenefits to assess. We need to understand both of those a little more in relation to this scheme, and that is effectively the decision that is before the Council of Ministers and yourselves for the recommendation. I don't think there is a tipping point. I don't think we have reached a tipping point where that would become imposed. I'm not aware of it being imposed on any scheme historically through the DCO.
It hasn't. Of course, the reason that you'll be very alive to is that, for example, if we're looking at Planning Act of 2008, there are thresholds that deliver those schemes into the system, but there are no such thresholds in MEMA.
Yeah, Mr. Garden, on behalf of the Department of Infrastructure, I think those thresholds are effectively to which consenting regime you go into. They don't dictate whether you have to secure that as part of any process. So I do understand that, and the way that the Marine Infrastructure Management Act has been set up, it doesn't have those same thresholds. It talks about development in the marine environment, and that's what that is effectively a kind of consenting threshold decision, and reflects the way the regime has been set up, as opposed to a need to secure that minimum generation capacity, for example, on offshore wind.
Yeah, thank you, Mr. Garden. Thank you, Mr. Smith. I will hand over to Ms. Pownell now.
I just wanted to, for the sake of clarification, so there's a lot of talk about the landscape and visual benefits from the scheme. I think the Cabinet Office has just been discussing those. But the construction benefits would also come into play here, I'm assuming. I'm asking the applicant here. So significantly less turbines, less construction activity, less vessels, less waste disposals. I just wanted to, if you just clarify that very quickly, just to make the point clear.
Amy Sterling, on behalf of the applicant, thank you for the opportunity. I did want to just ensure that everyone is aware that the applicant has carried out an appraisal of EIA receptor topics. That's at section 3, and then carried those forward where appropriate in section 4 of the Without Prejudice Indicative Alternative Layout document, which is, I can get the examination library in a moment, that exercise has been undertaken. The applicant has identified only 3 topic areas where there would be a change, in each case a positive change, to the likely significant effects reported. The first is in relation to SLVIA. I'm conscious we do have our SLVIA technical expert here. If there are any technical questions on the thought experiment and the reduction in impacts, or at least the change in magnitude levels related to the thought experiment, we'd be more than happy to take those. The other is in relation to commercial fisheries, and the third is in relation to shipping and navigation, noting that the shipping and navigation NRA already identifies that all impacts would be a LARP, but nevertheless the effect of the thought experiment would be that there would be a reduction in a reduction in infrastructure, therefore an increase in the available sea space. So the applicant has carried out that assessment and put that forward. The applicant has also set out in its documentation that the main change to the MIC application would be a reduction in the turbine numbers. The applicant is also currently undertaking whether or not there would be any other refinements associated with the thought experiment, such as a reduction in the array cable length to reflect the reduced number of turbine positions, and therefore a reduction in cable protection volume, for example. The applicant is undertaking that work and will provide it. Currently, I'm advised at deadline 7. Nevertheless, I would dispute that there needs to be a draft MIC to accommodate those changes, and I think if the applicant signposts what amendments there would have to be to the MIC, the way that the Marine Infrastructure Management Act is set up is they for the examining body, if it determines that an MIC application to be granted, to prepare a draft MIC and submit that to the Council of Ministers. There's no restriction. That's an open-ended power. You're not restricted to the MIC application, draft MIC that we've provided to you as applicant. Likewise, the Council of Ministers is not restricted to the draft MIC that the applicant has put forward. So it would, of course, be open to you in your recommendation or the Ministers in a decision to propose an MIC which contains these amendments. In any case, obviously you need to know what they are. That work on the array cables, as mentioned, which was the predominant change refinement that I would expect to arise from the reduction in turbine positions, would be identified. In relation to the management plans, the applicant did signpost the management plans that it was considering may have to be amended if the without prejudice scheme were taken forward. The applicant is happy to take as a hearing submission to put forward what exactly those changes would be. I suggest they're actually quite minimal, and it was more reflecting the amendments to the parameters rather than any change to the substance of the management plans. So I think that would perhaps give some comfort and also allow people to comment on what those potential changes would be in good time for deadline 7. Sorry, if I may, the final point is I just want to touch on the minimum viable project. I would suggest the applicant has considered and does consider that currently the thought experiment does represent the minimum commercial viable project as the applicant is set out in the thought experiment document. Our position is there's not one specific design constraint which creates a cliff edge after which the project is just immediately unviable, but it's a continued reduction in design flexibility which erodes competitiveness in the market, which ultimately means there becomes a point where no matter what's consented, the applicant is probably unlikely to build it. And it's that, and we've identified 72 turbines as that threshold, and positions below that would make it very high commercial risk project and not something that we consider is commercially viable.
Okay. Thank you, Ms. Sterling. I think these documents that you've just listed, they seem fine, but I think we would just need to think that through, and perhaps collectively with parties on my right. But also we would probably need to take that away and just like we've done before, signpost some additional documents in the examination library which we think might need updating. With regards to the MIC, you're absolutely right. It is up to the examining body to submit a recommended MIC to the Council of Ministers. But can we ask you to, without prejudice, provide what that changed MIC would look like if we insisted on it? For this. And Mr. Garden, if you have any points of input on that, then you're welcome to say it now or convey it to the applicant during lunchtime on what these changes to the draft MIC would look like. But at this moment, without having that information before me, I'm tempted to agree with Mr. Garden that we would probably need a draft from yourselves, or let's say draft 2 from yourself, for that to be considered. Just a couple of points.
Sorry, Madam, before we leave that point, Amy Sterling, on behalf of the applicant, could I query then whether or not you would also like without prejudice works plans, because the changes to the draft MIC would relate to the spatial extent shown on the works plan, so I suggest they would need to be read together.
Absolutely.
Yes, okay,
and
thank you.
Would you expect there to be a change to order limits?
Amy Sterling, on behalf of the applicant, there's no change to the order limits. It's just the spatial extent of works number 1 and 2, which is sort of reduced to the northeast. Amy Sterling, on behalf of the applicant, it is presented in the without prejudice indicative alternative layout document as an extract, but we can provide that as a standalone without prejudice plan.
Okay. Okay, good. My colleagues have questions, so I'm going to hand over to them while I collect my thoughts, actually. So, yeah.
It was just to add to that action. So I've got applicant to provide the updated draft MIC without prejudice for this scheme and the works plans. But also you indicated that you might be prepared to set out the changes in the management plans. Don't update them all, but just signpost the changes that will be across the plans. Is that?
Amy Sterling on behalf of the applicant. Yes, probably different deadlines. Sorry, I'm getting feedback on the...
Is that me? Might be me.
We have undertaken as a hearing action, yes, to review the list of management plans that we said in the without prejudice case that we might consider any changing, what we anticipate any changes would be.
Oh.
If it would be helpful, we could submit those as without prejudice updates for deadline 7 of those management plans. The
Updated, sorry, just to clarify.
Yes, the without prejudice versions at deadline 7, but I appreciate there's some time now between now and deadline 7, so we think it would be useful to indicate the direction of travel.
Sorry. I just wanted to clarify.
On behalf of the applicant, apologies. Sorry, I'm still getting feedback on the mic. Dr. Caroline has made a good point. So I think taking things in turn, sorry. So updated draft MIC without prejudice, we can provide that for deadline 7. It would be primarily a reduction in the number of turbines, and also what we're investigating is whether or not there would be a corresponding reduction in the length of array cables and the associated cable protection, etc. associated. That technical work is ongoing. We can also then provide an updated without prejudice version of the works plans, which is currently in an extract in the case we've put forward as a standalone document. Dr. Caroline has questioned, I think it's a good one, is that if we start providing without prejudice versions of management plans, might that be confusing for people? So would it be better if we signposted as a hearing action what the changes might be? Perhaps you consider those, and if you want those updated versions, you could ask in your written questions.
That's fine, thank you. Thank you, we'll take it away and come back to you.
Okay. Good, so I think there's quite a lot to chew over here, so we'll take that away. We'll come to it. Just one moment, please. We will take that away and we will consider it during lunchtime, and we will flesh that action out. And I think there's a few actions that we probably might need to revise in line with that. I am not going to cover agenda item 4C because I think in terms of planning balance, a lot of the discussion has been underpinned by that. But before I move on to agenda item 4D, I just want to collect comments from around the room, if there are any. Sorry, bear with me, Ms. Farragut. I'm going to hand over to my colleagues first, and then... Okay, fine. Apologies. Back to you.
So thank you for how you've tried to balance what's been produced today and how you're going to deal with it. And we'd be very pleased to enter into some consultation on that, as other stakeholders would be. But I can't, picking up on what Ms. Sterling said about the positive change to the LEAs, likely significant effect, areas that are going to be affected, sensitive areas. I cannot believe that we've got this far into the examination process without proper Seascape character assessment, and that is for the Isle of Man Seascape. Because no matter what is produced, whether it's the original scheme or another scheme or another, you cannot make... Who can make a judgment on how important our seascape is? It's no use using Nature Scot or Scottish Seascape or whatever you've used to do your assessments. We absolutely need to have our own policies here to protect our coastline. And this involves people, doesn't it? How is a seascape perceived and experienced by people? We had the drop-in Laxey. We've got lots of evidence that we've produced for you all on that. It's important to everyone's quality of life. People have attachment to places. People should have a say in how it is managed. And that's what's come out right through the public meetings, right until where we are now. The Manx people have not had a say in how the Seascape is managed. Seascape is experienced visually, but also through memory and association, senses of hearing. I'm reading from a document commissioned by Natural England here, actually, not Nature Scott. But this is general stuff. So it's involving people and how they experience the sea. Senses of hearing, smell, touch, taste, and awareness in art, music, literature. People value it for different reasons, often reflecting the ecosystem, but also contributing to their personal and community and identity. It needs an evidence base. You're looking for an evidence base to make your decisions today. And it needs a spatial framework, and we have not got a spatial framework.
Thank you, Ms. Farragher. I think some of the Seascape character points are being picked up later on today, so hopefully we can bring up some of that later on. But I do want to give the applicant an opportunity to respond to some of this because I do think it's quite pertinent.
Amy Sterling on behalf of the applicant. Yes, thank you. It was similar to the points that were raised earlier. I think the applicant's position is it has provided a seascape landscape visual impact assessment in accordance with the established and precedented methodologies. That includes visualisations and wirelines. It has also engaged pre-application and quite significant consultation with communities on the Isle of Man. The applicant previously signposted to that pre-application consultation as a previous hearing action that it had taken. Ultimately, of course, the examining body and the Council of Ministers will take into account all of the evidence it receives. You have the applicant's evidence, but you also have submissions from other principal stakeholders made orally and in writing to consider when you're determining the planning balance. So it's not the case that it's only the applicant's position and that is the only thing considered in the balance. I do think it's important just, I guess, for everyone to be clear when we talk about consultation, and that the consultation took place by the applicant in the pre-application phase. We're now in a formal legal process of examination, and it's through this examination that representations can and should be made in respect of the application. So if there is no sort of separate parallel consultation process that the applicant is undertaking, because we don't consider that would be appropriate in parallel with this formal legal process, because people may be confused as to where they should most appropriately direct their representations. In our view, is that it should be within this process. So I just want to be clear that there's not sort of an additional consultation that's ongoing.
And I think I've made that point as well before. But just one point, Ms. Farragher, that I do want to emphasise is that everything that's coming into examination is part of the consideration. So it's not for instance, if the applicant has not persuaded us on how it is meeting a certain policy that we consider important and relevant, which ultimately is what we have to do, then it is in our gift to find that missing, give limited weight to that. So it's very helpful for you to highlight where that analysis or where that justification is weak and why it is weak, and substantiate that with your own reasoning. So, all of your submissions do contribute towards that. Okay, thank you. I can see 3 further questions. I've not heard from the gentleman over there, so I'm going to invite you first. Yourself, please, sir. Yeah.
Martin Cubban, Principal Stakeholder. A couple of questions pertaining to the thought process. It would appear, from what we've heard from the applicant, that the current thought process doesn't make a meaningful impact on the visual impact of the project. What its impact is on fishing, on bird migrations, on navigation, it seems is debatable, but maybe that's just a lack of information. So my first question is, if you're going to embark upon a thought experiment, why not do something more radical and move the project to the west coast, where the visual impact is much less, where there'll be no impact on navigation, no impact on fishing, no impact on bird migrations. It seems, it seems somewhat obvious that if one's going to embark upon other alternatives, why not something which appears more radical but addresses many of the concerns expressed by members of the community? I have a second question, but if the applicant would like to answer that one now. Or I should go to the second question.
No, what I'm going to suggest, Mr. Cubbin, is that we're about to lose the monitor here. We're about to lose the monitor. What I was going to suggest, Mr. Cubbin, is that you put both your questions forward to us. I will ask the applicant to respond.
Okay. The second question, and I think it stems from something I think I heard, which is with regard to the minimum number of turbines to make the project.
Bear with me, Mr. Cubbin. We've got a little bit of a tech issue here, so I want to give you my full attention.
Main monitor switching itself off. It's sleeping in 21 seconds. No idea.
It's a TCL. If you could start with your second question from the beginning.
Second question. I think I heard from the applicant a few moments ago, actually, that the minimum number of turbines which is considered commercially viable for the project is 71. I mean, I think, that's slightly surprising, but I heard that below 71, the financial risks of the project are such that perhaps the applicant wouldn't go ahead. This suggests to me that one of the benefits argued in the past by the applicant is that there are significant fiscal benefits to the Isle of Man as a result of taxation on profits in the future. If this project dies on 71 turbines, it tells me this is a very risky project, even with 87 turbines. And that in turn impacts whether there will ever be any financial benefit to the Isle of Man government derived from fiscal earnings on tax. That's more of a point than a... But if that is the real case, that in truth, you wouldn't go ahead if it was less than 71, is a meaningful point, actually, with regard to the likely expected fiscal benefits to the Isle of Man.
Yeah, Mr. Cubbin, the second point, first of all, I believe that's 72 turbines. And we are going into that in quite a lot of detail in session 1 on Friday. So I'm not going to have the applicant address that question now, if that's okay. But the first one, there is quite a lot of evidence in the examination which responds to that point. However, if in brief you would like to give Mr. Cubbin a response to the first question, I think it would be helpful.
Amy Sterling on behalf of the applicant. Yes, first in relation to SLVIA, the comment there wasn't much SLVIA benefit. The applicant has identified through the documents it's provided that there is a measurable reduction in the magnitude of impact, and in some cases removal of a likely significant effect on SLVIA terms for certain receptors. However, it is not possible within the confines of the Isle of Man territorial seas and the agreement for lease area that the applicant has to design out significant effects on SLVIA terms. So there is some corresponding benefit in SLVIA. A few people have said there isn't enough information, or the information isn't before the examination, but that is not the case. The applicant has provided quite a detailed narrative of the implications, particularly for SLVIA, in its SLVIA thought experiment document. That's library reference D5006, and also the without prejudice indicative alternative layout. That's document D6006. The information is before the examining authority, examining body, and the examination. If principal stakeholders would like to review it, it does identify on a receptor by receptor basis for SLVIA what the magnitude of change impact would be from the thought experiment. In relation to the number of turbines, noted the discussion is likely to continue on Friday. Again, the applicant has provided quite detailed information in document D5006 on the sorts of factors that go into play when considering whether or not a project is commercially viable. We would disagree that, you know, this suggests that the proposed development is an inherently risky project. I would suggest that actually it shows that it's been sensitively designed to appropriately balance the sort of benefits and disbenefits of the scheme. I would simply just refer to the information that we've provided within that document, which can be read in full as to the different factors, you know, wind speeds, fiscal, drivers, etc., which effectively have to come together and be considered in the round when the applicant determines whether or not a project would be commercially viable.
Thank you. The question about the alternative, why is it not to the west of the island? Rest assured, I will pick that up on Friday as part of some of the agenda items that I've got on there. Okay. Thank you, Mr. Cubbon. I believe the lady in front had a question.
Michelle Cook, Principal Stakeholder. Thank you for allowing me this. I think that in the absence of the Isle of Man Treasury being here and not having any input from them into the DOI so that they could then pass on the consequences of the change in economics for the alternative scheme, I think it's, thank you, I think it's vital that that change in economics and the revenues is quantified publicly for us. The figure is bandied around the place of 2 billion, let's get this right, up to 2 billion over 35 years. So approximately 58 million a year, approximately equal to 1% of the current GDP. Now, I didn't think we could get much lower than that, much less than that in terms of benefits flowing into the island, under 1% of the GDP. But it turns out we can. And if we go with this other scheme, then we're likely to. Given this, and given that the First Minister has said that this is an economics first project, and we've just heard today how it's about the basis of the projects is about an exporting opportunity and about economic benefits. Can the board confirm that this figure, the revised figure, will be made publicly available?
I believe the applicant has actually provided some figures. Would you like to respond to that?
Amy Sterling, on behalf of the applicant, yes, I would refer to document D6006, the without prejudice, sorry, that was D6006, the without prejudice indicative alternative layout. In that document, the applicant sets out the results of its updated financial modelling for the primary case and the assumptions which feed into that and the resulting economic benefit. And the applicant also identifies, based on those same assumptions, what the economic benefit is likely to be for the indicative alternative layout thought experiment project. These are also set out in table 2 of that document in a tabular format. So for the applicant's primary case, the updated financial modelling, which has been updated on the basis of the auction round 7 CFD prices, is that there would be a 2.4 billion lifetime benefit to the Isle of Man from the primary case, and that would reduce to 1.8 billion for the without prejudice indicative alternative layout. So that information is before the examination and has been since deadline 6. We do appreciate that the Treasury has not yet commented on that. Of course, they will have an opportunity to do so, and the DOI has kindly taken an action to engage with them in relation to that. I would refer to the Treasury's own submission at deadline 4, where they acknowledge that they've not seen or reviewed Ørsted's internal financial modelling, but they've done their own shadow financial model, and the 2 billion exchequer benefit figure is within the range being a keyword, of realistic values. Ultimately, it's not possible to precisely define the economic benefit because there are unknowns. For example, tax rates, other things which are entirely within the control of the Isle of Man government, and the Treasury also recognises that.
Thank you. So, can I just clarify there, and I'm doing this off the top of my head, and first of all, apologies for not knowing
Madam,
that.
if you could address your questions to me, and I'll...
Certainly,
say,
yeah, certainly. So apologies for not having called that so far. There is you just get buried in the paperwork. It's a shame we didn't hear it from our own government offices. However, am I right in thinking here, so I've just done this sitting here, so it's about a 600 million drop in revenue from the 2.4 to 1.8. That being the case, that is a 25% drop in revenue to us. And I think the drop in the number of turbines I've just worked out, again off the top of my head, but I think that 15 is the difference over 87. I've made that 17% sitting here. If anybody knows differently, fine. But that means that we are losing 25% of the revenue for a 17% drop in the scale of the wind farm. Can anybody clarify that for me or confirm?
What's the question?
Is it that we are dropping a quarter of the revenue for a drop of scaling back by 17%, we're losing 25%, am I right?
And if you are, then what's the point that you're trying to draw in?
I am trying to, in the absence of our government giving us any economic input, I am trying to ask, is that correct?
Seems to be, yeah. The maths adds up, yeah.
Okay.
Thank you. Just on the point about economic benefit, it is worth highlighting that a lot of those matters are not on the agenda today. They will be covered on Friday, and as the applicant and DOI colleagues have explained, that this has just come into examination at deadline 6 in its completeness. It's come into the examination at deadline 6, which was about 2 weeks before the hearing. So we're still just grappling with some of this information. The government officers have not had an opportunity to review it, and now that they do, they will respond to it fully at deadline 7. Okay.
Amy Sterling, on behalf of the applicant, if I may, Madam, so just to confirm, the way the applicant's presented it is it relates to we've compared the generating capacity reduction, which is around 21%. I haven't actually got the percentage for the reduction in economic benefit. We can follow that up in our hearing submission. Of course, that goes to the point as to where the planning balance is then weighed when you're weighing the benefits and the disbenefits. Thank you.
Okay, thank you. I've got a question right at the back. Would you like to come forward, please, Madam?
Thank you. Patricia Newton, independent stakeholder. I was really wanting to try and clarify the figures I've just heard from you. Madam Chairman, I think you said that the indicative layout is a 47% reduction in size. I think it was also summarised at the beginning that this represents 1.1 gigawatts. Whereas the 2014 document was 700 to 800 gigawatts. I think I would like confirmation that that means that despite the fact it's a reduction in size, it still represents a 37.5% increase in generation power from a smaller site. The Treasury said that there was a need for the development, and that's what the 2014 document stated. But however, if the 2014 document said it was for up to 800 megawatts, it did not establish a need for the 1.1 gigawatts. I think the Manx public would also argue that they were never consulted on a need for 800 megawatts in 2014. There might have been a document, I can obviously be corrected in this. My understanding was that there would be the opportunity. It wasn't necessarily established as a need to generate a certain level of energy from the seabed lease. The other point I would like to make about this, in general, about the silver impact of the indicative layout is that the impact is less on the areas that are arguably most sensitive, i.e. from Marblehead to Laxey. Either way, from the applicant's own document, 82.4% of the time you can see over the 10-mile nautical limit, and most of this proposal is still within the 10-mile nautical limit. So it will still have a massive impact on people's lives. They will see this continually to and from the coast, particularly Laxey to Ramsey, Ramsey to Laxey. The impact, obviously Douglas to Laxey to Ramsey, albeit maybe not so much in the opposite direction from Laxey to Douglas, but that the impact is far, yes, it reduces the impact on the southern part of the site, but it really, especially when you take into account Morgan, etc., the cumulative impact of these turbines is still, it's negligible what the change proposed is.
If I can assure you that there are a few questions that are emerging in the next few agenda items just today, where we're going to test exactly that point about how this effect of either the current scheme or the reduced scheme, just a comparison of that. Would you be content to leave that question there while we get into that agenda item? And if you still have queries, which I'm sure you will.
Thank you. I wasn't sure if we're coming again to it later or not.
Okay. No, we definitely are. Ms. Sterling, are you content to leave this for the landscape parts of the agenda, or did you want to come back to you?
Amy Sterling, on behalf of the applicant, just a couple of points of clarification. To confirm, yes, the turbine numbers we have presented is a percentage reduction of 17%. That's table 6 of document D5006, and table 6 sets out on a percentage basis each of the reductions, so area, turbine numbers, capacity, predicted treasury revenue, and also in SLVIA, likely significant effects, seeks to translate those into percentage. So quite a useful tool for comparing, and apologies I didn't flag that earlier. In relation to the references from Ms Newson in relation to the 2014 document, I wasn't entirely clear which document we were referring to. The report by the Council of Ministers from 2014, which was approved by Tynwald, refers to 2 gigawatts. We propose to progress development subject to development receiving the appropriate consents and planning approval up to a maximum of 2 gigawatts from offshore wind. In that same document, the Council of Ministers, as approved by Tynwald, also refers to a significant opportunity to meet for the export of power to the UK to meet its national and European renewable energy targets, but also for revenue to the Isle of Man, citing a figure of around 5 million per year in either the proposed development or the alternative case. The figures far exceed the significant 5 million which is referred to in that government report, which was approved by Parliament.
Thank you for that clarification. I am going to thank you. I'm going to hand over to my colleague now, and this will be the last bit of questions that we have before we take a lunch break, because I can see everyone's failing a little bit.
Yes, and given that it's taken a while to get to my question, and I'm conscious that lunch is soon upon us, I'm going to ask just one of the two. And so quite a while back in our discussion on the alternative without prejudice scheme that we're discussing, I think, Dr. Carolyn, you, or Ms Sterling, you referred to the fact that there had been no change to the order limits. And looking at that, the document D6006, it's quite apparent that with the revised scheme array layout, and indeed your summary at the beginning of that document, there is a significant reduction in that array area. I think, let me just put up my thing, from 211 kilometres squared down to 113 kilometres squared. And so naturally the question that would put into our minds is, why would there not be a change or proposed change to the order limits in the array area?
Amy Sterling, on behalf of the applicant, there will be a change to the delineation of the works for work number 1, work number 2, which are the wind turbine generators and the offshore platforms. Those don't necessitate a change to the order limits because the order limits are still required to deliver works number 3A, which is the offshore export connection cable to the Isle of Man, and work number 4, which is the export cable to the UK. So the extent of the works descriptions within the order limits will change, but not the order limits. And the reason for that is because the location of the offshore platforms into which those cables will connect is not fixed.
Okay.
And then the other question, which I was going to ask, but I'm going to hold over, was actually to ask your landscape expert, whose name is eluding me right now, to explain what is in that thought experiment by reference to the different wire lines that we've received at D5 and D6. But mindful of time, I think we'll hold this over to the second session after lunch.
Amy Sterling, on behalf of the applicant, Miss Linda Thompson from Open. Yes, she's here. She's more than happy to speak to this, so happy to pick them up after lunch. Thanks.
Great. So we'll get those wire lines, and I believe the reference numbers are D611 to D613. If there are other examination documents that you feel illustrate that better, then do let Mr. Randall know. And
so it's D5006 and D5064 as well.
As well, yeah.
But actually, you may well decide that there are others that are more appropriate. So just take those, come back to us with the ones that you would advise are the ones that we should be looking at. And in considering that question, evidently there are different magnitudes of change in the alternative proposed, the without prejudice one, and we'd very much like to focus on where things might change and where things might not in that presentation.
Thank you, Ms. Fernandez. There's just a few things that we just simply don't have time for today, but they're absolutely crucial. One is procedural routes. It's basically under 4D. A lot of those points have been covered, but I do want you to respond to 4D, number 4. And number 5 is a hearing action already, and it's a hearing action for DOI, DEFA, as well as for the applicant. Now, number 6, I would like you to take that away as a hearing action, and if at all possible, to be submitted as a hearing submission, so by Monday next week. But let's come back to those deadlines as well at the end of the day. About what the examining body would need to do in your reading of MEMA and the regulations and the provisions in there, and what Coleman would need to do in order to consider this alternative recommended MIC and its supporting documents. Yeah. So those are 4 things that we just simply don't have time to get into right now, but we would like that information as soon as possible. So when we come back after lunch,
Amy Sterling, on behalf of the applicant, if it assists, Madam, I'm more than happy to provide our written submissions on agenda item 4D in its entirety as a post-hearing submission on Monday. We have them already drafted. Entirely happy to do that.
That's extremely helpful. And hearing submission doesn't have to wait till Monday. So if you want to submit it sooner, do, because it could then inform potentially SIH 10. But I hope you've understood the nuance of how we'd like you to respond to agenda item 4D6. So it is what the examining body would need to do as well as what the Council of Ministers would need to do. Yeah? Okay, so let's do that. And then after we come back from lunch, it will just focus entirely on SLVIA. Of course, a lot of discussion will be around this change. At the risk of some grumbles, I am going to suggest that we come back in 43 minutes at 2 p.m. Yes? Okay, so the time now is 17 minutes past 1, and we're closing session 2 of SIH 8.
How's the accumulation going? Getting wider and wider and wider, as I'm sure you can imagine. Oh, well, thank you. It's always appreciated, you know. It's, how gorgeous it is. I know. We had a break earlier and he came back in here and it's just been I'd be inclined to go and find a shady spot outside if we could do that, because I think it is kind of a new little underpass. A wee hidey hole. If we find a wee hidey hole, something I think will be really nice. I'm sure well, I might be back later. It's not like we've taken a slag and at least Treasury's taken a slag and it's Treasury will come on Friday. Typical usual. Yeah. Still, so it's public. I know, you were here the last one talking around the corner and they never even noticed you were bringing it up. I'm coming out.
Is everyone ready? Yeah, okay. Okay, good afternoon, everyone. Sincere apologies for the late start, but I believe we've had some technical hurdles to overcome. Have we sorted that out? Is somebody from the applicant's team able to present? Okay, fantastic. Good. So the time now is 7 minutes past 2. Apologies again for the late start. We are starting with session 3. Just a few points before we open. One is that we are proposing a few changes to the agenda given how late we are. And we propose that we will defer item on socioeconomic effects to SIH 10. Is there anybody here who was here only to speak on socioeconomic effects?
And to be clear, that's item 8 currently in the agenda before us, but...
9, I think.
Sorry, 9. Yep,
Yeah.
and skills, yeah.
Yeah. Tourism we will still be able to cover today, but I think it is job and employment that we will move.
Yeah, apologies, yes, no. Although we will take a check on the tourism content there as well, because at the end of the day, I think our view is that it will be critically important that we fully complete the items prior. We can make space in SIH 10. So that's where we think we'll go at present.
Good. And then the second thing is a short extension or to the day, to the finish of the day. So rather than finishing at 5:30, we're proposing that we finish at 6 p.m. and appreciate that it's a hot day. It'll be very long, but we do need to check if that's okay with parties. Yeah? Okay, good. Third, one final point, just to remind everyone that under Section 27(4) of MEMA, the examining body can allocate parts of its consideration of the application to one or more members, which is basically split our responsibilities. So we will exercise that power in relation to today's hearing. Session 4, just given the breadth of the examination and the work that's required, we consider more effective use of the examining body's resources for the members to divide their responsibilities today. And as such, Ms. Pownell will leave after session 3. Of course, everything that happens at the hearing at session 4 will be reported back and will form part of the collective consideration of the application. Hopefully that's all understood. So with that, I will hand over to Ms. Fernandez. I will hand over to Ms. Fernandez.
Thank you very much. So what we're going to do this afternoon is firstly to look at the VR goggles, please. And in so doing, what we would like to have clarified is, as part of the pre-application consultation, the applicant, you produced, I think, 4.5-second videos showing the proposed development from 4 viewpoints on the island. And correct me if this is not your understanding. We understand that you've updated those to reflect the application proposal. And I'm looking at you, you're all nodding, so that's good. And what we would like to do is view the videos and then ask any questions that we may have arising from the images that we saw. Okay. So this is a bit of an interactive session. Not quite sure how you're going to do it, but no doubt you'll advise us.
Dr. Carroll, on behalf of the applicant, we have commissioned a local company called Isleman 360 to update the virtual reality headsets that were created as more of an immersive interactive tools for the statutory consultation in summer 24. At that time, the scheme was the full extent of the array and up to 100 turbines. and that's what we brought out to. And the 4 locations were Douglas, Ramsey, Laxey, and Mackle. They were the 4 that we made available through the consultation events. They were widely used, widely commented upon, and those have been updated with the application. So 87 turbines, the same turbine parameter specifications, and then at that point introducing the output from the developable area approach, which was to reduce the array slightly from what it was like post-scoping. So that's it. They've been regenerated for those locations. Just to clarify, I mean, it's virtual reality, so it's not true reality. It's a computer representation of what the maximum design scenario is. We struggled a little bit, when I say we, I mean in terms of getting the correct technical parameters for the turbines into the model and getting a real-world representation of the lighting, particularly at night time. And we couldn't put the lighting on selected turbines because not every turbine is lit at night time, but within the virtual reality headset, every turbine is lit at night time. We couldn't get the lighting to the correct dimming and candela value, so it's the virtual reality experience at night time is exaggerated, but it's still a realistic view of what the wind farm would look like at that time.
And just before you do that, Dr. Carolan, you mentioned that one of the viewpoints is Douglas. Is that Douglas as in Loch Promenade, or Douglas Head where in Douglas?
That's Douglas Loch Promenade.
Thank you, that's helpful. And just out of interest, did anyone here make use of the goggles over break and at lunchtime? Great, so I can see a few hands up. That's good to hear, thank you. Okay, so what's going to happen? Have you got 4 sets? Talk us through what we can expect in the next few minutes. Okay, so but you might need to be on a mic, on audio.
Dr. Keoghan, on behalf of the applicant, my able assistants. So yeah, if you put on the headset, it should be switched on. You will see in front of you, it should be blue. Should be blue, and in front of you, you should have a little Mooir Vannin info telling you what's there. Once you see that, if you could just move your head about, look around, left, right, up, down, find a little blue dot. Move the blue dot onto one of the locations on the map, be that Laxey, Ramsey. Keep the blue dot in the middle of the circle, and then the video will load and it will commence, and it'll play 4 15-second segments, one first thing in the morning, one at midday, one late afternoon, and one in the evening. If at any point you would like to return back to the map, if you look up above the wind farm, you'll see a little white circle which says return to map, and you can return back to the map and select another location by moving the little blue dot into the center of the white circle.
Well, I've done many things in a hearing, but that's the first time I've looked at VR goggles, and that was very helpful. Thank you. I just need to gather my wits now because I'm feeling quite hot. Yes, I said this morning, perhaps you weren't here, the applicant's here all day, and I'm sure they would really love you to look through them because it gives us a different impression of things in 3D, and I know that's certainly something that people have asked to see. Okay, so just a few questions, if I may. Why were those 4 locations chosen for the VR headset experience?
Dr. Keown, on behalf of the applicant, we selected, out of the 11 viewpoints, we selected 4 along the east coast because obviously they were the ones with the most sensitive views. And when we were doing our statutory consultation events, those were the locations closest to the statutory events. So we wanted to present something that was local and that people could relate to. So we wanted to give them viewpoints that were that they were familiar with. So to get a full, immersive experience of what the effect of the project would be.
Thank you. And if the XB was to consider that additional ones would be helpful, is that a job that can be done fairly swiftly?
It can be done, yeah, but we would like to understand for what purpose. It doesn't come cheaply. This experience cost in the region of £10,000 to create. So it would be roughly £10,000 again to make any updates and do alternative scenarios. So while we're happy to do that, we would like to be satisfied that it had a good purpose.
Amy Sterling on behalf of the applicant. I guess the point I would like to make is to understand what purpose within the MIC decision making the virtual reality headsets would be serving. That has always been my sort of concern, is that we have provided SLVIA information on a accepted and established EIA practice through the wire lines and visualizations. Dr. Carlin's already explained just some of the inherent difficulties with the virtual reality, particularly, for example, the candela lighting, and I would be concerned that weight would be placed on the virtual reality headsets when that was not their intended purpose.
Yes, and both of those points are understood. Thank you. Okay, thank you. And yes, again, I would just ask people, if you are in the room and you haven't had a look through them, please do avail yourself of today. Okay, so let's move on then. Yes, I can't quite see, but do come to the table, please.
Apologies. My name's Richard Taylor. I reside very close to Laxey Beach, and in fact about 40 yards, it appears, from where one of those VR headset things were done. I came over as a tourist. I know we're going into the tourist piece initially, almost 30 years ago, and very soon after that I decided to relocate to the Isle of Man. So I say I live on Laxey Beach, and I've recently been appointed or elected as one of the commissioners for GARF, which serves an awful lot of the region up the east coast, which is being impacted by this. From my front room and my bedrooms, I have an uninterrupted view of Laxey Bay all the way across the Cumbrian coast. In previous sessions, you've talked about how does this impact well-being for the individuals. Now, I used to drive home from Douglas, through Groudle, all the way down to Laxey, through Lonnon. Even after the toughest of days, making that drive back, being able to look out to sea, see Cumbria, impacted my mental health, my well-being significantly, and must have given an impact to my home life. There are hundreds of people who do that trip each day. They do it on the buses, they do it on the trams. Tourists come along and they want that electric train experience all the way along that coast, past Macclesfield, all the way up to Ramsey. It's significant for the Isle of Man, and people are going to stop coming over, I believe, off the back of it. Those images through the VR headsets, it shows literally one man and their dog on the beach each time. I know it's virtual reality. However, that beach, that front is very, very busy. It doesn't show the paddle boarders. Tourists who come over do that. It doesn't show the dolphins. It doesn't show the dolphins interacting with those paddle boarders. All of these things, this is an image that is being put forward that, whilst it's meant to be virtual reality, is not real. You saw yesterday at
Mr. Taylor, if I could just pause you there. So you will recall that when I had finished looking at the VR goggles, there was a conversation with the applicant about this is not evidence, and we take it in the light within which it was presented. And to that point, it is not evidence. It was something that we were interested to see, as indeed many of you had been afforded the opportunity. So what I would like to do now is to move on to the Landscape Enhancement Plan framework. Thank you.
Okay, thank you. Thank you for your time and for the whole process. Much appreciated.
Okay, so the next item is the Landscape Enhancement Plan framework. And for the purposes of today's discussion, I'm looking at document D4014 in the examination library. And what I would like to do is to ask the applicant to provide a short overview of what that document contains, and then I am going to ask DEFA if you would also provide your views on that document following the applicant's overview presentation, please. So if I may turn to the applicant first for an overview of what that is. And the context for this is that we asked a question, second written questions, I think, about landscape enhancement plans, and I think we drew the comparison to other DCO NSIP applications where such a thing had been provided. So if you could please explain a little bit about what that document contains. Thank you.
Dr. Kieran, on behalf of the applicant, in drafting the Landscape Enhancement Plan Framework document, we concluded a review of landscape enhancement comparative analysis of recent precedents of enhancement funding provided by other NSIPs in the UK, which sort of gives some context and a benchmark for how enhancements have been delivered on other projects. The Landscape Enhancement Plan framework sets out just the initial ideas and resources and summarises potential enhancement measures that could be applied. The spatial scope for the application of enhancement comprises two discrete areas which are not really mutually exclusive, and they are those parts of the AHLV and Groudle National Glen where residual landscape and visual impacts arise as a consequence of the construction activities at landfall, and then areas of the AHLV and the four candidate special landscapes that experience more long-term seascape, landscape and visual effects from the construction and operation of the offshore wind farm. Engagement is needed really with stakeholders on basically the spatial scope of the landscape enhancement plan, to ensure that the enhancements align with the aims of the relevant organisations and the landscape enhancement management strategies for the purposes of the designation, which is basically to preserve and enhance. And that consultation hasn't really begun extensively yet, but we have some comments back from DEFA. The key organisations that we had proposed to consult with are MNH, so Manx Natural Heritage, and DEFA. The potential for initial ideas in relation to landscape enhancement is quite exhaustive, actually. And we have just set out a few projects in there that would give an idea of the things that we could do. And we have focused our attention on potential enhancement for landscape character type A for the uplands, for candidate special landscape 3, Mackle de Lexie Coast, and for the UNESCO Biosphere Isle of Man Vision and Strategy. And they are set out in Table 1 of the document. Enhancement is likely to include peatland restoration for the uplands, and these type of measures have typically been considered enhancements on other NSIPs provided to address the planning purpose of designated landscapes. Section 1.3 provides a summary then of the potential enhancement plans, and they're mostly in relation to public access, enhancement of coastal access, recreational activities, enhancement of footpaths, tracks, greenways, and heritage features, and working with the UNESCO Biosphere, particularly in relation to youth projects and biosphere partnerships with schools and university to foster biosphere engagement. And that's the level of detail that has been put in the framework at present.
Amy Sterling on behalf of the applicant. If I may, though, sorry to jump in, Madam, an important clarification. The applicant has reviewed the position across DCO projects, which gave rise to this discussion. And I think there are approximately 3 which we're aware of that have put forward a landscape enhancement fund and 3 which haven't. And the Secretary of State's been quite clear in his decision making, in particular most recently in the North Falls offshore wind DCO decision, that a landscape enhancement fund isn't a necessary consequence of the duty to conserve and enhance, albeit that duty is not in Manx planning policy, so far as I'm aware. It's in the Countryside Rights of Way and Access Act within the UK. So the applicant's position is that it doesn't consider a fund to be justified for the purposes of this application, but nevertheless, noting I think the words were very strong, Steer, I think it was from the examining body at the previous hearings, the applicant is in the process of preparing a draft requirement and a draft plan to support that requirement through an update to the framework to set out more information on, funding, etc. Should the examining body or the Council of Ministers decide differently, the applicant's position will remain that a payment of a sum of money for enhancement for landscape and visual isn't required by law or policy and not something that is seeking to advance in its own case.
Yes, and I'm going to come back to that a bit later. And I wonder, and Defa, whilst I have asked you if you would set out your views, I'm going to actually just change my thought process ever so slightly. And what I would like to do next is go to the wire lines, which look at this scheme that, the scheme 2, so not the application, but the scheme the reduced scheme that we were looking at just before lunch. Because I think let's have that together. And then, Defa, I'd like to ask for your response to the Landscape Enhancement Management Plan. And Ms Sterling, remind me to come back to the point you've just made. It's quite an important one and I don't want to lose it.
Linda Thompson for the applicant. We're going to be reviewing a number of documents. This deadline 6 is the critique of the indicative alternative layout visualisations and wirelines. There are 3 parts to that document with wirelines within them. I'll give you the references. D6, 011, 12 and 13 contain the visualisations. So I think we're going to bring those up, please. Can we move on to the visualizations, please? Okay, so you'll have to zoom out. So we're starting here at Point of Ayr, which is the viewpoint 1, which is a very wide panoramic view. It's taken from the coast to the east of the lighthouse, where there is a small parking area with public access taking you slightly further south. So the lighthouse in that view for orientation is to the left of that open view. So if you can move on, please. So this shows a 90-degree field of view. The visualizations shouldn't really be viewed on screen. For the purpose of assessment, they should be printed and taken out, and I'm hoping that the examiners have done that in their visits to these viewpoints. They are importantly viewed at the right scale. So this is a 90-degree view towards the proposed development. As a wireline, it shows cumulative development as well, and the headland gives a comparative scale there. If you can go down, please. So this then shows the 53.5 degree field of view. The wireline clearly shows the visual extent of the field of view that would be affected by the turbines. That is reduced, if you let me look at my notes. So there's a marginal increase in the distance from the point of air, but the lateral spread has reduced by 8.4 degrees, and the visibility...
Audio seems to have disappeared slightly, thank you.
So we have reassessed the magnitude of change at that location, given that the distance has gone from a high magnitude of change to a medium-high magnitude, but remains as a major significant effect in the assessment. Do you wish to go through each viewpoint in a similar way? Or
what I would like is to focus on ones where there is a difference in the magnitude change, the sort of greatest distance, and also ones where there is little change between.
Okay, so if you could go to part 3 of the, which is D6013, please. Okay, so we're looking for viewpoints 10 and 11, if you can zoom in, please.
So you're going down to St Michael's Isle. So basically you've gone from the top right down to the bottom of the eastern coastline, down to St Michael's Isle, and then after that, where were you thinking of showing us?
Onto viewpoint 10.
Viewpoint 10 being Marine Drive, Little Ness.
Sorry, no. Viewpoint 11, South Burial.
South
so
Burial.
The 2 south viewpoints.
Okay, so let's look at St Michael's Isle.
Changes.
So this is a change from medium to medium-low.
Yeah. At this point, we are now increased the distance by 4.3 and 4.4 kilometres respectively between those 2 viewpoints. We've reduced the lateral spread, and we've increased the distance to an extent that it takes it to 33 and 35 kilometres respectively across those two viewpoints. So still taking account of the high sensitivity to change at those locations, the medium to low magnitude of change at that range reduces the effects to not significant.
And that was viewpoint 10, and then you're proposing to go to South Burial, viewpoint 11?
Yeah, to viewpoint 11. So there, the distance is increased to 35 kilometres, which is 4.4 kilometres more distant, and a reduction in the magnitude of change to medium to low, resulting in a moderate, not significant effect.
Excuse me, it's really difficult to hear.
Sorry.
Just worried that I can't hear here, so.
Shall I repeat that?
Yes. Thank you.
Okay. So for this one?
Now we're at viewpoint 11. If you could just, again, just when you're speaking, if you put your voice into the microphone, it just helps others.
Increase the volume. So the increases in distance has taken the distance of the array area to 35 kilometres at this location, reducing the magnitude of change to medium to low, and a resultant level of effect to moderate that is then considered to be a not significant effect. That takes account of the high sensitivity at that location.
And then, please, can we go to the viewpoints where the magnitude of change has not altered? And I'm thinking particularly in relation to viewpoint 3 and, yeah, let's start there, please.
Okay, so we need to go to document D11 for viewpoint 3, please. Sorry, I can't read that at this distance. Is that us now at viewpoint 3? Okay, thank you. So this visualization, can we zoom out, please, so we can see? At Maggold Head, there is a wide panoramic view, but because of the width of the wind farm in this view, it is spanning across two different 53.5 degree field of view images there. So you need to understand that the top one is linking on to the bottom one, and that's the part of the array area that would be visible with wide expansive sea that would be unchanged in that view, which is extensively panoramic. But we have retained an impact significance, a magnitude of change that's high at that location, and retained a major significant effect. The distance has increased from the application. It is 3 kilometres more distant, with the lateral spread being 3.1 degrees narrower. So there is a reduction, but it isn't sufficient to change the threshold or the level of magnitude of change.
And the other viewpoint that has not changed, viewpoint 2.
Yep, so further back, please. So this is at Ramsey. So at this location, we are 3.2 kilometres more distant. We have a 20.9 narrower lateral spread, and that's 20.9 degrees narrower, but we are anticipating that the magnitude of change there would be retained at medium to high, but given the high sensitivity of the receptors at Ramsey, that retains then a major significant effect.
Thank you for showing us those wire lines. And is there a document that you can signpost us to where we can compare side by side the application wire lines and these? And if not, would you be able to draw them into one document? It's quite difficult to retain one and then look at the other without them being side by side.
Yes, I understand. I'm assuming that would be possible. I'm assuming that would be possible at Deadline South.
Amy Sterling, on behalf of the applicant, I'm advised that it's D4019 comparative wire lines.
No, we don't.
But okay. Yeah.
So that would have to be a D6 something or other.
Thank you.
Yeah, so no, we don't, but it could be done for Deadline 7.
Certainly, I would find that helpful to do so. And as it's not necessarily producing new wire lines, is that something you could do fairly swiftly? I know there'd be a lot of interest in those.
Dr. Kieran, on behalf of the applicant, for the wire lines that have been submitted into examination already, that information already exists. You just have to toggle between one wire frame and the other. So in the first wireframes that we submitted in with the thought experiment, the upper screen is the wireframe for the application, and then the lower one is the alternative. So you just got to flick between the two of them, so the information is there. It's my understanding that you actually wanted like two overlays so you could see together that, or do you just want the two?
Well, ideally the second, where you can actually overlay one on the other.
To see the difference?
Yeah.
Okay, so if that was something we would have to take away and do additional work on. We could possibly do that for deadline 7. Yeah.
But actually, it's also helpful to, yes, just
so the one that you flick between is already in examination.
Okay.
Yeah, as part of the thought experiment, so you can just go down between, you can scroll between them. But then the creation of the additional wireframes that are overlaid in each other so that you can visually see which ones then we could prepare that,
That would be helpful. Thank you.
Linda Thompson for the applicant. Can I just clarify that it's just wireline comparisons you want and not photomontages?
It's both, in fact. I'm just not... yes, if you can do both, then it should be both.
To overlay photomontages?
It's quite tricky, I think. That's why I'm puzzling over whether it's even possible, but certainly the wire lines. The point of the question is, if we are looking at a difference between an application document and the alternative stage 2, then whatever we can see to show that difference would be beneficial to the examining body.
Okay, we'll do that in wirelines then.
And Ms. Thompson, so this was really an opportunity to explain what the differences were in SLVIA terms between the application document and the alternative, given that it only came in at deadline 6 and 5, but mainly deadline 6. Is there anything else you would like to draw our attention to as we understand our way round what is now included in the without prejudice alternative?
So within the thought experiment SLV assessment, we have also included a zone of theoretical visibility. Of relevance to that is the reduction in the array and the reduction in the turbine height will have some degree of change to the zone of theoretical visibility. There is obviously some areas of coast that are very close, but the ZTV, as the bare ground ZTV is, in my opinion, quite markedly limited across the island by landform, and that's further limited in the north in particular and within settlement by the above ground features of the built form and the landscape features of vegetation, so that where the reduced height and extent of the visibility might not be massively different geographically, the extent to which the turbines are visible in places above those features will be reduced. There are some places that we have found to be further degrees of magnitude of change across the island, but that we haven't gone into in great detail, but we've looked at the extremes, and to note that in the south, that reduction in significant effect of those representative receptors does mean that there would be a reduction across the whole of the south of the island.
And can you just show us on the screen the zone of theoretical visibility, just so that we can see what it is under the alternative without prejudice stage 2, please?
Can we turn to D6006, Appendix 2, please? Appendix C. Can you move up to the ZTV, please? Keep going to the next one. It's most helpful, I'd say, with the viewpoint locations. So in the north is where I was describing that the theoretical extent of visibility would be further reduced by the above ground features, and that would also apply within the settlements where built form would reduce that theoretical visibility further.
It's quite difficult to see what you're talking about here. Just to explain in longhand what we were seeing and what we would be seeing now if we had the two side by side.
We would see a slight difference in the geographical extents of the visibility. The visibility bands also represent smaller numbers of turbines at each level because the number of turbines is reduced. The height and the vertical extent of the turbines that may be visible above ground features would also be reduced because of the tip height and the further distance. So particularly in the north of the island where there is where it's relatively flat and it shows there to be widespread theoretical visibility, what I'm suggesting is that the actual visibility would be reduced by the vegetation that is present within that landscape, particularly from the routes that people travel through once you've got away from the coast there, because there is a lot of vegetation along the routes.
Okay, thank you. That's helpful. And again, I'm assuming that the before and after is in the same document that you referred to, which number I didn't write down in. I know you haven't done the wire lines before and after.
Dr. Kieran, in relation to the wire lines, my colleague can just show up on screen the wire lines from page 8 of part 2 of the thought experiment, which will show, I think, what you want. So this is the view from SNEFL, and if we can scroll down just to get the two wire lines on the same image. So the image, I think you need to zoom out.
Apologies, bear with us, we just need to change the document.
After is the before and after zone and theoretical visibility. Yep.
Dr. Kieran, on behalf of the applicant, it's not the zone of theoretical visibility. I just want to show you the before and after wire lines for just one to see, does it satisfy you that what we have already produced is sufficient for the purpose? Yeah.
Yes, but then let's not lose a ZTV point as well.
Okay, yeah. So on this image, on the top image, you have the wire lines for the project and application, and you can see the extent of the project with the red turbines. And on the lower wireframes, you can see the extent of the indicative alternative scheme. So you can see the reduction in lateral spread and the significant shift offshore. So you can see that it now no longer goes down as far south as the existing offshore wind farms, the Walney Wads projects. You can see the green projects, which are the Morgan Mona. So they're all the other REC projects. So you can see the quantitative scale of change within the wireframes, and they're already in the thought experiment in part 1 and part 2. So I don't know, is that sufficient?
That is what I was after, yes. Yeah. And does that also reduce the blade tip height? But I think actually from what you were saying earlier this morning, whether or not it does, it would not make any great difference in terms of a wireframe.
Dr. Kieran, on behalf of the applicant, these are at 330. So these ones were done on any change at that type is not discernible to the human eye at that distance.
Okay, thank you. And then to the ZTV's zone of theoretical visibility point, please.
We haven't prepared an overlay analysis of the difference in the ZTV, but we can do that.
So that would be helpful, thank you. Okay, and our ambition for that would be that we could have that as a post-hearing note early next week, Monday, I believe.
Linda Thompson for the applicant. Yes, we can do that for Monday.
Thank you. And Ms. Thompson, anything else that you would wish to draw our attention to in the stage 2 without prejudice alternative?
Linda Thompson for the applicant. I think one of the earliest suggestions was to try and increase the distance of the array area as far as possible to beyond 20 kilometres. So that has been achieved north of Ramsey and south, just to the north of Douglas, so from north of Douglas southwards.
Okay, that's been helpful to understand. Nonetheless, even with all of those changes, the overall conclusion remains that it is still adverse significant effects.
Yeah, except for in the south of the island where the effects wouldn't be adverse or significant. Well, they would be adverse but not significant.
But the overall conclusion when one takes it into the round is still adverse significant effects.
I don't think overall conclusions in SLVA are something that we draw on.
So you would say that these different viewpoints remain different and you would take them as individual locations?
Yes.
Understood. Thank you.
Dr. Kieran, on behalf of the applicant, just in relation to likely significant effects remaining, I mean, as part of the sensitivity analysis for the thought experiment, we looked at this, and there is no scheme that can remove likely significant effects due to the location of the wind farm, its proximity to shore, and the size of turbines. Even a turbine that was 100 metres that was offshore now and it was in a less number would still result in likely significant effects, probably in a major, up in the major, so it's not possible for us to design that out.
Yes, we understand that. On this scheme, I'm looking at this scheme, it depends on obviously the scheme that's before us, but on this proposed development, that is the case. If we were looking at other proposed developments where the array was a long way from shore, it would be a different case. So bearing in mind that we're only talking about today's proposed development and not something else. Okay, thank you very much, Ms. Thompson, for that. And then can I track back now to where I was slightly before? And there's one question. Yes, the gentleman at the back, if you would please come forward.
Kim Morton, my name. I was just wondering whether there's any better montage than has been produced, because long years ago, another company...
Is your microphone turned on, sir?
Hello? Long years ago, another company was very keen on a similar wind farm development, but they very kindly produced a photo montage of just how high these turbines were from Maccled High Road. And they superimposed it, and there was the Chief Minister's house, Mr. Karush's house. The photo montage showed that these wind turbines were higher than his house. Can you give us some actual dimensions, please, about the height, the weight of the cement that you use for the base of these towers? Is it, in fact, Are they as higher than the Eiffel Tower, these wind turbines?
And so we were discussing the height of turbines this morning and the proposed changes between the application document and the stage 2 document. And I would refer you to D6006, which is an examination library document. And if you look in there, Table 1 provides a comparison of the different heights and dimensions of the proposal and the application proposal. And that does include details about the height, for example. And the application document is 330 metres. The application document is 350, reduced to 330, but all the details are in there in the examination library. And one other hand, and then I'm going to move on to the landscape enhancement management plan. And if the roving mic will find you, thank you.
Thank you.
And just on that point, there is a visual in the ES which does, I think, show comparisons with, for example, the Eiffel Tower, and perhaps the applicant could have a look for that, because I do remember seeing something, and I think that would be helpful to find the reference for.
Dr. Carolyn, on behalf of the applicant, I'm merely speculating based on what I've heard. Any previous offshore wind farm developer on the Isle of Man would have been Dong Energy, so that was Ørsted before we changed our name. So I'm not aware, and again, it depends on where you are and how you view something, whether it's bigger than the house. I mean, I don't know how big of a house he lives in, but a 300-metre turbine is going to appear bigger than all houses, so it depends. I'm not sure. If there's anything that we have produced as Dong Energy in relation to the first Isle of Man offshore wind farm consultation events or SLVIA, I can have a look internally and see if we have something like that, and I can make it available. In relation to the Eiffel Tower, I don't know how tall the Eiffel Tower is. I only know that our turbines have been reduced from 350 down to 320.
So there is a visual in the summary, I believe, of the ES, which perhaps if somebody from the applicant's team would have a look and then provide a reference for that. Sorry, and to the lady that was up the front, thank you.
We've covered lots of time. Okay, sorry. It's been covered quite extensively and comprehensively in these sessions and in feedback and wherever about the importance of the visual impact and how it's going to look. And so I'm not going to go into that now. But in the context of that and the frustrations that are around that, I think it would be really helpful if the VR images in still form were made available. If not, the VR headsets themselves could be made available at the Commissioner's offices or the courthouse in Ramsey or blah, 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 it doesn't matter where. But that would be so helpful because we can't look at those the VR images online and there isn't a 3D model available. So it wouldn't take much effort, time or money to put up still images of different perspectives around the island at different places around the island. So you could be in Mackle Head and see what it's going to look like from Mackle Head. And I think that's a really quick fix and would be informative and, you know, in the absence of a proper consultation, we could now have people informed in the way they should have been. I don't really understand why that hasn't happened, but I think it would be really helpful to the residents to have those images available.
And I think it was Miss Cook, if I'm right. Yeah. So that's because we cannot take the VR goggles and the 3D as part of our evidence. That's not something we would direct. Nonetheless, the applicant is in the room with you, and I would suggest that that's a conversation that you have out with the auspices of this formal part of the examination.
Yeah, I did earlier. I said there's a good suggestion, and they thought it would cost a lot and it'd be difficult to maintain. And that's why I think that, and it's a shame because they're not on a break-even project here, profit-wise. So there is, you know, money available for that. And I think it would be really appreciated by the residents. I don't want to speak on other people, but I know that there is a frustration about the lack
of visibility of the visual impact, definitely.
Yeah.
And it won't cost much to put up posters with turbines in instead of without them, which is what's been going on, and to put up still images of the VR images.
Yeah, that point is made, and I think you've made that point a few times, but it's just worth emphasizing again, and perhaps for the final time now, that this is not something that the examining body can request from the applicant, because it does not form part of evidence that we can take into account in our consideration. What we can take into account is the environmental information that's been put before us, which includes the SLVIA wireframes. It's also just worth stating that we're not in consultation at the moment. This is an examination. So while you are free to engage with the examination, there's a distinction between a consultation process and an examination process. So a lot of what you're saying, it falls within consultation. Now, the lack of that consultation, we've had a lot of evidence about that in examination, and that, we assure you, is a matter that will be taken into account when we write our recommendation report. But this examination process cannot make up for what was lacking or not lacking in the consultation process.
Okay,
Thank you.
understood. Thank you.
Dr. Carroll, on behalf of the applicant, if I may, on the Mooir Vannin website, we have on there, and it's been on there since 2023. It was updated in 2024. So all of the VR headset, the videos, so obviously not the VR headset because we can't put it online, but the videos that you've seen have been available in our town hall. So all our consultation materials that we brought out to the public through our statutory consultation remain online. It remains an interactive forum in which everybody can go in and they can view. So you can go and see all materials that we provide for preliminary environmental information. You can see the VR headset, all of the videos. You can see Seascape landscape.
Dr. Carolan, thank you.
Yeah.
So I think that what I'm taking away from that is the applicant team, please talk to the, and I've just lost your name, apologies, Ms. Cook, and any others, and just please signpost them, because I think we are hearing just a concern for more information, and if it is there, then signposting people will of course be helpful, won't it?
Amy Sterling on behalf of the applicant, if I may, just to touch on a point that was just made there. Madam Chair, are you suggesting the applicant's approach to pre-application consultation will be a factor that you weigh in the planning balance as to whether or not consent should be granted? I would suggest that the pre-application
Ms. Sterling, it's probably best not to make an assumption on that. All I said, it is a matter that is under consideration. It's something we will take into account. Whether it's a matter that's taken into planning balance or not is not something that we're still in examinations, not a matter for us to comment
Sterling,
on.
on behalf of the applicant, I do think it's important to clarify your intention either now or in written through your written submissions, because I think that is something we'd want to provide commentary on if it was suggested that the pre-application consultation in some way affected the MIC application decision, because I would contest that.
The point is that is definitely going to be taken into account, or is in our consideration, is the comments that we hear from the floor at all of our public meetings, and indeed at specific issue hearings, and the concerns that parties have raised about the information that is available to them, and that is something that we will comment on. What that consideration is, we don't know yet, because we are still in examination. And should you wish to provide a commentary on that, there is nothing that stops you from doing that. But no, we will not be issuing a written question asking for your commentary.
Amy Sterling, on behalf of the applicant, noted, Madam, we will provide commentary on whether that's an appropriate thing to consider within your decision and recommendation. Thank you.
Okay, so let's return back, it seems a little while ago now, to the Landscape Enhancement Plan Framework. And so where we are now in proceedings is that we have had an overview from the applicant about what was proposed in that framework document. And then I had asked you to show the wirelines, what's in the alternative stage 2 proposal. But now I'd like to invite the Department of Environment, Food and Agriculture to provide a response, which is in the examination library at D5019. But just before I do, I noticed the applicant responded to your response in quite brief terms. Has there been any subsequent conversations since deadline 6 between yourselves, DEFA, and the applicant? Mr. Milne.
Ken Milne, representing DEFA. With regard to your latter point there about deadline 6, the only discussions we've had is statement of common ground, which are ongoing. If I go,
and so not about the specificity as such of the landscape enhancement plan, enhancement plan?
No, it's too early for us. And if I may be...
Yes, press on.
Obviously, DEFA welcomes the landscape enhancement plan framework as a constructive initial framework. And I'm going to pass over to Mr. Brown online to give more detailed comments on that. That's okay.
Good afternoon. It's Oliver Brown. I'm a chartered landscape architect representing DEFA. I'll just provide, as per the agenda item, just a quick summary in terms of the position. Obviously, this is a constructive starting point, but as identified earlier by the applicant, this is it's an early framework rather than a defined enhancement plan. Similarly, at the previous deadline, we provided more detailed information in response to this matter and our position. From a landscape and visual perspective, I think the key issue really is that certainty. The document, obviously, at this stage, being very early, doesn't explain clearly what projects will be delivered, how they'll be selected and prioritised, how they'll be funded and governed, who will deliver a management or manage them, or how they'll be secured. The comparators that were usefully provided as well at previous deadline, they appear to largely rely on Section 106 type mechanisms, and I think looking at this, if it goes ahead, it would need an appropriate Isle of Man mechanism. I mean, obviously, I'll leave that to my planning and legal colleagues because that's somewhat out of my ability. But I think we want to ensure that the enhancement package is sufficiently certain and it's deliverable and enforceable. And also want to stress that the enhancement, it can't really be treated as direct mitigation. Talked a lot previously about the scale of the scheme and identifying those residual significant SLVIA effects, and mitigation of those effects is not possible in this context, and we understand that, but it's important to not treat any enhancement as direct mitigation or full compensation for that. So in summary, we obviously support continued development of any LEP framework with relevant stakeholders. But until that can be secured, I think it's going to have limited weight really, and looking at those securing mechanisms and once they've been established.
Yes, thank you, Mr. Brown. That's helpful, and I recognise that a lot of the points DEFA has raised in that response will be best dealt with through discussions between the applicant and DEFA outside of this hearing. There's a lot of progress to be made, and certainly it did seem like it was an initial framework, and quite a lot of progress needs to happen to turn it into something accepting that it's without prejudice. And the point you raised earlier, Ms. Sterling, that would be something that we would want to see before the close of the examination. So I have a series of questions to DEFA, and I'm assuming I'll direct them to you, Mr. Brown. So you might want to stay on camera. About the framework, I'll call it the framework for now. And then I will be following up with detailed written questions. So Mr. Brown, I'm leaving you on camera just because it's helpful not to stare at a blank screen. So I may not be specifically asking you a question, but it just is helpful to feel like you're in the room and not having a cup of tea somewhere else. So if there's no legal duty to enhance through this framework, how would the applicant propose to provide enhancements?
Amy Sterling, on behalf of the applicant, I mean, we would wholly agree that it doesn't meet any aspect of the mitigation hierarchy. It does not avoid likely significant effects, it does not mitigate likely significant effects, and it does not compensate for likely significant effects. It is a pure enhancement, and in our view wouldn't really serve any planning purpose in the mitigation hierarchy for EIA. Therefore, that is the primary reason that the applicant is not putting it forward as something which it is seeking to including within its draft MIC. The applicant also wholly agrees that given it would not avoid, mitigate or compensate the likely significant residual effects, the weight to be attached to those likely significant effects remains unchanged by the provision of any landscape enhancement fund, and a landscape enhancement fund should not weigh in the planning balance because it is sort of almost irrelevant for planning purposes in our view. Nevertheless, the applicant is obviously aware of the submissions from the examining body and DEFA, so has proposed a landscape enhancement framework. Apologies for my terminology, I think I missed one letter in there. The applicant is reviewing and updating this document to include, on a without prejudice basis, a series of principles. Possibly we expect to be aligned with the landscape enhancement scheme principles in terms of at least format, which was secured via the MONA DCO application, which sets out some principles around the spatial scope, fund timings, mechanism for delivery, payment profiles, etc. That work is ongoing. That would be included, and in the applicant's view, could, if the examining body and Council of Ministers considered it met the tests for a planning condition, would be included could be included via an MIC requirement. The applicant doesn't consider a Section 106 agreement to be necessary because Section 37.4 and paragraph 14 of Schedule 1 of MEMA provides that an MIC may include provision for or relating to the payment of contributions. So the applicant suggests that the existing framework already would provide for such a fund if deemed necessary via requirement. The applicant would, however, note there is an equivalent of Section 106 in the Isle of Man under Section 13 of the Town and Country Planning Act 1999, but the applicant wouldn't consider it necessary to bring in to engage an entirely separate process.
So that was my next question: is Article 13, am I right in my interpretation that Article 13 would be similar to Section 106, accepting what you've just said?
Amy Sterling, on behalf of the applicant, sorry, can you clarify Article 13, what are you referring to?
Section 13 of the TCPA, 1999.
Section 13 of TCPA relates to planning obligations affecting land, yes. As mentioned, the applicant considers that to be unnecessary. It is noted in some of the other schemes, I think particularly Mona, whilst it was referred to as Section 106 being progressed, I don't believe that was in place at the time the DCO was consented, and the DCO is subject to a requirement which secures the landscape enhancement plan principles as we're intending to do.
So, what weight then should the examining body give, in your view, in the planning balance, in any enhancements, if what you're saying you're not required to provide them for the reasons you've set out?
Amy Sterling, on behalf of the applicant, I would suggest that a landscape enhancement fund should attract no weight in the planning balance. It's not for a planning purpose. It doesn't mitigate or avoid, mitigate or compensate. And instead, the planning balance should still be weighed against the residual adverse effects from landscape and visual, which the fund would go in no way to mitigate. Thank you.
Ms. Sterling, can you just try again, and let's just see if the volume of your microphone needs to be adjusted again.
Yes, of course, apologies. Is that better? The applicant considers that no weight should be placed on a landscape enhancement fund in the planning balance because it would not avoid, mitigate or compensate any residual likely significant effects, and instead the planning balance should weigh those existing significant adverse effects in the planning balance and not attribute any weight to the fund.
May I turn to DEFA, whether it's yourself, Mr. Milne, or Mr. Brown, just to any comments on that, please?
Sorry.
Yeah, I'll just pass it. Ken Milne, representing DEFA. I'll pass over to my colleague, Ms Morgan.
Abigail Morgan, DEFA Planning. So I work on the terrestrial side of planning. The Section 13 is a legal agreement relating to development, which in this instance probably wouldn't be applicable because it is terrestrial.
Sorry, could you speak a bit closer to your
You have to be quite close.
Thank you.
I'm trying to read my screen as well. In terms of the policies that we apply, which we've previously submitted information on in relation to Environment Policy 4, which we touched on earlier, it does talk about reduce, mitigate, and there is some element for compensation if there is any effects that could be compensated for. So in some ways I would agree with what Ms Sterling has said in relation to the landscape environment plan, framework plan, in the context of MEMA, and whether or not it would be weighed in the planning balance at all.
Thank you. Mr. Milne, any comments on that?
Ken Milne, representing DEFA. Nothing else to add, thank you.
Okay, thank you. So moving on, and bearing in mind that I said that quite a lot of the progress on this would be made, I think, through conversation with you both, as opposed to a lot of progress we can make in the room today. So in paragraph, in the framework, you advise that enhancement is likely to include measures that do provide a degree of compensation. And I'm thinking about paragraph 1.1.1.3. For example, peatland restoration management for recreation. And you advise this has been accepted as enhancement rather than compensation on other NSIPs. Can you provide details of what NSIPs? Because once you refer to those, they are not actually listed in the framework. And what was the status of the landscape that was being enhanced?
Dr. Carroll, on behalf of the applicant, I need to go back and review where that came from, but just off the top of my mind, I think it was in relation to Snowdonia National Park. So it was basically in relation to our Wally Mooir, and specifically enhancement measures for enhancing upland peats within Snowdonia and in close proximity basically to the development. But I can confirm that in writing as soon as possible.
Yes, that'd be helpful, thank you. And just turning back to DEFA for a moment, and some of my questions may not be directed at the applicant, but maybe also at DEFA. With regards to the potential for enhancement, what is the policy position for landscape protection in the Isle of Man designated landscapes? Is it the same as requirement to conserve and enhance? Is it the same basis as other places?
Abigail Morgan, DEFA Planning. So we would refer back to Environment Policy 4, and that sets out the hierarchical principles there in the strategic plan.
Great, thank you. Okay, just looking through my notes here slightly. So then, turning to the applicant, in paragraphs 2.8 and 2.9 of DEFA's D5 response, DEFA advocate that candidate special landscape designation should not be used as the sole criterion for eligibility within the framework. How would you respond to this?
Dr. Carroll, on behalf of the applicant, we have included the candidate special landscapes in there, but it's just within a framework. So that's just our first reading, our first understanding, and our first offering. If in consultation it's felt that they're not appropriate, then they can be removed. As Ms Sterling alluded to, she had reviewed the MONA principles document. So we are hoping to update that principles. So the principles that we have sat down in draft format at the minute, which will be incorporated into any update we will consult, is on the fund timing, the fund size, the project scope, the spatial scope, and the establishment of the steering committee and who's members of that. So that project and spatial scope would be determined in consultation with DEFA and Manx Natural Heritage.
And perhaps is where I might invite, if I may, DEFA and possibly Mr. Brown. One of the aims we would hope of such a proposed framework would be that it responds, I think this is actually in DEFA's submission, that it responds to the affected landscape and seascape as a whole, rather than just using CSL status as eligibility criteria. Mr. Brown, or possibly somebody from DEFA, is there anything else you want to add to that?
Yeah, I can come in, Oliver Brown, DEFA. Yeah, I'd agree with that. I think without a detailed response yet, it's about not limiting it only to those areas now within the CSLs. I think it's looking at holistically at that landscape and yeah, the focus on those directly affected landscapes.
And if I can summarise your position, Ms. Sterling.
Amy Sterling on behalf of the applicant. I'm conscious the applicant has started preparing this principles document and we do have some time for deadline 7. The applicant happy to engage with DEFA in the drafting of those principles to include within its deadline submission, which would obviously cover which landscapes are what the fund's intending to address essentially. Apologies, and also Manx National Heritage.
Yes, okay. So I have many more questions, but it just does strike me that you need to talk together to make progress. And mindful of today, I'm going to jump a bit further forward in the agenda of... Just bear with me. Okay. I think the two things I'd like to focus on, and then we will move on, is stakeholders and timelines. I think this is the nub of it. So while I think appropriately you need to talk amongst yourselves and you need to do it with some earnestness, there is reference to stakeholders. So clearly DEFA and the applicant, you are talking to each other. There's been no response from Cabinet Office. Who else are the stakeholders that you have been in contact with and in the development of the framework? And who else, this question to the applicant, do you think should be involved in the development of the framework?
Hey, Dr. Keogh, on behalf of the applicant, we had suggested DEFA and Manx National Heritage being the two stakeholders that are part of the steering committee.
And anybody else in? No?
No one else, no.
And DEFA and Cabinet Office?
Diane Brown on behalf of Cabinet Office. Excuse me, Cabinet Office Planning Policy hasn't been involved in the steering meetings throughout, but have become more involved throughout this examination. Given that we've been involved in the candidates' special landscape work and the landscape character work, if we can support those, any meeting alongside MNH and DEFA, then we'd welcome to be part of that. Thank you.
Thank you, Ms. Brown. And to your colleagues in DEFA?
Ken Milne representing DEFA. Yeah, we'd obviously welcome that engagement, and we acknowledge that Cabo should be involved, and perhaps DOI as well, because they own a lot of the greenways, etc. Yeah.
Just before you come back, Ms. Sterling, thank you. Have you finished? You still look like you're talking.
Ken Milne from representing DEFA, and there are probably a few other stakeholders as well, but they're the principal ones from government.
Ms. Sterling.
Amy Sterling on behalf of the applicant. I'm just conscious I don't want to conflate two things. There's consultation, engagement to use the proper term, engagement with parties in identifying the principles to go in the management plan, which could be secured via requirement, and then who's actually on the steering committee to administer the fund. Those are two separate things, and I don't think the parties are necessarily the same. For example, the Department of Infrastructure, perhaps yes, we could engage on the principles to go in the document, although they are ultimately the discharging authority for the requirement if it were to be imposed. So we just have to think about their role in the process and whether they could or would want to be on a steering committee, which then administers a fund, which ultimately they will approve via requirement. So I do think we just need to give some thought to that and make it clear that we're talking about potentially two different things here.
Yes, that seems like a reasonable question. Let me turn now to DOI.
Yeah, Robert Garden on behalf of Department of Infrastructure. I think the key role for the department in relation to this scheme is that a number of the accesses fall within its remit in terms of management. So I think the role is certainly involvement in the principles, and establishing them is critical, and probably in terms of delivery as well, given the control on the public rights of way, for example, as one of the potential measures identified in terms of public access improvement.
Thank you. And so timelines. So let me track back. Ms. Sterling, you were referring to, and I don't recall, section something, where you explained that there was provision within MEMA to potentially look at something that had funding attached to it. If you'd remind me of what that was, and then I would ask DOI if they have any views on that, but I can't recall exactly the reference.
Amy Sterling on behalf of the applicant. Of course, section 37(4) of MEMA, read alongside Schedule 1 of MEMA, sets out provision that may be included in a marine infrastructure consent. And paragraph 14 of Schedule 1 states that provision may be included within a marine infrastructure consent, if you read the heading, which relates to the payment of contributions. So therefore, the applicant considers that a requirement within a marine infrastructure consent could secure the payment of a contribution via the management, via the fund, via requirement, without recourse to a separate process under the Town and Country Planning Act.
Mr. Garden for DOI.
Yeah, Robert Garden on behalf of Department of Infrastructure. That's how we would prefer to see this dealt with, rather than, as you say, a separate agreement under Section 13 of the Town and Country Planning Act. I think Section 37 of MEMA does allow for the payment of a contribution. It's consistent with what's been done on DCOs in relation to similar funds historically, and certainly I think that would be our preference as to how this is secured in the draft MIC, if it is to be secured.
Okay, thank you. And then maybe this takes away this question in my mind, but we are running fast during examination, and if this, to give you the parallel, if this was a Section 106 agreement for the examining body to accord it weight, it would need to be signed before the close of the examination. I'm conscious that we're looking at quite an early stage framework. I understand the intention, and I know that you will all work hard to bring it to a fuller state, but in terms of our consideration of it, the fuller it is, the more weight we would be able to give it in our consideration of the application. So how are we going to get from today to that final thing, the final framework, where there is a good degree of agreement about what is quite a, I mean, the DEFRA response, as an aside, is really detailed, and actually I think the XP found it incredibly helpful in terms of some of the feedback. But if we were hypothetically to address the points that are in DEFRA's response at deadline 5, there's a lot of work to be doing there. So, Ms. Sterling, probably a question for you. How are we going to land this before the close of examination, where we've had a chance to see a fuller framework, others have had an opportunity to comment on it, and the XB's had a chance to think about it too?
Amy Sterling, on behalf of the applicant, we obviously work within the examination timetable that we have. The applicant's intention would be to put forward that without prejudice requirement at deadline 7, and also to put forward the updated framework plan, whatever we call it, with those principles at deadline 7. That would leave ideally in a form which has been discussed and agreed in an ideal world, or certainly it will have been discussed at deadline 7. That allows parties to remaining deadlines to provide their comments. Of course, just to reiterate, the applicant's position is that no weight should be placed on the fund. So it's, but we will seek to progress it as fulsomely as I can, noting the without prejudice position.
Yeah, and very much in the mindset that by deadline 7, because we heard a bit earlier today that because of the fast turning pace of deadline 4, 5, 6, others hadn't necessarily seen what was coming forward from the applicant. But in what you've just said, my understanding would be that you have all had several conversations, so there wouldn't be a surprise. It would be the base, that submission at deadline 7 would be on the basis of quite a lot of thought and conversation with the different departments represented here, and also Manx M&H.
Amy Sterling on behalf of the applicant. Yes, that's correct. That's certainly the intention.
Just turning to, I'm just going to take the line actually, Cabinet Office and then DEFRA and DOI. Any comments on that?
Ken Mill, representing DEFRA. No comments, thank you.
Can I rephrase that? Sorry. Are you willing and up for the conversation, and will you work hard between now and deadline 7 to bring something to fruition?
Ken Mill, representing DEFRA. Yes, we've obviously prioritised this work and to get it delivered in the timescale that you've asked for.
Could I just clarify then what the deliverable is? So we're looking at a framework with updated principles, setting out principles, which includes stakeholder comments by deadline 7. Is that what we're saying, rather than for comment by stakeholders? There's a difference in that.
Amy Sterling on behalf of the applicant. I think we can, the commitment is that we will engage with DEFA, Manx National Heritage and others as appropriate on the content of an updated plan, which would be submitted on a without prejudice basis, along with a without prejudice MIC requirement. I don't think we can at this stage commit to including stakeholder comments within that plan, because that's subject to ongoing discussion. We are currently, as I understand it, quite far apart from DEFA in terms of the nature of the fund and the things that it would cover, the quantum of the fund, etc. So we can't commit to putting their comments in the plan, but we can commit to engaging with them and reflecting that engagement where we can in the plan. It might help. We could put in a consultation log or something like that, which might assist.
Ms. Sterling, as part of the earlier discussion and some of the information that we were requesting as part of both agenda item 3 and 4, we are minded to issue a Reg 31 request for some of that information, because that way we can issue a date by which that information should be submitted. And the reason for doing that is because we appreciate your inability to submit that as a hearing submission, and the fact that we actually need to see it before deadline 7. So that's a very long and roundabout way of saying that there's likely to be a Reg 31 issued which requests information at on 24th of July, Friday the 24th of July. So does that maybe provide you an opportunity to provide the framework sooner than deadline 7, but enabling parties to respond by deadline 7? The reason I'm keen for that to happen is then you can provide something which takes into account some of their commentary by deadline 8.
Amy Sterling on behalf of the applicant. Yes, that seems reasonable. We could provide an updated document for an additional examination deadline of next Friday, I think that is, and allow DEFA to comment for deadline 7.
Yeah.
I think it would be important for the parties to also continue to engage with each other outside of those deadlines as well.
Yeah. So just from now on, let's just assume that we're not going to call it a deadline, but let's just call it a Reg 31 date, and we'll polish the language around that in our hearing actions.
Could I just establish clearly the stakeholders that should comment on it? So it's DEFRA, DOI, who else? Match National Heritage, so those three.
And Cabinet Office, I think, have indicated a willingness to be involved. That's Cabinet Office.
Cabinet Office, DEFRA, DOI, and the Heritage Trust.
Manx National Heritage, yes.
Okay, perfect. Just want to be very clear, otherwise we're going to...
So I was just running down the line, going back to that, and just confirming with DOI that you're happy with that, you understand what we're proposing, and you're ready to engage and do what you need to do.
Yeah, Mr. Garden, on behalf of the department, yes, can confirm we're happy to engage on that basis.
Brilliant. Mr. Brown, thank you for staying on camera during this item. It's been nice to know you were there. And I think we've probably got all we have on this item. So thank you very much, and we'll put everything else that were in my questions into written questions. And I think that it's hot and stuffy in here, so let's have a break for... Can we do 20 minutes? Yeah, let's have a 20-minute break.
Okay, welcome back everyone. The time now is 1 minute past 4 p.m. and we will start session 4 of specific issue hearing 8. I'll hand over to Ms. Fernandez.
Yeah, thanks very much. And it is hot and sticky in here, so I hope you've all had a chance for a drink in the break. Okay, so this is turning now to a new item on the agenda. This is Groudle Bay, and here we're looking at both Groudle Bay Beach and Groudle Bay Field and activities arising in those locations and some of the things at the XB which the examining body wants to probe a little further. And as part of this agenda item, we did ask the applicant to work with DOI, although DOI suggested it was others, or was it DEFRA and it suggested the other way around anyway. It's hot. To work together, to put together effectively what I would call a planning constraints map, and then to overlay the different works plans on that map. So we've received that, and we were using that at the accompanied site inspection yesterday morning, and thank you all of you who put that work in to get that together for us. It's helpful to have that integrated picture. And I think, Mr. Smith, there was a question you wanted to ask. Well, actually, before I jump into that, would it be possible to briefly, and I do mean briefly, run through the constraints map on the screen so we can just orientate ourselves on it? Would that be okay from the applicant's team? And I appreciate that we've had a few technical difficulties, and if I'd thought about it, I would have asked you to set it up beforehand. So it might take you a few moments.
Toby, it's on behalf of the applicant. There'll be various people speaking to this Groundle Bay agenda item in relation to layout and design, and the map that's on screen. It'll be Dr. Carolan that's speaking.
Mr. Randall, just for the purpose of this agenda item, can we close the list of attendees so that the map appears a bit bigger? I don't know if it will, but let's just see. Yeah, okay, good. Sorry, just bear with me 1 second. And in fact, oh, somebody else is controlling the map, isn't it? Would you actually just zoom in a little bit more, because we don't mind losing the key.
Not quite that much.
I bet. Okay. Where are you going to start with, Mr. Carolan? Hey? The marine environment. So if we could start with the marine environment, so zoom in as much as... Okay, good.
Dr. Kieran, on behalf of the applicant. So what is on the screen is a combined constraints and works plan, and this was used to inform the accompanied site inspection yesterday. It's been submitted into examination. Its reference is HS3 008 for anyone that wants to access it. I'll speak just about the general layout and arrangements of the cable, the construction areas, the works plans, and then I'll pass to my colleague, Ketchy Amazy, who will speak about the constraints in detail. So what we're looking at is we can see to the top centre, Groudle Bay Field and the indicative works compound, laydown compound, as this is taken from the Port Skillion and Groudle Bay indicative master plan. So it shows the location of the TJB, the grey area to the top right of the compound in blue, and then the area down to the bottom left of that compound, which is, you can't really make out, but is green. And that's all of that area's works numbers 6. And that the area at the bottom is the welfare and laydown facilities. Coming the blue, we've got the blue cable, and the blue cable then is for the offshore drill. So we will HDD at this location from the onshore, so from the transition joint bay out to the yellow rectangle, which is at the 12-metre contour. And that's going to be the location of the offshore cable installation vessel. So it could be a jack-up barge, or it could be a similar cable layer installation vessel. It'll be located roughly within the 12-metre contour. Can't get in much deeper or much shallower due to the size and the draft of the vessel. That will be the trenchless technique. It'll drill straight across the intertidal and pop up in the field. And then the other arrangement that we have is, I can't really see it, but we've got another yellow rectangle coming to the beach. So that will be the location of the offshore cable installation vessel at the 12-metre contour. And from that point to Groudle Beach, we will excavate the cable trench. So that will be, the rock will be broken, the cable trench then will be excavated, and then the cable subsequently laid on that as we come across the beach, go up the beach and shown in yellow, and then we turn right into the transition joint bay. So the area just to the left, the most southern part, you can see a green, red and yellow line, and that represents the order limits. So you can see it at the southern extent, sort of bending round in an arch and then coming back round. And that line represents the extent of the order limits. I'll pass to my colleague Ketchy, who will go through a breakdown of all of the constraints, the environmental constraints that are shown on the map.
Ketchy Amazy on behalf of the applicant. So in preparation of the constraints map, we have collaborated and worked in conjunction with the DOI and also DEFA Planning and Policy. We've taken into consideration a number of constraints, including the ecological constraints. As you're aware, we undertook a habitat condition assessment back in May. So the outcome of that was also used in preparing these constraints. We also, from flood risk data from the DOI, have incorporated that into the constraints map. You can see that on the western side of from my screen, the blue teal-ish polygon running north to south. The solid areas to the east and a large part of the constraints map constitutes the habitats, the various habitats that were identified during the HCA survey. There is also an element of heritage assets, a couple of them. So there's a water mill that you can see just very close to the car park there, and the LIT, which is both outside the order limits, but immediately within the vicinity. The shapefile that is grayish white lines hatched, that is the wildlife site as identified. We do also have a shapefile which identifies designated tree areas, but I think this would require clarification with the policy and planning team of Cabinet Office, as their ship files don't quite match up with what we were provided with previously on the project. So yeah, we've got heritage assets on there, the flood risk, and ecological constraints as shown on the maps. Thank you.
And something that we touched upon earlier this morning was the removal of one of the transition joint bays to Groudle Bay Field, something that came in at deadline 6. Would you just explain what's happening there? Because obviously the indicative master plan had 2, that one of the previous versions, and now we're looking at 1. So if you could just explain that, please.
Toby Yates on behalf of the applicant. So the latest position in the examination is as set out in the project description chapter, which is D6-025. And at the moment, that sets out optionality for having 2 cables at either the field or the beach, or you could have 1 at the field and 1 at the beach. But as indicated in the deadline 6 cover letter, which is D6-001, there's a possibility for a design refinement to reduce the 2 cables to 1 cable, and that would be 1 cable into either Groudle Beach or Groudle Field.
And what led you to the removal of that particular one in that particular location?
Toby Yates on behalf of the applicant. I'll pass to Julian. Dr. Caroline here.
Hey, Dr. Carroll, on behalf of the applicant. We had initially requested from our technical team to provide the indicative master plans previously, and they had put 2 cables into the field and 1 cable into the beach. Then it was highlighted to us by DEFA. DEFA had asked us basically if we could provide an update to the indicative master plan to provide a 2 cable arrangement for the field. At which point we went back to technical, and they sought to optimise that work. So when looking at refinements to the project, they seen that there was an opportunity. Well, it was a very constrained site within the beach, so it was quite challenging to get the 2nd cable in there. So they looked then in discussion with Max Utilities to see if there was options to refine them down. Technical then confirmed that the maximum design scenario for 2 cables really at both locations probably wasn't required, and that we could deliver the island link with 1 cable. A decision then was made to reduce the maximum design scenario down to 1 cable for the project, and then to have that 1 cable solution either in the field or in the beach. So the beach arrangement already had the 1 cable, the field arrangement had 2 cables, so then that was updated to remove the 2nd cable.
Okay, thank you. That's helpful. So, looking at it really simply, and you probably explained this before, but we would benefit from another explanation. Just looking at that, and having been to site, both accompanied and unaccompanied, and in terms of what you've just explained, the Gradway Beach is hugely constrained in terms of road access, topography, physical location, space, all of those things, people living nearby, whatever. Yet Groudle Bay Field, when you look at it on that map, and it quite illustrates it quite nicely, is less so. So the naive observer might wonder why Groudle Bay Beach is still in the running, if I can put it in colloquial English, and why, if you're removing 1, you didn't remove that one and leave the 2 in the field.
Dr. Carroll, on behalf of the applicant, I think just to step back, I can't remember when. It was just when I explained the evolution of the site selection consideration of alternatives back some time ago. Groudle wasn't a landfall option that as the applicant, we were considering until we started our consultation and detailed technical discussions with Manx Utilities. At that time, Manx Utilities suggested this site to us as being a potential for the landfall, the reason being that they had done extensive route planning, site selection work and landfall analysis for their Manx 2 interconnector, and this was identified as a site for the potential landing of the Manx 2 interconnector. So they said, if you're looking for landfall, this is essentially an interconnector that we're building. They said that this would be, they had given it a due consideration, so we reviewed that. So the position was then that we would take this forward into the route planning, site selection, consideration of alternatives for landfall. We totally agree. It's heavily constrained. The engineers said they can build it. It's not the optimal solution. The optimal solution that Ørsted have chosen as the applicant is the field solution. So it presents an unconstrained development opportunity for us, and hence a bigger compound, easier access, and hence why there's difference in the footprints from the field to the beach. That's sort of why the sites differ in terms of their spatial footprint. But both sites are deliverable, and we will determine in consultation with Manx Utilities which one is taken forward.
And what would be the nuts and bolts that would help that decision making? What's the essence of that? Why would Manx Utilities suggest one location over another? Is there a substation location they have in mind? Just trying to understand the nature of that conversation and how that would affect ultimately decision making should this be recommended.
Dr. Carroll, on behalf of the applicant, I would just be speculating on behalf of Manx Utilities, and I'd prefer not to. But from a project experience, there's a number of criteria that would come into that consideration, where the grid connection location was going to be, the the length and complexity of the onshore cable route, whether there was geotechnical constraints or otherwise at any of the sites. It's not like a foregone conclusion that we can make that HDD drill. That will need to be determined through detailed geotechnical investigation. It would be our preferred option if Ørsted were coming at this solely by ourselves. But because we're in partnership with Manx Utilities, they have identified that site, and hence it forms part of our application. And until such times as the decision is made on the appropriate landfall, then we can't select between one or the other.
Okay. Can I just... Yeah,
and just on that point, it's a point well made, and speculation isn't what any of us want to do.
Yeah, well, that's exactly where I'm going on this. The first is to just clarify one point that you made, Dr. Carolan, which you've said twice, so I trust is clear and is not speculative, namely that all other things being equal, the field site is the applicant's preferred site.
I wouldn't, Dr. Keogh, on behalf of the applicant, it's not our preferred site. It is basically Ørsted's internal technical design optimal site. Yeah, it wasn't identified by Manx Utilities as being a potential site. This was our engineers looking at it and going, we would prefer to have that field, and this is the arrangement that we would prefer. It's not our preferred site. This would be our optimal site, if that makes sense, not preferred.
Yeah.
Because the preference on terms of site selection depends on many other things.
That's very clear. Then, stepping down the staircase, to the extent that there might be particular, essentially external to Ørsted considerations, Manx utility considerations about why one would not use that site, those rest with MU, who are not with us today, and if we need to pursue that further, we're going to have to write them some written questions. But absent information from them, and this is the reason why I'm raising this point, because I think it is one that could prospectively also still be usefully pursued through statement of common ground process, even if useful answers to written questions are not forthcoming, is to think about the respective broader land use planning settings of the two potential sites, namely that uncontroversially having regard to what we saw on site and having regard to this constraints plan, it is a physically smaller site with a larger number of constraints at the beach versus the field, which is larger, more open, fewer receptors, etc., etc., etc. So absent information that provides a clarity around the case for the beach, there's then some hard thinking that the examining body would have to do if it gets as far as making a recommendation and starts to think about these sorts of matters of detail. And I just place that on the table simply because it would be helpful to us then, I think, to be able to appreciate if there is anything that we are still unaware of that underpins Manx Utilities advice around the retention of the beach site.
Toby Yates on behalf of the applicant. That's understood, sir, and we hope Manx Utilities can contribute in response to third written questions. I just add here on behalf of the applicant that we'd put that in absence of that information, that adds support for the need for that optionality, and the position that the applicant's putting forward is that without that level of design certainty from Manx Utilities at this stage, it could be either the beach or the field, and that's the extent of the application that we're putting forward.
I note that, but there is a kind of, shall we say, localised balance of harms dimension to this. And unless Manx Utilities, who seem to hold unseen cards in relation to information that bears on the justification for the beach site, it does become quite difficult to actually even appreciate why the beach site might be of any relevant part in this.
Dr. Kieran, on behalf of the applicant, just in relation to the significant effects of the project, neither site is predicting potential significant effects. So there's not really, from an environmental perspective, favour for one site over the other. Yeah.
That may be so, but probably doesn't relate that much to Manx Utilities. And
I am going to pursue this one more time, because if we think about circumstances in which an examining authority in the UK deals with an application for a generating station in circumstances where there is no connection specified, it has long been a standard article of policy in the EN suite that whilst they can't have regard to the connection alignment that isn't there, they do have to broadly, two things are true. Firstly, that the absence of the onward connection is a commercial risk for the applicant. And that secondly, for the examining authority, the examining body here, they have to broadly satisfy themselves that essentially there is no reasonable impediment to the potential ability to complete the connection alignment. Now, we are kind of in an analogous situation here because whilst your essentially array to landfall alignment is put in front of us, what we can't see is the last mile, so to speak. We can't see the final bit of the connection. But I do think taking that policy position analogously into the circumstances here, we probably have to at least be clear that there is no reasonable impediment in relation to delivery of the onward mile or the last link. Now, at the moment, I will be very frank with you, where we currently sit is that we don't have that in relation to, frankly, either of those sites.
Amy Sterling on behalf of the applicant. We agree with your summary of policy, sir. I think the current wording in EN1 is no obvious reason. It's been updated on various occasions as to why there's no obvious reason the grid connection would not come forward. The applicant does recognise that there is inherent uncertainty with the island link. It is sought to accommodate design flexibility within its application where it can, within the limits of the information available to it. The government will, an intention to have an island link, and obviously within the spatial restrictions inherent in MEMA. That's why the applicant has, I would suggest quite unusually, agreed a Grampian style condition with the Department of Infrastructure, which is requirement 31, which essentially prevents the offshore electrical connection works number 3, 5 or 6 from coming forward until such a time as planning permission is granted for that onshore connection. So we do appreciate the lack of information in relation to that onward connection that's currently before you. I would repeat Dr. Callahan's position that as it currently stands, there's nothing from a technical and environmental perspective, which means either landfall location is not able to be put forward, and actually, you know, they are both technically deliverable, and neither of them, in our view, would result in likely significant effects. We will seek to engage with Manx Utilities to see if there's any more comfort we can provide to you in terms of the necessity of having the optionality within the application.
Yes, and we've had correspondence from Manx Utilities, which seems to say that if they are requested for more information, then they will provide it. I think that's D5029. So maybe there is something there that we need to either follow up ourselves in written questions, but actually, applicant, if you would also follow it up. Because to Mr. Smith's point, the map speaks for itself, doesn't it? I mean, we're not disagreeing with the constraints and the questions that therefore raises. Yes, please do come forward. Welcome.
Hi, thank you very much. Ian Strafford, resident of Laxey. Just listening to the conversation, which is interesting, and Mr. Smith, you were making the comment with respect to potential at risk for the applicant if a connection couldn't be made, for example. Is it not conceivable that perhaps actually this case is 180 degrees away from that, in that, as we have heard in previous examination hearings, that the Mooir Vannin project is not dependent upon a Isle of Man connection. And I think we've also heard from the applicant through media interviews that nor is Mooir Vannin under any obligation to provide the Isle of Man with electricity. So arguably, in this particular case, should there be issues with this, it doesn't make much difference to the applicant as to whether or not the power is provided in terms of what the primary purpose of the project is for. But we've also heard, and I think, Madam Chair, you've made the comment a number of times with respect to the benefits for the island in terms of the planning balance and electricity supply being one of those potential benefits. I think my observation, therefore, would be is I'm not sure there is a risk to the applicant with respect to financial risk or whatever that might be in terms of moving the project forward. And I think we're coming to the last few meetings here and we still do not have clarity on one of the key benefits from a planning balance perspective, or at least that's how it appears from members of the public. And this seems to illustrate that continues. And I find it very difficult to understand how we are still moving forward without having this concretely decided one way or the other.
Thank you, Mr. Strafford. I think the applicant's response in this regard is in examination, but I think it will be helpful to have a response summarised quickly at this point.
Amy Sterling, on behalf of the applicant, yes, the applicant isn't and can't commit to delivering the island link. The applicant has, outside of this process, has made a commitment to provide energy benefits. There are two options currently being discussed with the Isle of Man government, one of which is an island link connection, which it has sought to facilitate to the limited extent that it can within its MIC application. The other is a power purchase agreement directly with the Isle of Man at a discounted rate. The applicant has put forward its view on where these energy benefits via the island link may sit within the planning balance and the weight that should be afforded. Ultimately, we're kind of, it's good, we're reaching the crux, I think, of all the matters. The weight to be afforded is for the examining body and the Council of Ministers to determine. You may decide that no weight should be placed on the island link because of the uncertainty in its delivery, and that would be, you know, within your gifts in terms of your recommendation.
Thank you, Ms. Sterling. Just on that point, Mr. Strafford, Ms. Sterling made reference to a Grampian-style condition earlier, and basically what that condition in a draft MIC, what that provides is that until there are certain points, until there's certainty about the island link of energy actually coming straight onto the island, there are certain parts of the application that will not be actually built. So perhaps that gives you while it's not giving you the clarity that you seek, but perhaps it responds to the point, at least on the planning balance point, that it's the applicant's position, which the examining body is taking into consideration or will take into consideration, is that given the uncertainty around the island link, there may be no weight given to the island link and the energy that's being provided to Isle of Man. Having said that, if you look at the SIH 10 agenda, that matter is in discussion and is live.
And Ms. Sahai, if I might just also come back to Mr. Stafford on the, I guess, reversal of economic risk point, which is clearly articulated, but the reason I referred to that particular point in the direction that I did, namely with the risk on the applicant, is because that is how it has been framed in policy, and it was merely to make clear that I was referring to a specific policy element of EN1, NPS EN1, not necessarily saying that that particular thrust of that particular policy is directly descriptive of the circumstances that we find ourselves in here, because I'm not sure it is. But the critical underlying point in policy terms, though, is that there can be circumstances where a generating station is brought forward without a connection. And in those circumstances, there are still things that an examining body needs to know.
And I appreciate that, and thank you very much. And I think all I would note is that in this particular project, it was clear that the UK connection has been, I'll call it progressed to a certain point in terms of certainty with respect to national significant infrastructure project status being declared in order to then therefore bring this project forward. But I think certainly what I'm hearing and what I think a lot of members of the public are hearing, and it's just worth noting, is that there are only two fundamental benefits being purported for this project to the Isle of Man. One is potential for energy, and the other is the financial benefit. And both of them seem to be incredibly up in the air at this stage in terms of what they might be, the quantum of them, when they would arrive, etc., against the very clear, concrete impacts that will be seen, as we've been, some of which we've been discussing this morning, and I understand that. And I understand, right at the very outset, I think, Madam Chair, you very, succinctly said that what you were here to do in simple terms was to weigh that balance between the benefits and the disbenefits. The disbenefits have been very scientifically underpinned, and the benefits seem to be very much in the air. And that's the only comment I'd make, and it's not a question, it's just where we seem to be at this late stage. And I think a lot of members of the Manx community find that entirely unsatisfactory, but that's where we are maybe. Okay?
Yeah, that's a valid point. Thank you.
And I see another hand up. May I just ask a question, then I will invite you up again. Just maybe this is a signposting thing, maybe we've missed it, but I noticed that there's been quite a few references to a power purchase agreement recently, and I just don't recall having read something in the examination library, or what is that? And can you, maybe that's straying slightly into later in the week, but can you just put a bit of colour around that? Because as far as I recall, I don't remember seeing that, but that's not to say that I missed something.
Amy Sterling on behalf of the applicant. It is referenced in some of the documents, but it's not a matter which is included within the MIC application because it doesn't relate to infrastructure or anything. A power purchase agreement would be a direct agreement for the purchase of electricity between the applicant and the Isle of Man government at a set price. That power could flow through the existing interconnector. So essentially what would happen is the applicant, I mean, I'm at risk of speaking beyond my knowledge here, so I will keep it brief. The applicant would transmit the power from the wind farm to the GB grid, and the Isle of Man government, or Manx Utilities, I'm not entirely sure who the counterparty would be, would purchase that electricity at a set price agreed between the parties from the GB grid. That's not necessarily relevant to the planning case. It's not something we've sought to put weight on in our planning support statement or our planning statement, but nevertheless, to ensure everyone has the full picture, it is something that has been discussed between the applicant and the Isle of Man government and Manx Utilities, and another reason why the applicant can't commit to delivering the island link is there may be another mechanism which the Isle of Man government wishes to realise energy benefits from the scheme which don't involve the delivery of the island link, for example through a discounted PPA.
Just on that point, Ms. Sterling, given this is energy that's generated, renewable energy, that is by some mechanism coming back to the Isle of Man, why are you proposing that that not be given any weight?
Amy Sterling, on behalf of the applicant, I was talking about the discounted power purchase agreement.
I'm talking about the same thing.
I can consider it further. I haven't typically considered it to be a planning benefit. There's certainly no certainty on the delivery. We were sort of more focused on the island link opportunity within the application, but I can give that certainly some more thought. We don't currently place any weight, any reliance on it.
What I'm trying to draw out is that why is there a distinction? I can see why there is a distinction, but why isn't that a distinction in terms of a gradient rather than a binary distinction between decarbonised energy coming straight to the island or decarbonised energy coming a slightly roundabout way through the UK? So it's just worth understanding that. That's one thing. And then the second thing is that if you do come to a point where you feel that it deserves some kind of weight, of course, ultimately, and this is for the benefit of everyone in the room, it is for the examining body to determine what weight we give these matters, but it is for the applicant and other parties to propose whether, this is great weight against the application or great weight for it. So whatever weight you think that needs to be given, if you determine that actually that does deserve some weight, then perhaps some evidence of that should be presented into examination. Just aside from that conversation, I think what would be really helpful is to just for us to understand a little bit more about this. Can do, yeah. So, and we don't have to finish this conversation today. We can come back to it later on Friday. But I think it could be quite relevant at that point as well. So do you want to just take that away?
Amy Sterling, on behalf of the applicant. Yes, fair comment. I do think it's something we'll have to reflect on, and I'm certainly not the right person to speak to you about the mechanics of a PPA. So we will reflect on that and ensure we are prepared to speak to it on Friday. Okay. Thank you.
Okay, so, I think we would say that there probably is a policy link because it is something to do with energy security. So maybe just have a think on that point. And I'm conscious that there are two hands up. Ms. Cook, I did say I'd come to you before then, so if I may, I'd come to Ms. Cook, Then I know, Mr Strafford, you've also got your hand up, and then I'd like to go to the government department. So if we could do it in that order, that would be handy. Thank you.
Thank you. Just quickly, and actually it's a bit of a housekeeping thing, I guess. Better? Yeah. Thank you. I think the audio dipped slightly at one point, so I'm just asking for clarity, for understanding, in case anybody else struggled with that point as well. Apologies. So a few minutes ago, I think you were saying that the uncertainty around the link to the island, did you say, this isn't a challenge, honestly, this is just a confirmation, clarity, did you say that it means there's so many uncertainties that it might not be possible to take it into examination? Or did I mishear that?
So we made 3 points. The applicant's case, and please interject if I'm misrepresenting you. The applicant's case is that because there's uncertainty around the energy actually coming onto the island, given that there is no substation at the moment, the applicant's case is that the examining body may decide not to give any weight to the energy coming onto the island. Via the island link. The second point here is that the applicant's case relies more on the economic benefit that's coming to the island. And at that point, I do want the applicant to either by nod or to say whether that representation is correct.
Amy Sterling on behalf of the applicant. Yes, that's correct. The applicant in its planning statement and previously planning support statement suggested that a moderate positive benefit could be placed on the opportunity afforded by the island link, but ultimately that is only the applicant's position on the weighting to be afforded, and as set out today, and as you've repeated, it's ultimately for the examining body, council of ministers, and they may decide that no weight should be afforded to the island link. And yes, our primary case is that we meet the government policy to deliver an offshore wind farm in territorial seas for export to the UK to help the UK meet its energy targets and to bring economic benefit to the island. And it's on those 2 elements that we place reliance.
Thank you, Ms. Sterling. I should have just handed over to you, but does that clarify your question?
Yep, that's helpful.
Okay, and I'm just going to refer you, and I apologise, this is another technical document, policy-related document, but if I could just refer you to the applicant's planning statement, the latest one that's gone into examination, that explains some of these points and is response to almost exactly the same questions that the examining body put to the applicant.
Okay, perfect.
Okay, thank you.
Thanks.
Then if we might invite Mr Strafford to come forward and then to the government departments. Thank you.
Thank you, Ian Strafford, Laxey resident. Just with respect to that comment around potential purchase power agreement, I think it is correct to say that it isn't part of the application. But it's also correct to say that in the preceding last couple of months, there's been an awful lot of media stuff going on. And within that, I'm going to say this in the best way I can, but excuse me for saying it, almost like promises are being made as to what might be done instead kind of thing for power. So the Manx population have now heard things like, well, we'll be getting 15% discount on our power. We'll be getting power purchased through our interconnector rather than a direct cable to the island and so on. A direct cable to the island provides clearly more energy security than one via the UK grid and so on and so forth. So I think it's really important as a matter of principle here to be very clear in terms of there are things which are within this application, but there are now things which are being discussed and being put forward by the applicant outside in media, giving the population a potentially different view as to what they may or may not be getting. And I think that's unhelpful. But you need to be aware that that is where we're at, and that's trying to influence people one way or the other as to what may or may not happen.
Thank you very much for bringing that to us, Mr. Strafford. Can I just put this to the applicant? Can you confirm if any of the aspects that Mr. Strafford has talked about is in the examination, in the application?
Amy Sterling on behalf of the applicant. As I think I made clear what Mr Stafford is referencing, the discounted PPA doesn't form part of our MIC application. The applicant is engaging with local communities outside of this process, recognising that it is not solely responsible for delivery of the Island Link and other ways that energy benefits could be realised, engaging more with the Isle of Man government and Manx utilities as to how those could be delivered. The applicant has never suggested that it will absolutely deliver the Island Link under the MIC because it's not possible for it to make that commitment.
But there was other aspects that Mr Strafford just mentioned, which he is suggesting is potentially misleading the community, and I just want unequivocal response from the applicant whether those matters are in examination at the moment. Are they before the examining body?
Amy Sterling on behalf of the applicant. Apologies if I missed it. Can you specify what specific information you consider in the public domain is misleading, and what I can consider whether from the applicant, that I can consider whether it's in the examination? I'm not entirely sure what I'm referring to.
So I think the point I was trying to make is when we started this examination process, it was very clear that in terms of power to the Isle of Man would be either via a link, a direct island link, which was part of the application, or there wouldn't be power to the Isle of Man, because I think the statements were made that the primary purpose of the project was to provide power to the United Kingdom. As time has gone on, I don't believe anything has changed to the scope of the application, if that's the correct way of putting it, in terms of how power might be provided to the Isle of Man. It was either via a link or there is no power to the Isle of Man. As I'm sure everybody's aware if they've followed any of the media and listened to the radio or whatever it is, as it's become apparent that maybe an island link isn't a direct island link, that is, isn't necessarily a possible or might not occur, then ideas have been put forward, or suggestions have been put forward, not ideas, that rather than that, then what would happen is the Isle of Man would receive its power via its own interconnector, and that might be at discounted rates and so on and so forth. To me, and I think to a lot of people, that now feels like the scope has been changed in terms of how power might be provided to the Isle of Man that is outside of the application that's being examined. And therefore, in my view, that is unduly trying to influence people in the Isle of Man as to what actually is being examined, in the sense of it's a change of scope that I don't believe is in the documents. I don't think, I've not read every document, but I've tried. And I think the point's just being made is we shouldn't be advertising things outside to members of the public about what we may or may not do if it isn't actually something that's being examined under this application, because it has no authority with which to make those claims. That's my point.
Amy Sterling on behalf of the applicant.
Ms. Sterling, I think that's a valid point, and it kind of goes back to the point that Ms. Fernandez made earlier, that you have been referring to this PPA. We've not seen it in examination. Why are you referring to it? And then you said, gave a response to that. So there is confusion here. There is confusion about whether it's an examination, whether it's not. Given the discussion that's just happened here, if you need to take this away and respond to us formally on the question that Mr. Strafford's put forward in continuation to the question that Ms. Fernandez put to you initially, then that would be fine. So you can make that choice.
Amy Sterling on behalf of the applicant. Yes, we have already undertaken to come back to the PPA in more detail on Friday. I would suggest that it's not misleading, and that an additional option for energy benefit to the island has been identified between the initial, it's an island link or there's no energy benefit, to it's an island link, or there's now a discounted PPA option which has been discussed between the applicant and the relevant government departments, that there is no development associated with that PPA, so it's not included within the MIC application, and we haven't to date sought to place any reliance on that discounted PPA in the planning balance, hence why it doesn't form part of the application. Nevertheless, it is an option being discussed between the applicant and the government, which is why some of our documents reference it, because to sort of almost try to join the dots and acknowledge that position. So I wouldn't suggest the applicant has been misleading. There is just an alternative commercial option which sits outside of the planning process through which energy benefits could be realised, which in all honesty I don't know what specific media reports are being referred to, but I would envisage that as the purpose of those.
Yeah, I think that's fine. I would just draw a slight distinction here between what you consider needs to be taken into account in planning balance terms. So that's one discussion. But then there is the other discussion about public perception because of matters that are being discussed in this examination. There might be confusion about what is in examination and what is not, what in fact is a viable option and what is not. So perhaps we should think carefully about how we make that clear. But I think the response that the applicant has given does clarify that. I do want to avoid too much back and forth, Mrs. Trafford, so make your final point.
It is just one final point with respect to whether or not it relates to this project in terms of, sorry, I can't quite remember the words that you used, but it was very specific, has been very specifically said in the public domain that if the power was to come back, the discounted power would be as a result of the money that was saved through not delivering the island link. So I would argue it is directly related to the project because it is directly going to be funded by money that was not going to be used on an aspect of the project. So it's very, you can't divorce the two, is my view.
Okay.
So I respectfully, not disrespectfully, sorry, I respectfully disagree.
So I think there's quite a few points that have been made here, and what we would like, and I will note this as a hearing action, is quite specific responses of clarification on all of these points, because everything that's been put before us, if it relates to this matter about the PPA, I think it is really helpful to clarify some of these points. Okay. Thank you. Back to you.
And so I was just going to ask whether any of the government departments wanted to, and it's a generic question across the whole table, to come in on this point, probably starting at DOI and then asking DEFRA and Cabinet Office.
Robert Garden on behalf of the Department of Infrastructure. I think fundamentally the control of the interconnector that we're talking about, the ownership and operation of that, does sit with Manx Utilities, and I know we've had an action already today about potential questions for Manx Utilities. So I think that this one falls into that camp as well to make sure that they are asked or provide a position on this.
Your colleagues to the left? No? Okay, thank you.
Now, before we leave this item, just one very small matter of clarification. Can whoever is controlling the on-screen version of the constraints plan, please, starting on the right-hand end of the page as I see it, place their cursor on the red line boundary, and in doing so, at the margin of the page. Now, in doing so, what we're observing here is the drawing in of the red line boundary between the wide marine cable corridor and the narrower, smaller, more tightly defined landfall area. And there is an extent of coastline here, and if we compare this plan with the works plans, there's an extent of coastline here where the red line boundary travels along what I infer is probably mean high water springs. Can I just check whether that is correct? So if you track your cursor along that red line boundary, it travels along parallel essentially with the coast, and then it strikes inland to include the landfall site.
Dr. Kieran, on behalf of the applicant, that red line isn't the red line boundary. That red line is mean high water. So where it runs parallel...
Where is the red line boundary then?
So the red line, okay, so it's only shown on the terrestrial limit. It isn't shown. We need to look at the works plans to see the red line boundary. So we only have the onshore works for this because it was for the accompanied site inspection. So we only have works number 6. We don't have all of the other marine ones. We don't have works numbers 3, which would show that it more or less keeps in line with the field and goes out into the marine environment. The line that you point out is the mean high water line on the lower line. Yeah. If we could show the works plans, it would be much easier. I know, but the tide lines aren't.
Question in principle then, what is that red line showing if it's not the red line boundary? I mean, proposition it is mean high water springs, but
I think, Dr. Kieran, on behalf of the applicant, I think that's a bit of a GIS error, and what it does is it takes, so the red line does come down from the field to the side, yeah, down there where the cursor is,
yeah.
And then it mistakenly joins then with the tide lines and goes round. And what it should do is go straight on down.
Can we see the latest version of the works plans, which
The works plans will clarify it.
I apologise for asking for yet another document to be brought up, but it arose on site. We are close to a final opportunity to clarify plans, and I just want to make sure this is clear.
Dr. Kieran, on behalf of the applicant, showing the works plans, apologise, you are correct that the works plan does follow, so works area 3 follows the tidal limits round. Yeah.
And then there is, as we've already discussed, if we actually look at the master sheet, yes, sheet 4, you can see that in fact the marine corridor is considerably wider, as one would expect. I mean, that's a typical provision in an offshore cable corridor. But yes, there is a brief period there in relation to, I guess, what I would describe as the northward as opposed to the southward foreshore, where because of the additional width of the marine corridor, there is a red line boundary struck along the foreshore. And I just do want to check that that is mean high water springs, or where is it?
Dr. Kieran, on behalf of the applicant, it is mean high water.
It's mean high water, just plain MHW. Okay, fine.
So I think there is something that comes out of that. And what we were hoping to do with the Groundle Bay discussion was to integrate the offshore and the onshore, and appreciate that conversation, but it would be helpful to bring this out a little bit more so we see the offshore and some of those works plans and how they integrate into the onshore. That just then gives us a full picture. Quite often with these applications, people look at things individually and nobody's actually sitting there looking at the place as a whole. Okay, thank you. There's one hand up, and then I'm going to move on to... Let me just finish this thought. So thinking about that interface between the offshore and the onshore, there's a clarification which we would appreciate because we aren't entirely sure we understand what is being proposed. So with respect to Groundle Bay Beach landfall, at one of the previous hearings, we heard Dr. Carolyn, and we were looking at the transcript the other day, you discussed the fact that there was a need for geophysical and geotechnical surveys, and that should that rocky marine reef necessitate it, then there is ability within the draft MIC to look at HDD as opposed to open cut trenching. Is that correct?
Dr. Keoghan, on behalf of the applicant, it wasn't in relation to reef per se, it was in relation to bedrock outcrops within the intertidal that would form an engineering constraint that we needed to then have some flexibility to route around, and if we couldn't route around, then we would have to cut a trench through that rock, assuming that it wasn't of high ecological value. If it was of really high ecological value, then we would need to look for alternative means of installation, and that then would be HDD or an equivalent trenchless technique.
Yeah, can you approximately indicate where you're thinking when you're wondering about whether this, I mean, accepting the surveys haven't been done, but approximately between what I think is the yellow square being the jack-up vessel and landfall location, where's the area of search and how far inland would into the shore area would that come?
Sorry, search in relation to what exactly?
The bedrock, the conversation we've just been having.
Okay, Dr. Keoghan, on behalf of the applicant, looking at, if you zoom in, maybe I can get my colleague to zoom in to the 188 metre, I think it's 188 metre, you can see, for the open cut into the beach. Dr. Keoghan, on behalf of the applicant, so you can see, basically, you can see the gravel to the beach, you've got the yellow cable route that comes all the way out for the corridor, which is all within sand. So you can see moving on out into the marine environment, you've got exposed bedrock to the north and bedrock to the south and west. The area intervening between that appears from this aerial photograph to be sand overlaying rock. And then moving on out, it starts to get a little bit patchier. So where you see those dark patches moving out past, or just to the south of the 188 metres moving out there, those dark patches could either be attributable to gravel lag material or bedrock at or close to the surface. So it will be them type of features that we would be seeking to avoid, or it's those features that we may need to employ an alternative installation technique. As we move further out, the overburden of sediment over the bedrock is sufficient to bury the cable in it. So it's only in those areas where the burden of sediment over the bedrock is insufficient to attain the target burial depth that would be an issue.
And so, and I'm sure I know the answer, but nonetheless I'll ask a question. There isn't any prospect that HDD continues, let's say, straight through and up to the beach and pop out there?
Yeah, Dr. Keoghan, on behalf of the applicant, our understanding from all of the geophysical, geotechnical interpretation that we've done to date in our ground model work indicates that this is a viable open cut solution all the way.
Does the MIC, however, allow the HDD in the event? No.
Amy Sterling, on behalf of the applicant, you preempted the point I was about to make. The works plans and the works descriptions restrict HDD to the field and open cut trenching to the field.
Yes, that's what I was just...
It's the beach, sorry.
I was triple checking that. That's fine.
Which then raises the final point. Is there a precautionary need to consider a works description that might enable HDD from point to point beneath low water should the characterisation of the bed indicate that it is A, rocky, and B, of such biodiversity or geological significance that you do not wish to trench it?
Amy Sterling, on behalf of the applicant, as you can see, I think it's one we'll consider. The maximum design scenario as it currently is that it would be open cut trench at the beach. It is, of course, possible in the works plans for the applicant to then go to the field from this boundary as well. So if it encountered that rock, it could turn east.
You would essentially then wish to move into the field.
I'll need to take instructions on that. That's certainly what the works plans currently allow for.
Which actually returns to the earlier stage conversation here. and the question about up to 1 or up to 2 transition joint bays in the field. Because if you needed to turn, based on what you found, that might be a means of managing that.
Amy Sterling, on behalf of the applicant, I understand the intention of the applicant is to amend it to up to 1 cable and therefore up to 1 transition joint bay at either the beach or the field, and there wouldn't be circumstances where we needed 2 cables because of increased confidence in the capacity of cables to take any power from the island link through a single cable, and therefore we would reduce the number of cables and the number of transition joint bays to 1 at both locations.
Dr. Carroll, on behalf of the applicant, just in relation to the HDD and open cut, we will confirm everything at the pre-construction stage when we do the detailed geophysical, geotechnical investigation, and it may well be that that becomes the trigger for the decision on which of the sites is the most appropriate to take forward at that time. But we can also review whether it would be more appropriate to incorporate the HDD within that open cut as an alternative solution if that was the case.
One further question, which, if you remember, Mrs. Sterling, I said I'd like to come back to, and that was the point about macro siting as opposed to micro siting. And the macro siting, I recall, was 150 metres. What would the potential effect of macro siting this? What could that enable at this location?
Dr. Carroll, on behalf of the applicant, so the macro siting, so the information that would inform that will be the high resolution geophysical survey for the cable corridor. On any geotechnical investigation that we had, so that would inform that. We would also then have the benthic survey that would be overlaid on top of that, so we'd have all of the sensitive features mapped. We would agree then buffers around those sensitive features in terms of sediment, disturbance and footprint. We would agree then with DEFA and sign that off with DOI. That then would inform the cable specification and installation plans. We would then define the final cable, and that process is the macro siting. So that is like done during the design phase. Once we get in then to the cable installations, so should anything change within the marine environment between the sign off and the installation, then the micro siting would be deployed on site by the contractor, and that would be done up to a maximum of 150 metres to avoid a new area of bedrock outcrop that had become exposed between the survey and the installation. And that then, there's no consultation with that, that's just through a notification process through the as-builts.
Okay, good. Right, let's just skip on. We're on land now, on ground. Oh, I beg your pardon, I did say I'd ask you, Ms. Smith, if you'd like to come forward.
Hi. Jennifer Smith for myself. So I have 2 questions. One in relation to the site we're looking at here, whether it's here or in the field. How big is that in actual size, square meters? How tall will it end up being in terms of the structures built there? And what percentage of its environment will it take up? So in other words, how dominating will it be in Groudle Bay? Well, obviously, it's going to make a big difference there. And then secondly, something that's just struck me is in terms of that corridor of where the cables obviously are going to come from 6 miles to here, what would the restrictions be on people boating, sailing, swimming? A lot of wild swimmers here. They're really wild. But people's interaction with that corridor, how will that impact how people engage?
Ms. Smith, only in the interest of time, we've covered the first part of your question. We covered quite extensively while we were at the accompanied site inspection yesterday. But what I will request is that the applicant respond to this in their post-hearing submission, and I'll note it down as an action. The second point that you've covered, it's possible Mr. Smith will cover that when he looks into tourism today. Okay. But if it doesn't, then I will again request the applicant, because that is a point that we would like a response to, the second question that you've put forward. Does that cover everything?
That's great. Thank
Thank
you very
much.
Okay, so we're back in Groudle Bay in the beach location. DOI, I have read that there are a number of areas of disagreements still in relation to traffic and transport, and I'm not proposing to read through that representation, but really my question to you is, of the areas where there is still disagreement, it is primarily traffic and transport, with the applicant, where are you in those discussions, and do you foresee agreement being reached in some of the areas where you're agreeing?
Yeah, Mr. Garden on behalf of the Department of Infrastructure. So there have been further discussions between the applicant and the Highways Service Department. There were 4 or 5 areas of disagreement that are outstanding, and I think those are largely agreed now, or there's a process in place to agree them. The first was around the number of accesses, and the applicant in its deadline 6 submission is committed to a reduction on accesses. There was a point around road safety at King Edward Road, and I think to address that, the applicant and the department have agreed on a number of matters to be dealt with through the outline construction traffic management plan. So again, we expect that document to capture the agreement between the parties. Similarly, in relation to Groudle Old Road and King Edward Road. And then finally, the road safety audit. And again, there has now been agreement on how to progress the road safety audit between the parties. And I think the current state of affairs is that the applicant is going to prepare a scope for that it's going to consult with the department on in relation to then settling and carrying out that road safety audit. So I think the meeting has led to some progress on those issues in and around Groudle.
And so what that sounds like to me is that you don't anticipate any unresolved traffic and transport access or related issues to emerge now.
Mr. Robert Garden on behalf of the Department of Infrastructure, I think that is correct. I think there is still one item which is outstanding, which is noise and vibration monitoring. I think that is not agreed between the parties, but I think both parties have put their position forward on that, and further discussion planned in relation to that.
And the applicant, do you concur with that characterisation?
Toby, it's on behalf of the applicant. If you want to get into the specifics of noise and monitoring, I'll go to a consultant, but in broad terms, then that's an accurate summary, yeah.
And so, looking at deadline 7, we'll anticipate to have confirmation that things are agreed and everybody's content insofar as those topics are concerned. Is that reasonable?
Kachi Amazing for the applicant, that's correct. So we've had a number of engagements with the DOI, and largely all of those points have been aligned on. And the one outstanding point on noise and vibration, we intend to have a conversation with them probably ahead of deadline 7, and hopefully find a position of agreement on that.
Okay, let's turn now to the outline biodiversity strategy and DEFA and BNG and the applicant. So we've been asking for a little while now for a plan to demonstrate how the minimum 10% BNG can be delivered on the site at the landfall location, or through off-site offsetting, or a combination of the two, and we're still waiting. Having said that, we have seen there is a requirement, a draft requirement that's come into the MIC. But where are we on that, and why does it feel like we're not necessarily seeing the progress we might hope?
Dr. Carroll, on behalf of the applicant, I feel we've made loads of progress on biodiversity net gain since it was first raised. It's currently just from we have a requirement, so it's a requirement 5.2 of the draft MIC. We've done the habitat conditioning survey, which is the first part of the biodiversity work. And we've also written it into our biodiversity strategy. We've made that commitment, and we've also had another formal commitment within our commitment register. So from our perspective, we've made a commitment, we've secured it within the MIC, we've started the BNG work, and there isn't really much further that we can do at this stage. So we think we've made as much advance on that as is reasonable at this stage, really.
So I referred to the requirement, and I did refer to the biodiversity strategy. And what I'm really specifically asking is the plan for the 10% BNG. That's what we're looking for, and how that 10% is calculated, where it will be, what it will look like, and we just don't have that detail.
Dr. Carolyn, I think what the examining body just needs to be able to see and reassure itself that the 10% can be delivered. And if it can be delivered, where, and we just need to understand if there are implications within the order limits, outside, whether DEFA agree to it. And then, of course, as with a lot of biodiversity net gain strategies, plans, you know, it is possible that they're in outline form and have to be agreed and so on, but, you know, what we'd like to see is how it's going to get delivered. We're looking at a
plan. Dr. Carr, on behalf of the applicant, I think just to be clear, there's currently no statutory requirement for biodiversity net gain, yeah, and we've made a voluntary commitment to do this. We hope to do that within the site, so we hope to do it on site, so in the field or on the beach, whichever of those sites will be the option where we hope to deliver the 10% biodiversity net gain. The biodiversity condition assessment submitted at deadline 6 G67 D6008 says that the scenario where habitats are reinstated to their baseline condition within 2 years, and within Groudle Bay Field we have quantified the number of habitat units that so we have identified all the habitat units. There's 7.97 habitat units, which require 0.8 additional habitat units to achieve the 10%, and this is in the plan. This has been the habitat condition report. Groudle Bay Beach contains 3.52 habitat units, requiring 0.35 additional habitat units. Groudle River generates 1.27 watercourse units, which will require 0.13 additional watercourse units to achieve 10% biodiversity net gain. So we have gone out, established what all of the units are, established their condition, quantified them, and then set out within that report how many units are required to deliver biodiversity net gain. It's our understanding we will deliver them on site. That will be subject to ongoing consultation with DEFA and other stakeholders, and subject to us getting the appropriate land agreement in place with the landowners.
So maybe we're not so far apart in our understanding of where you are. I think what we're looking for is an outline biodiversity benefit management plan. Something is that there in what you've just referred to? Is it nearly there? Maybe that's the gap here.
Dr. Keogh, on behalf of the applicant, that's not nearly there, no. So we've only done the habitat condition assessment. We've made the commitment for the 10% biodiversity net gain within our biodiversity strategy. So we will need to come back then, once we've made a decision pre-construction on the appropriate site, we'll come back, redo the habitat condition assessment, re-quantify the units, identify those that need delivered for the biodiversity net gain. So we could start to develop a more detailed plan, but we'll be very outlined at this stage, and if you feel that that's something that needs done, then we're happy to do that. We thought that the requirement on the initial stage of the condition assessment and the commitment was sufficient because it's secured within the biodiversity strategy. So, but if you feel there's another document that would help bridge that gap, then we're happy to provide that.
Yes, thank you. I think that would be helpful. Would just like to invite DEFA for any views on that.
Ken Milne, representing DEFA. We welcome the commitment to the 10% biodiversity net gain target. We've not had a chance to fully review the deadline 6 submission, so we've still reserved the right to comment on that. I think at this stage it's understanding what that plan would look like and what BNG opportunities might be present. We are still unclear on that with no clarity at this stage.
And so the most efficient way to getting there is for yourself, DEFRA, to discuss that with the applicant so that by deadline 7, if an outline, and I think we are asking for an outline biodiversity benefit management plan, if when that does come through at deadline 7, there has been a measure of discussion and, DEFRA, you're cited on it and have had input to the contents, and if there's anybody else that should be cited, I don't necessarily know who that might be. Would that be okay, applicant? So would that be okay?
Yeah, Ken Milne, representing DEFRA. That would be okay. Obviously, we'll comment for deadline 7 on the deadline 6 submission, but if you want something for deadline 7, we obviously need it in a timely manner.
Yeah, I'm just mindful that deadline 7 is a little way away, and I think we can make progress in that time.
Sure. Dr. Kerr, on behalf of the applicant, I think the best thing for us to do is to go away and get a draft plan, give it to DEFRA as soon as possible, and hope to have it reviewed, commented on, substantially updated, submitted for deadline 7, where we have agreement, and I think we can get there pretty quick, to be honest.
Yeah, thank you. That's great.
Just going back to the requirement as well, Dr. Carolyn and Mr. Mill, I would like you to look at it, because at the moment the requirement seems to suggest that there will be a plan which will be submitted and approved. I'm not necessarily seeing a trigger here or what this plan triggers, or a trigger for the plan, and I'm not seeing a timing for it. So details of how to, action plan must be implemented as approved, like when. And so I think you need to go away and see whether you're happy with that requirement, whether it has the teeth it needs. And you would probably, if you are submitting something potentially as an outline, then this probably needs to be thought about. So in a way, some of the actions identified in the biodiversity plan, what is the precedent here when it comes to biodiversity net gain, which is being delivered on the English side? When do some of those actions, it is my understanding that some of those actions will get implemented before the damage is done to, which starts at pre-construction stage. So, you might want to think about what that trigger is for the plan to be implemented, submitted, approved, implemented.
Toby Yates on behalf of the applicant. Yeah, it was intentional that there was no trigger on the face of the requirement, given that it was a voluntary enhancement commitment as opposed to a response to mitigate works that are being carried out, although as part of the applicant's review or preparation of an outline plan in advance of deadline 7, we can consider if that remains appropriate. And DCO precedent is usually by reference to an outline landscape and enhancement management plan, which the applicant has provided as an annex to the Code of Construction Practice, and we can consider how that links together and provide a coherent update for deadline 7.
Just bear in mind that the optionality with some of this enhancement that you're calling voluntary will then have an impact on what weight the examining body can attach to it, because obviously we will not have any certainty to it. Okay.
Okay, I've just got one tiny little question to finish up with, and then on to the next item on the agenda. So when we were on the accompanied site inspection yesterday, we were outside a holiday, Glen Cottages, Groudle Glen Cottages, and we were discussing that the vehicles would be going along the side of the car park and down to the proposed compound. And where that left me wondering was, that's a private car park. How are you going to do that? And is there an agreement? What's the land rights issues? It just doesn't seem that you can just randomly drive a HGV across somebody's car park.
Dr. Kerr, on behalf of the applicant, I spoke with our landowner manager yesterday after that, and that is part of the landowner deal for that compound area. So we got information, there's 5 official car parks there. So those 5 car parks are for the 5 properties. And then there's overspill car parking as well. And we will take the overspill car park, and the 5 car parks will remain. So that is part of our option agreement for that land.
Amy Sterling, on behalf of the applicant, just to confirm, we don't have an option agreement currently in place, but matters are progressing. We understand the landowner has instructed solicitors in relation to preparing the documentation, but I think it's important to note for the record the option isn't yet in place.
So if there's an options agreement for something that's outside of the order limit and an option agreement or an options agreement being pursued, progressed for things that are within the order limits, why would you not have the access route within the order limits, as is normally the case for a lot of DCO applications?
Amy Sterling, on behalf of the applicant, we're limited to extending the order limits to 150 metres on shore by MEMA.
You are, but there are other parts of the order limits which are beyond the 250 limits, which are within the order limits.
Amy Sterling, on behalf of the applicant, can you identify which areas you consider are beyond 250
I'm asking you the
metres?
question. Are there?
No, the legal regime only allows the order limits to extend to 150 metres landward of mean high waters. I'm not aware that there are any part of the order limits which extends beyond that.
Fine.
Okay. And also there's documentation to indicate that there's no HGVs accessing the beach. Can we just clarify that? Because there seems to be a slight discrepancy between what's in the documentation and what isn't. Well, what's in the document? So the question is, shall I rephrase that? Is there any intention for HGVs to access Growler Bay Beach through that car park that we were just referring to?
Kachi Amazi for the applicant. Yes, that's correct. And appropriately sized HGVs for the beach works as indicated within the CTMP.
So something to look at after today's session. Would you please revisit the Outline Code of Construction Practice Annex A, Table 7, and just check that that is correlating to what you've just said, please? Thank you. Okay, that's all from me. I'm just wondering. Miss Newton, please come forward. And what we were discussing there is, please make your representation, and then we're going to have a 5-minute break just to allow people to stretch their legs and have a drink of water and do whatever. But it will be really short so that we do get finished in good time.
Thank you. I just wanted to mention the fact of pedestrian access. The constraints map here may be a bit unclear because of all the colours merging, but the public footpath referred to from the Ballymenic Road, it's shown quite clearly down the edge of the Groudle field site, down to the river and over the footbridge. This, of course, is the Radna Follion. It's the island's coastal footpath. It actually continues up the access road, Groudle Access Road. So it's used by a lot of pedestrians doing that. The Groudle Access Road has no pavement, and people just take a risk with cars travelling to the site. Other pedestrians, there's a lot of people, I can't put a number on it, but visitors to the holiday cottages don't necessarily bring cars. It may look like the site is not well occupied, but a lot of visitors just come on foot, and they use the MER. So again, they are using this access road up to the MER halt on King Edward Bay opposite. The visitors to the campsite, as far as I can make out, also have to take their refuse up to bins, which is on a store just opposite the reception area, and there was a load of bins for glass and recycling, etc. So this road has a lot of other uses, and it's not just construction vehicles and cars you're going to have to cope with. It is pedestrians I would suggest that that is a good reason for not using this Groudle Bay beach site at all for any heavy work site. The gradient of it is also, and with a right hand, not a right hand, but a dog leg back on itself, it's very, very unsuitable for any large vehicle doing it. And I don't know whether the current refuse vehicle collection even goes down that far. It possibly just goes to Scott Close, being the residential properties, and these bins beside the reception area. So I think it should be made clear that this is a public footpath and part of the coastal network as well.
Yes, thank you, Ms Newton, and for those observations, which I also remember seeing some of that when I was on the site. I just wonder whether we might ask the DOI to pick that up in their conversations with the applicant in relation to the few outstanding areas, because it's quite, just to make sure that that point isn't lost. I know the applicant, you've got your hand up, but I think there is still an action there which I would like DOI to pick up with the applicant. Thank you, Ms Newton. Applicant?
Kachi Maisie for the applicant. So we've got measures in the CTMP to manage that interaction between HGVs and pedestrians. So you've got escort vehicles and driver inductions, but that equally in our conversations and engagement with the DOI, we have agreed appropriately sized vehicles, and we've done the traffic and transport assessments along those routes to be able to get the right vehicles down that road. But everything's managed within the OCCP for the pedestrians with respect to the public access management plan. And also vehicle interactions with pedestrians within the CTMP.
I don't doubt that. Nonetheless, sometimes these anecdotal observations, which aren't necessarily scientifically backed, are quite helpful. And I think my question is for DOI and yourselves to just think about that perhaps in a slightly more sensitive way as to, is there something that we're missing here that may need to be added or considered. So I just would like some further thinking on that and some reassurance as to how that has been approached. So if I could just leave that as an action for you all to do.
Robert Garden on behalf of the Department of Infrastructure. We will look at that. We had done as you say, the SWEPT analysis, and there is public rights of way I'm getting feedback. Sorry, thank you. And there are provisions in Appendix D to the CTMP that do deal with that, the provision of a banksman, for example, and signage. But we will, as you say, revisit that and just confirm to you that we are comfortable with what is there.
Okay, then let's thank you, Ms Newton. Let's just have a sort of a 5-minute break just to stretch legs and whatnot.
If everyone could come back at 5:40. We'll conclude the hearing by 6.
Good afternoon, ladies and gentlemen. If we can resume our seats, and welcome back to this final session of today's issue-specific hearing. Now, I am going to work backwards on this agenda, firstly to confirm and reassure everyone that agenda item 9, economic effects, employment and skills, will not proceed tonight, because that's a reasonably chunky item, and Ms Sahai and I have discussed moving it into SIH 10. So that's how that will be handled, and deep apologies to anybody who has attended possibly all day with a view that they want to speak solely on that item, but that is how that will have to be handled. So we can then return to agenda item 8, economic effects and tourism. And I'm going to just particularly reference check there Chapter 14 of the Environmental Statement, APP-059, and then 2 Deadline 6 documents, D6-035, Socioeconomics, Tourism and Recreation, and D6057, the Outline Employment and Skills Plan, which are worth having in the back of our minds and referring to as we pass through this item. Now, as precursor remarks, we have been mindful of essentially somewhat of a disparity between the broad view of the applicant and government instrumentalities that there are only limited tourism effects. And there I'm referring particularly to the latest position in terms of the Statement of Common Ground between the applicant and the Department for Enterprise, D4-101, which I think could probably safely be characterised as identifying much green, combined, as in agreed, and limited effect, but that also there are still a number of white line items that are marked up as subject to agreement. Before I go into the substantive items, can I check, do we have somebody online for Department for Enterprise, DFE, still? No, we do not. That's a shame, because I did actually have a certain number of questions for them, but that probably also shortens this evening, but does not indicate that those matters will go away. I'll just have to deal with them in writing. So there's a disparity to a degree between the position represented there and individual observations that have been made by a number of principal stakeholders and speakers at public meetings, and also, I guess, the underlying justifications for some of the site inspection requests that we had received. And in that respect, again, before going into the substantive items, so that everybody is clear about what we have been doing, you will note that our unaccompanied site inspections progress is recorded in document EV-020. And in that, you will have seen that we've recorded, amongst other things, responses to site inspection requests to a number of tourism locations. That we have visited the entire alignment of the Manx Electric Railway and the Snaefell Mountain Railway, Machald Head, and we have also most recently visited Axonfell at night, not in the most ideal of circumstances, I hasten to add, because at this time of year, sadly, the sun disappears from the sky very closely before midnight and then starts to re-emerge in the sky not that shortly after midnight. And so we have done our best there, but nevertheless we have tried to honour the requests that have been made to us about visiting sites of relevance to tourism. I am, however, just briefly then going to name check a group of other sites that were subject to accompanied site inspection requests where we indicated that we wouldn't visit on an accompanied basis, principally because the sites were all publicly accessible and we felt that we could visit them on an unaccompanied basis. So we have now additionally been to amongst others, Clayhead, Port Cornay, Cashtel and Ard, Balafell Cairn, the Quaker Memorial Site and Charlie's View, and Port Mooir, Mocheld Head, again making a longer progress along the public footpath there, and the Albert Tower. So we've tried essentially now to absorb the positions placed in front of us in site inspection requests and principal stakeholders' submissions in terms of understanding the context of sites and footpaths and landscapes that constitute the area in broadly the northeast coast of the Isle of Man, where the tourism utilisation, the tourism offer, is probably of most relevance. And I thought it was worth just making those opening remarks. So given the absence of DFE then, what I am going first to do is just to check in on a couple of residual tourism-related questions bearing on Groudle Bay. So that's agenda item A. Then I'm going to open up more broadly in relation to tourism effects, in relation to visitation, enjoyment of views and activities from tourism locations, and then the specific locations identified in items 1 and 2 under item B here, and I will bring in requests from the floor to speak to those items. Then, finally, I have a couple of questions in relation to cruise ships, boating and yachting and effects outside the Isle of Man that hopefully I'll be able to deal with quite swiftly. So that's a tour through the territory that we'll cover. So briefly then on agenda item 8A, one just residual question in relation to Groudle Bay, but emerging from Ms. Jennifer Smith's question earlier on this afternoon. I would like to ask the applicant, and apologies if I have overlooked this in the document set, but do we have a set of occupancy figures for the cottages at Groudle Bay that are still available as a tourism facility, showing their either average annual occupation or utilisation for tourism? Even better if there were some monthly figures showing a breakdown.
Catchy Maisie, for the applicant, no, we don't.
You don't. Is there any possible source for any such figures? I mean, is there an operator who could provide those?
We have a land manager who's been in discussion with the manager at the cottages. So conversations are still ongoing. Certainly we can, speak to him to see if those numbers are possible to be provided. Okay.
And then similarly, are there any figures, and again, forgive me if they are present, but I've just failed to find them, on the same basis for tourism utilisation of the railway as an attraction, the Groudle Bay Railway?
At the moment, no.
Yeah.
We have posed our question to the DFE, certainly at the same time that we were speaking to the DOI in providing information on usage at the beach, but we don't have those numbers.
Yeah, well, that was going to be my third question, the usage at the beach question. But what I'm going to suggest is that unless any of the government departments who are here have any insight into this, recognising that it's probably DFE territory and not DOI or DEFA territory, can I just check, does anybody have any figures to hand? Mr. Garden?
Robert Garden on behalf of Department of Infrastructure. I'm afraid not. I think it's a DFE matter, sir.
Yep. Mr. Milne, I guess your answer is the same. Well, had they been here, I would have asked the DFE, and we'll have to place that in writing, but I think we will aim to set that out as an action emerging from this hearing, asking for the good offices of the DFE and indeed any further insights that the applicant can gain as a consequence of outreach through your land agent. Is everybody clear about that on those three items? So,
Sorry, Mr. Smith, can you just clarify what 3 items
We've got the tourism utilisation of the Groudle cottages, hopefully broken down monthly, but an annual figure would do. Then we've got the same request in relation to the tourism railway, the steam railway, and then finally, if there are any figures available at all around beach utilisation. Now then, I do see a hand before I close this item. So, apologies, can you just come forward and use the microphone? And it's Patricia... Sorry?
No, it's Michelle Cook.
Oh, Michelle Cook, apologies.
No
Apologies.
worries, no problem. So that's great to look at the impact on revenues of the places that you stated and the industry you stated, but also perhaps what about hotels and restaurants, that side of it, the hospitality side is going to be hit because, oh my goodness, thank you.
Ms. Cook, you anticipate me. I haven't got there yet.
Okay, perfect. I'll step back. Thank you.
Thank you very much. Now we've moved out of the immediate setting of the landfall, I'm then moving on to agenda item B, effects on onshore tourism in the Isle of Man. Actually, no, I'm not, because I'm going to stay in the effects on onshore tourism in the Isle of Man arising from onshore development, and recognising that there are potential effects in the broader setting of a landfall. Is there any other information, is there any other data available to us about hotel or restaurant or equivalent tourism facility utilisation in, I guess, in the broader setting of Groudle?
Catchy Maisie for the applicant. In relation to Groudle, no.
No. Well, again, maybe if we can kind of pop that on as a sort of fourth action for follow-up with DFE, because again, if there are standardised visitor attraction statistics that are kept, it may well be that there's a restaurant or a hotel in the locality that provides us with some standardised figures that could be used. Mr. Strafford.
Dr. Carroll, on behalf of the applicant, just very...
Apologies, yes.
Just
Dr.
very briefly.
Carolan, just wait on Mr. Strafford.
Just in relation to other sensitive receptors from a tourism and recreation perspective in the proximity of Groudle and the landfall walks, there is none, so we have already done that review. There's Groudle Glen cottages, there's the cafe and the railway. They're the only receptors. There's no other ones within close proximity that could be impacted. All the other ones are classified within sort of the Isle of Man in terms of national restaurants, hotels and things like that outside of the impact zone.
So that's your view. The answer is no, because there is genuinely nothing.
Yeah. So any action to go and follow up on that just would confirm that point.
Okay. Mr. Strafford.
Thank you, Ian Strafford, Laxey resident. Just a statement, really, which hopefully you'll find helpful, and you probably cover it, I'm sure. Two things. First is, if you think about things like the Radnor Folion, which go through Groudle, then the impact on Groudle isn't just the infrastructure in Groudle, such as cottages and so on. But the second point, which I think is more important, I recently read, for example, for the Manx Electric Railway, that they had calculated that for every £1 spent on the Manx Electric Railway, £3 was spent in the economy. So I think it's important when we think about the impact on tourism, is as you go through each one of these things, it's not just a hotel or a cottage or whatever, but there's a huge multiplier effect within the local economy, or within the totality of the Manx economy, because as you obviously will have seen from the visits that you've been on, people get on the Manx Electric Railway at point A, to maybe go and spend in the cafes, the ice cream bars, or whatever it is. So it's really important that as we go through this, we capture that multiplier effect, because otherwise you may well end up significantly underestimating the impact on the Manx economy of tourism impacts. That was just a statement, really. I'm sure you're going to cover it, but thank you.
Yeah, no, that's a clearly set out view, and essentially what we need to be able to get to at the end of this examination is a sense that we have a clear understanding of possible multiplier effects that might emerge in relation to that. And I think it's really a useful reminder, actually, Mr. Strafford, so thank you, that before we leave this impact on Groudle, this item A, that we do note the Radnafoilen, and we do note the proximity of the MER, and therefore, unless the applicant, and I will take it again that this is a DFE matter, so I'm not going to put the question to government instrumentalities at the bench here, but we will put it to them in writing. It would be useful just to be pointed to either where in the existing document set passage of tourism on foot through that area utilising the Radnafoilen has been taken into account, given that that is a national asset. And then similarly, and it may be possible that this is something that DOI could access an existing data source on, but that is the question about, to the extent that it's known from ticketing data, when people are using the MER, how many of them get off or get back on at Groudle?
Robert Garden on behalf of the Department of Infrastructure. So we do have data for the usage across the year for the MER and also for the steam railway. I don't have to hand the data for when people get off using ticketing information, but I think that is something we can endeavour to get hold of. But certainly we've got data from 2025 for total usage of those two railways.
Thank you very much. I think that could be quite a useful starting point. Does the applicant need to respond to that? I mean, if that data becomes available, then it gives us a context where we can actually start to evaluate both the foot traffic and the rail traffic that is passage through using national assets, but where Groudle is a possible destination. Thank you very much. Well, on that basis, I am going, I believe,
Toby Yates on behalf of the applicant. Can I just jump in there just to respond to the points?
Yes, by all means.
To the buzzer. Just initially, if I can respond to a couple of points that Mr. Strafford raised, it'd be really helpful if we could see an evidential document setting out that multiplier effect that Mr. Strafford referred to in examination, so the applicant consider that properly.
I think, with respect, he's probably making a very generalised economic point. Mr. Strafford, do you have a specific document that you have referred to that hasn't been put in?
It was in the advertising literature for the MER, so I guess DOI will have that because they look after the Manx Electric Railway, but it was a specific leaflet where MER said for every roughly £1 that was spent on tickets, they estimated about, I think the multiplier was 3. I might be wrong, but it was in that order.
Yeah.
But it's not one of my documents. So.
No. Again, given that that's an MER document, is it possible to rest that on the broadening shoulders of the DOI?
Yeah, Robert Garden on behalf of Department of Infrastructure. Yes, sir, we'll look to obtain that and provide that to the applicant.
Thank you very much.
Dr. Kearn, on behalf of the applicant, just in relation to the coastal path, we've sought to get information on its usage. And we haven't been able to get any numbers. We know it's well used. The numbers vary from anecdotal sources. And just to confirm, we're not seeking to close, divert, or temporarily or permanently disrupt access to that path. It will remain open at all times.
And that is a clear submission, but I guess it is still in the mind of the examining authority that there will be a change in the visitor experience. And so we need to take that into account, and it may well be that it's your following submission, once we've seen material from DOI and DFE, that you don't change your assessment. But nevertheless, to the degree that we can harden this up, I think we should. I think it's our duty to do so. Now, I have seen... Sorry, Ms. Sterling.
Very, very briefly, Amy Sterling on behalf of the applicant. I just wanted to be clear for everyone in the room that when we're talking about Groudle Bay, what we're talking about is temporary construction works to construct a transition joint bay, and there's no above ground infrastructure on a permanent basis, because there have been some mentions today of a substation, for example, on a couple of occasions at this site. So I just, for everyone's benefit, want to ensure we're clear what we're talking about. Of course, the permanent infrastructure offshore and impacts on tourism is a separate matter, which I'm sure you're going to come to.
And we are clear, and in that respect, the principal focus has to be on the construction period, and it has to relate to a potential up to 2-year construction effect.
Just on that point, Ms. Smith, I think you have raised that point a couple of times. So I hope that clarification was helpful, that while there might be some above ground structure that's visible during construction, during operation, there won't be any above ground structure, and especially any reference to a substation. At the moment, there is no substation proposed because there isn't an island connection proposed. Or rather secured through this draft MIC. Okay, thank you.
No, I believe, see a hand almost directly behind the camera tripod. Now, who was that? Ah, would you like to come forward, please? I know it is. We're just going to go on. And apologies, my chair is telling me off for taking too much time, but I'm afraid I do read the room and form the view that this agenda item is one that certain people did wish to speak to, so we will continue and deal with it.
Patricia Newton. It was just to clarify that when the DOI mentioned steam railway, they mean the government steam railway Douglas to Port Erin for figures.
I'm very clear on that. Yeah.
It's not,
no, I know the Groudle one is an independent
They also have
trust.
figures, dare I say it, for the Douglas Horse Tramway, and all the figures last year increased quite dramatically, especially the horse tramway. So there is great usage of the tram of all forms to get bring visitors to the island, and the experience that they get and the visual effects, the scenery from as it goes past Groudle in particular and then north, Alaxi Bay and Ramsey Bay from the MER.
And you anticipate where I'm going, actually, on the next item, and I think in the interest of time we should cut to the chase, so I am going to close out.
It was really just clarification of the DOI statement.
Yeah, indeed, but I am going to close out item 8A, but move on to B, where recognising, again, that we don't have DFE with us, but we do have DOI, bundling up items small 1 and small 2 together. The point has already been put in front of us by some of the speakers, and we've already made some actions that will draw out in relation to effects arising to views from specific receptors or activities arising from offshore development of possible effects on MER, Snaefell Mountain Railway, and other historic heritage or landscape receptors, beaches, wildlife watching locations, walking and dark skies tourism locations. Now, you've heard the thrust of the conversation that we've already had with a very specific reference to Groudle. Are there any additional observations that anybody needs to place in front of us on specific effects in relation to those items, matters that we might take up with either DFE or DOI in relation to the railway operation dimension that we haven't already covered? We're alive to the MER. Is there any need to look at possible effects on other assets. Who? Ms. Smith, Patricia Smith, would you like to come forward?
Less about offering different things to look at. I would just like to suggest there's a lady called Deborah Heather. She's the Chief Executive Officer of Visit Isle of Man, who manages all our tourism, Chair of the Tourism Society, Tourism Alliance Advisory Board member. I've heard her speak a couple of times. She's vastly knowledgeable about our tourism industry, completely holistically. And they've done much research into what draws people to the Isle of Man, what experiences people are looking for, both here and in alternate places. And I'm almost positive that she would be most happy to share that with whoever needs to approach her and engage, and as opposed to looking for information from lots of different little bits and pieces. Anyway.
Now, she's obviously, I would guess, a government agency or department employee, and so the degree to which she was available to do that is going to be within the gift of government. Quick observations from
Robert Garden on behalf of the Department of Infrastructure. I believe she is with an agency of DFE, so one and the same effectively. So I think it's again something to take up with DFE, and we are making requests at our side to ensure that there are responses to these questions, and appreciate there'll be written questions that you will have as well.
I think that's the best way of dealing with it, to be frank, that, we will have, given we haven't got DFE here today, we'll have to write. So thank you, Mr. Garden, that's a very productive suggestion.
Robert Garden again on behalf of Department of Infrastructure. I am instructed that DFE will be here on Friday, but not here today.
Okay, but we don't want to run this agenda again on Friday.
Katia Maisie on behalf of the applicant. I just wanted to point out that we are in a conversation and engaging with Visit Isle of Man. So we have spoken to Ms. Heather, who is the CEO of Visit Isle of Man. So yeah, we are collaborating with them and exploring options in relation to the tourism package for the Isle of Man.
Okay, I mean, in terms of making that concrete, do you anticipate that there will be a joint position statement, a statement of common ground, a document that records a different position from the one that we currently, or the ones that we currently have in examination? And if so, is that likely to be available at deadline 7?
Toby, it's on behalf of the applicant. No, there's not an intention to submit that.
Okay, so in other words...
Just to point out, it's not required, but Visit Isle of Man is part of DFE, and we have pulled in a position point on the SOCG to cover that conversations with Ms. Heather and the group.
Okay, and I've had regard to that, and that was where I started with. There's a lot of stuff still not fully finalised.
Amy Sterling on behalf of the applicant. I think it is also relevant to note that in section 5 of the Outline Employment and Skills Plan, Visit Isle of Man is specifically listed as an important stakeholder relationship who will be involved in the final production of that plan.
Noted. Okay, conscious again of time, I wanted to ask if there were any other specific matters that anybody here wanted to put in front of us in relation to particular individual receptor locations. And I did see Ms. Fadra.
I wouldn't be speaking to any particular location. I can't give you any figures. I'm a registered tour guide on the Isle of Man. I'll be working with the Walking Festival when the people come over at the end of September. It may be possible to get you some numbers. I know the numbers are up this year, and we'll be walking all over the island, including the Red Napoleon. I just know that King Charles said it, didn't he, yesterday, how important the landscape is, the marvellous landscapes that surround, and the sea that surrounds us. And he mentioned the beautiful beaches and environment justly designated as a UNESCO biosphere. What value can anybody in this room put on that, and our landscape and our biosphere, and what the people come for to the Isle of Man? I don't think we have. I don't think there is a value out there. I mean, we'll know the DOE, enterprise. They will have an idea of visitor numbers. I know they're trying to increase them to 500,000 by 2032 or something. The people that come here because the island is different, and they come here for our identity and our culture, to visit our cultural places. That's what I do with the cruise ship. When the cruise ships come in, we're getting smaller cruise ships. We're getting people who are discerning where they want to travel within the world, not just the British Isles, and they're coming here to see the difference that we have, that we are different. We take them to, bird watching walks I do with them, heritage railways, all the things you've mentioned. I can't think what else I need to say, but if you need any more information on that, I can get it for you.
Well, again, in the circumstances, we're clearly going to have to review what we put out in writing. So I think that the best thing for us to do is to continue to think in that space and make sure that we address any remaining questions in writing. Unless anybody has anything further that they wish to put. Yeah, now, Madam, would you mind coming forward? And what I'm just going to do whilst you're getting ready is just to avoid a sort of continuous round robin of question on question. Can I ask if there's anybody else who would like to speak on this item, just to raise their hand, and I will come to you in turn. So I have one more hand. Okay. Madam, your name?
My name's Alice Strafford. I'm resident of Laxey. First of all, I'd like to apologise. I was unable to attend the public meeting on Monday. I really wanted to. I had points I wanted to raise. I was travelling on that day, and whilst I tried to change my travel arrangements, because this is a very high priority for me, I couldn't. The issue I'm raising here, I think, is relevant to tourism. A couple of people have mentioned it already, and it's regarding our UNESCO biosphere status. We use our UNESCO biosphere status as a selling point to attract tourism. I'm getting very frustrated with this process. You'll think I'm like a stuck record. I've raised this issue at least once in writing and twice in written statements. Other people have raised very similar issues. I do not believe that this proposal is in line with the principles of our unique biosphere status. I've read the applicant's document, D3-009.
Yeah, I am at this point just going to, with respect, pull you up, because the matter has been in front of us before, and we are conscious of the relationship between the Ireland government and the UK government and UNESCO in relation to biosphere status. We're, rest assured, we're taking those matters carefully into account. What I do not believe we are in a position to do is to impel UNESCO themselves to participate in this process or to place questions to them on those matters. I mean, the Isle of Man government rests as the responsible body for the delivery of that designation, and to the extent that there's any overarching foreign affairs capability dimension of that, then there is a kind of small element of responsibility that rests with UK government. But rest assured, if we need further information on UNESCO biosphere, then the pathway to that, unless UNESCO itself volunteers to come forward, would be through Isle of Man government, because that's the normal way in which those questions would be asked.
Or is there an independent body that can rule on both sides? Because we just have a standoff at the moment that the applicant states that their application is in line with the biosphere status. It's one of our most asked questions. There is a huge amount of concern with the Manx population who are very proud of our biosphere status.
Yeah,
and King Charles mentioned that, but I first raised this on the 3rd of March.
I do know. And I am, at this point...
We're not getting any further with it, so it's getting very frustrating.
Going to say to you that we have got evidence essentially on both sides. We've got an action on the applicant to speak to us about, or write to us about, their engagement with the UNESCO biosphere position. If we've got any further outstanding questions, we can raise them with government, Isle of Man government, and short of, what we cannot do is compel an international entity to come to this examination. So we are where we are.
I think one of my, with all due respect, one of my submissions says, please don't ask the applicant the same question again, because they've clearly outlined their position, how they feel that their application is in line, and then you've just said to me, you've put the question to the applicant.
Yeah, well, what we will sometimes have to do in these circumstances is we have to take a matter away that is not agreed between parties and adjudicate. And if that's where it rests, sadly, that's what we'll have to do.
Well, and I think that's what we're looking for, is having an independent
that's
adjudication.
What, yeah, and in that sense, we are appointed to do that job.
Okay.
Thank you.
So this is part of the frustration with the process.
Okay, I am at this juncture going to note.
What's going on.
I am, Ms. Strafford. I am going to note that, I'm conscious that you're passionate about this, but I'm equally conscious of the fact that it is now 20 minutes after the time when we did say that this hearing would end, and I still have some questions that I need to ask. So can I ask that we rest this matter and move on?
Yep.
Thank you, Ms. Strafford.
Thank you.
On that basis, then, I am going to move on very briefly to item C, which is effects on offshore marine tourism. And here I'm simply going to note that utilisation of Isle of Man waters by the cruise ship industry, it is something that Isle of Man government appears to be wishing to promote, which again was a question that I had wished to put to DFE. APP-059 ES Chapter 14, paragraph 5.4.1.2 identifies that there hasn't been available quantification of cruise ship landings, cruise ship visitor numbers, that those numbers were not obtained or provided by Isle of Man government during the preparation of the environmental statement. Now, first question is, have I missed something? Is there a later document that sources economic landing numbers, economic benefits, spend, or indeed possibly multiplier effect?
Robert Garden on behalf of the Department of Infrastructure. I don't think we can get you the spend figures, and that will be something for DFE, but certainly from the Harbours Department within the Isle of Man government, we should be able to obtain the landing information in respect of cruise ships.
Sorry, would you mind repeating that? I just missed that.
No, sorry, sir. So in respect of spend, that's not something the Department of Infrastructure has, but in respect of landing numbers for cruise ships, that is something we should be able to obtain from the Harbours Department of the DOI, because they should hold that information and keep the records, so we can secure that information. The spend will be a matter for DFE.
Thank you very much. And then finally, in this item, although I do note that there is a question from a lady in the back who I will ask to come forward. No, sadly it wasn't. And again, if I could just have a show of hands, I don't wish to prolong this, but I do need to see hands from people who do wish to speak on this item. I have one more, and Madam, I will bring you in. Sorry, your name, Madam?
Hi, my name is Alison Mackenzie. I live within the Mackald region in Portofellon, just above the beach. We have a small family activity holiday centre which we have provides outdoor activities for a range of groups, mainly school children, mix of on-island and off-island, and also some...
Does this pertain to cruise ships?
No, but I did put my hand up before and asked to speak at the end of that last section, and you didn't come back to me.
Apologies if I missed you.
Can I carry on?
Just briefly proceed. Madam, I will just ask, is yours on cruise ships?
Okay, I'll let the lady go. It's fine.
Thank you.
Hi, Vanessa Christian, 48 11 Peel. I spoke at the public meeting the other night. Sorry, can you press the button? Oh, sorry. What do I do? No, it isn't. Follow towards it and speak. Okay. Hi, is that better? Yeah. Hi, I'm Vanessa Christian, 48 from Peel. I spoke the other night at the public meeting. It's not really even a question, it's just a quick comment. It's probably one for government and everyone who's considering biosphere status, the effect of cruise ships on tourism, and that generally cruise ships don't go with biosphere status. So the upshot, if we do discourage cruise ships from coming, is that it should improve our biosphere status, and all the people worried about dolphins and mammals and cruise ships generally don't have a good impact on them. So it was just a quick comment on that, and I can send you links if required. Thank you.
Thank you very much. Now, madam, I did leave you out. Yes.
Okay, and again, my name is Alison Mackenzie. I'm a resident of Mackle, Portofellon. We have an activity centre in the north of the island. We have a lot of people that come to our centre each year. A conservative average would be about 5,000 people per year. So over our 44 years of existence, we have had contact with a lot of people who come and want to have a tourism experience in the Isle of Man. Not all of them are from across, some of them are locals, but one of the things that pulls them to come to us, apart from our fantastic activities and activity instructors, is the setting and the views and the sense of freedom, which if you come from inner Manchester or you come from inner Liverpool, has got a high value. It might not be something you can put a monetary thing onto, but it's something that fills the soul. And I think we maybe shouldn't lose that in this discussion. So that was my first point. And my second point was, there was a lady who was sat behind me earlier on today. She's unfortunately had to go, but she has a B&B, and you were asking about Visit Isle of Man and information that comes from them. All I would request is that some form of survey goes out to all of the kind of stakeholders who have got B&Bs or who have got, on a small scale, it might not be big to you, but it's maybe quite a big part of their economic existence. So if you could find some way of not just going through Visit Isle of Man, who don't deal with everybody, but deal with, put a survey out to all the B&B owners and people that it has an effect on. In all honesty, being totally truthful, I don't know how much impact it will actually have on our business, because obviously primarily they come for the activities. But there are people it will have a huge effect on.
Okay, noted. That's not a direct commitment that this examining body is going to make now, but what we are, as you can see, thinking about is looking at the relationship between the information we already have before us and the possible sources of proportionate additional information that might help us to form evaluations on the planning merits points that arise here. But thank you very much for your comments. Okay. My final item under C then related to boating, yachting, leisure, fishing and related activities. Now we do not have, as I understand it, the Royal Yachting Association here, either online or in person, but at deadline 5057 there was a brief written submission made about engagement with RWA and or yacht clubs that broadly took the view that they did not consider that sufficient attention had been paid to them as a user group of the marine environment or information that they might provide. Now, that was a very brief submission. Can I just ask the applicant for an update on any conversations that they may have subsequently had with the RYA?
Ryan McManus for the applicant. So we responded to the RYA submission in our deadline 6 submission. Just going back a couple of years, we did actually consult with the RYA through the navigation risk assessment process. So they were invited to and did attend. The chair of the northwest region of the RYA attended the hazard workshop in December 2024. They made a couple of representations at that time about what the NRA should cover, including that it should assess internal transits as well as increased recreational traffic that's potentially displaced outside, and the NRA did include both of those things. They confirmed at the time that as long as the standard minimum blade tip clearance of 22 metres above mean high water springs was adhered to, then the RYA were content at that time.
Okay. Right, so we'll probably need to address a final written question to them. Okay, now moving then on, there are other matters in relation to tourism effects outside the Isle of Man and any indeed other tourism effects. Now, given the passage of time, I am proposing to bring them into writing. But does anybody else have any other matters that they want to raise on these matters before we close out this agenda item? Thank you very much.
Thank you everyone for your participation. The time now is 6:31 and the specific issue hearing 8 is now closed.